And before we begin, let me read a few announcements. In the interest of safety, I would ask you to note the location of and access to the exits of this hearing room. The two doors through which you entered the room are the emergency exits and are marked with exit signs. In an emergency, the two doors behind the legislators can also be used. In the event of an emergency, please walk quickly to the nearest exit. After exiting the room, go to your right and proceed to main stairs or follow the exit signs to one of the fire stairs. Please quickly exit the building and follow any instructions from the Capitol Police. Do not delay and do not return unless and until you are advised it is safe to do so. In the event of a lockdown announcement, please remain in the hearing room, stay away from the exit doors, and seek concealment behind desks and chairs until all clear announcement is heard. Thanks so much. And with that, we will start our public hearing this morning. And let me just begin by asking my co-chair, Representative Sanchez, got it right this time, if you have any comments to begin.
I do.
Great. And Acker, Representative Acker, I can't believe I'm doing this each time I screw up the names. Representative Acker, our ranking member, do you have any comment?
Yes, it's just an announcement. Representative Yacarino was out because of a family issue, so he will not be here joining us today.
Okay, thank you for that. And Senator Sampson, any comments? Great, then we will begin the hearing. Let me just pause one moment, but I will invite our first speaker, Patrick Hewlin, to come to the table here. But I do want to pause for a minute because we have to, we have to make sure we have our Zoom link activated. And are we recording? Great. Give me 1 minute to get. Okay, I think we are all set now. So thank you. Please state your name and for the record and begin your testimony. Good morning.
Good morning, everybody. Good morning, honorable members of the committee, chairs, ranking members. It's nice to see everyone in person this year. I'm very happy to be back here in person. My name is Patrick Hewlin. I work in the governor's office. I'm the governor's deputy policy director. I'm here to testify in support of House Bill 6594, an act concerning non-compete agreements on behalf of the governor. And I am here on a panel with two national experts on the topic. There's more details in my written testimony as to my logic, but I wanted to give the committee an opportunity to talk to some of the two foremost experts on the topic. So they should be in the Zoom room. I'm here with, yep, they're here. Okay, so I will pass it off to Ms. Terry Gerstein to introduce herself.
Hi, I'm Terry Gerstein. Thank you for the opportunity to testify today about House Bill 6594. I'm the director of the State and Local Enforcement Project at the Harvard Center for Labor and a Just Economy and a senior fellow at the Economic Policy Institute. Previously, I worked for over 17 years enforcing labor laws in New York State, including at the Labor Department and the State Attorney General's office. We handled several cases involving non-competes. Other AG's offices have done so as well, involving sandwich makers, baristas, check cashing workers, health workers, and fledgling journalists. Non-competes lock people into jobs. They prevent them from getting a better job, better pay, better work-life balance. They also can lock people into jobs where they're experiencing violations like wage theft or discrimination. They're virtually, except for very high-level workers, they're virtually never negotiated. They're presented as a requirement of the job. Studies show that they suppress wages and that when states curb them, wages increase. This bill, House Bill 6594, is good, but I think it should go further. As you likely know, the Federal Trade Commission last month proposed a prohibition on virtually all non-competes with a really extensive record of evidence. which I think really changes the conversation from what non-competes should be allowed to why they should be allowed at all. In light of that, the pay threshold in this bill is really too low. I think it should be higher, more along the lines of those in Washington, D.C., which is $150,000 for a categorical ban. You know, anyone earning less than that, would there be a categorical ban on non-competes? Or Washington State, it's $116,000. And so the bill in Connecticut should be
Very
more.
sorry. Can I just cut you off and hand it off to Professor Arno Richmond to introduce yourself? I apologize.
Thank you.
Good morning.
We can hear
We
you.
can hear you.
Perfect. Thank you very much. My name is Rachel Arno Richmond. I am the Rosenthal Chair in Labor and Employment Law. I have taught and researched on non-competes and employment issues for over 20 years. Prior to entering teaching, I was a management side attorney representing companies in labor and employment matters. I support this bill. Non-competes are restraints of trade. They pose three distinct sets of harms to three different constituencies. Obviously, as Ms. Gerstein said, they constrain workers, keeping them locked in their jobs, unable to pursue better opportunities, and importantly, unable to negotiate better terms of employment with the restraining employer. They also pose harm to businesses by preventing companies from seeking the labor and making hires that best suit their needs. And importantly, they constrain and damage the public, both by depriving individuals of the useful labor and services of the restrained individual, but also increasingly, as we have come to understand through about a decade of empirical research, by limiting the flow of information and services and talent that is necessary to ensure strong economic growth and sustainable development. For this reason, no state permits non-competes to be enforced as written. In all states, including Connecticut and common law, prior to this bill, they are permitted only where narrowly tailored to protect a legitimate interest. The problem is the law is extremely vague on what constitutes a limited interest, and employers are extremely powerful in their ability to impose these non-competes as a matter of course. The consequence is that we know now from economic data and empirical research that 1 in 4 workers has signed a non-compete in their life, and approximately 20% of workers are currently constrained. It is extremely hard for workers to challenge these non-competes. It is extremely easy for employers to threaten their use. For this reason, we have a holdup pattern. What this bill does is effectively address key aspects of this problem while preserving employers' limited ability to use non-competes. I share Ms. Gerstein's contention that in this era, given the action at Congress and also the action of several other state legislatures, the best course of action is to ban non-competes. Short of that, this bill takes a narrow approach, a lesser approach to permit some uses of non-competes, and also preserves businesses' ability to use other instruments to protect their trade secrets and other proprietary information. I'll close my remarks now and allow for additional time if anyone would like to ask me a question. I'd be happy to stay on.
Thank you. Let me just ask a couple of quick questions and then I'll go to a ranking member. I'm interested in Ms. Gerstein's testimony because you spoke quickly, but I understand that you had in your previous capacity in New York State with the Department of Labor, I think you said, that you had some experience seeing these cases and complaints. And could you describe the workers and the impact on them that you encountered when, because I think we think of a non-compete as somebody who has proprietary information at a high level that, is intellectual property of the company, and, they're not, a person signs that they won't take that information to a competitor to disadvantage their employer. So that's the way I always thought of it. And if you could share with us what's really happening in the real world out there.
Yeah, so when I was in the New York State Attorney General's office as the Labor Bureau Chief, we handled several cases involving just sometimes very low wage, sometimes middle wage, but just very ordinary rank and file workers who did not know the secret recipe, who did not have confidential information. And what seems to be happening is that employers sort of use non-competes broad brush in an entire workforce, as opposed to really making any individualized consideration about whether it's needed for this particular worker. So we had a case, the case that got a lot of coverage in the media, that our office and the Illinois AG's office both got involved in, involving Jimmy John sandwich makers. We had a case involving a phlebotomist who traveled throughout the state drawing blood for life insurance exams. And she got another job. She worked for a national company. She was offered another job that would have required much less travel and allowed a much better work-life balance. And the company told her she couldn't take it and that she had a non-compete. So we see there where it really prevented her from being able to move on. We did end up being able to get the company to agree to stop using non-competes. There's a worker that I spoke to after leaving the job in Connecticut who had been in her job for a number of years, and a single mom with a few kids, middle income, who suddenly her employer sprang a non-compete and said, you have to sign this. And even though, she learned that it probably was not enforceable, felt compelled to sign it because of a pre-existing health condition. She later learned that a male colleague who started the same time as she did, had lesser credentials, and was doing the exact same job, was making thousands of dollars more than she was. And so that sort of gives an example. If you have a non-compete and you learn of a violation, it's really hard then, makes it harder to address that, because you can't just, leave, and it makes it harder to complain about a violation. Most people, our cases involved a lot of lower wage workers, but again, even people at much higher wage levels, people live, almost everybody lives paycheck to paycheck, and people really can't afford to wait out a non-compete. There's also evidence that non-competes disproportionately affect women, because they may be less likely to move to another geographic area to get another job. And so, they really do affect a wide range of workers. And one other really important point that I think is a good aspect of this bill is that it's really important to prohibit them and have a penalty, rather than just making them void, as some states have done. Research shows that employers still use non-compete contracts, non-compete clauses, even when they're unenforceable, and workers do not know their rights, and they assume that the terms in an employment contract are valid, and that has a chilling effect. And so there's not really any, if you don't prohibit them with a penalty, there's not really any deterrence. There's no disincentive for an employer to just overreach and give it a try and get the benefit of workers being chilled from seeking other jobs.
Thank you. And one other quick question, I know you testified already that in one state, the threshold is 150,000. Can you tell us again what that state was?
So in Washington, I've submitted written testimony that has links to this. In Washington, D.C., the salary threshold is 150,000. In Washington State, I think it's somehow indexed, but right now it's currently 116,000. I think they both also have a higher threshold for independent contractors having a non-compete. But for employees, that is the number. The number in the bill right now is 3 times the state minimum wage, which if you annualize it after the upcoming increase this summer, works out to a little over $90,000. So, ways of dealing with this could be either using an annual salary that is higher, like that in Washington State or in Washington, D.C., or using a higher multiplier of the state minimum wage, like 5 times or 4 times the state minimum wage.
Thank you very much. Senator Sampson.
Thank you very much, Madam Chairman. Appreciate you folks being with us today. I just have a few questions after listening to the testimony. I guess the first one, I would say my reaction to the discussion on this bill and some of the other bills that we've had in recent years on non-compete agreements, and it seems like the majority's moving to eliminate them as much as possible. We had the non-compete agreements invalidated in the case of home care workers, for example, and then we have this bill in front of us today. I guess, from my seat, I look at a non-compete agreement as part of a private contract between adult citizens. And as far as I'm concerned, I mean, in America, we've always respected private contracts. In fact, we are representatives of our constituents. So they're our bosses. And if they want to enter into a private agreement, I don't understand why it would be up to us to say no to that. And I just wondering if any of you folks have a reaction to that statement through you, Madam Chairman.
Thank you.
So I have two initial responses, and I'm sure that my fellow panelist does as well. One initial response is that I think it is a misnomer in this instance to refer to them as agreements. You'll note that the FTC in its proposal refers to them as clauses. They're generally presented to workers often after they've already accepted a job or into their experience of working in a job, and they're presented as take it or leave it. This is a condition of employment. And if you want to have this job, you have to sign this. They're almost never negotiated. Workers don't get extra consideration for signing them. And so I think that in that context, it's really hard to call them a genuine agreement on both sides. Also, there's a lot of evidence out there, and the Economic Policy Institute, where I'm a senior fellow, has an entire project focused on this, doing extensive research on this about the unequal bargaining power between workers and employers. And workers are dependent on their jobs for their livelihood. And there is just greatly disparate bargaining power between workers and employers. So that's the first part of my answer, is that I think it's inaccurate to call these really agreements. They're more clauses that are imposed on workers, similar to forced arbitration, that if you want to work, you have to sign this. My second response is that we do have, all of our workplace laws do impose on the ability of employers and workers to contract. That same argument could be used to oppose the minimum wage law, or, and that was used to oppose the original labor standards laws in Lochner and the Supreme Court at the beginning of the last century. But fortunately, in light of the understanding of the disparate bargaining power between workers and employers, our entire regime of laws has understood that we want to set standards below which, yes, we do have a free market, and yes, it is a capitalist system, but we do have some basic floors, some standards that have to be followed. Otherwise, it's a race to the bottom.
Thank you.
Well, I'm sorry.
May I add to that?
Certainly.
I completely agree with everything Ms. Gerstein said, and I just want to add a third reason to her too, which is that we not only, as a policy matter, set aside freedom of contract concerns in many respects when dealing with the workplace. We also live in a system of antitrust law where contracts between businesses are precluded where they have an anti-competitive effect. If two companies were to agree to respect geographic boundaries in where they marketed their services, we would instinctively react to that as freedom of contract adherents, as capitalists, as Americans, with the reaction that that is unlawful. And it is only because of historical accident that non-competes were not put in the bucket with other antitrust type of restraints that are clearly unenforceable under our law. So what I think is important here, it's an excellent question, but this is an important opportunity to reset the baseline understanding of what is and is not lawful. This is not a freedom of contract issue, it is a freedom of competition issue.
Thank you. Senator Sampson.
Thank you, Madam Chairman. I appreciate those answers. You guys gave me so much to discuss here. I don't even know where to begin. I might start by questioning the notion about whether we should be choosing between freedom of competition and freedom of contract. I like all freedom. I don't want to specify which type of freedom we should be restricting. The note that it was noted that sometimes these are offered to employees after they're already hired on a take it or leave it basis. But a take it or leave it basis is, in fact, still a private contract. And employees have the same right. I mean, an employee can walk into their employment and employer and say, I can only work on Tuesdays now. Can I still keep my job? And the employer's got a take it or leave it decision to make. That's part of doing business as free citizens and adults in a free market country, which I would argue we don't have a free market country any longer. And it's partly because of policies like the one that's before us today. And these are, in fact, agreements. And the title of the bill acknowledges that they're agreements that are signed by parties. And I completely understand the motivation behind this bill. I totally get it that if we were talking about very low income, entry level jobs, maybe non-competes are being used in some sort of nefarious way, and maybe we can get at that at somehow. But when you're talking about people that make, as I was mentioned, around $90,000 and up, generally speaking, they're intelligent people and they know when they are being hired for a job what the terms of that employment are. And my concern about this is not only taking away the freedom of my bosses, because that's what we're doing. We're telling the people that we work for that we don't respect them enough for them to get into their own decision making. But you're also going to stifle economic opportunity. And I'll just give you an example, and I'm looking for a reaction on this too. My personal experience is that I was an insurance producer when I was in my 20s. I used to be an independent insurance agent, and I'd travel around and knock on doors. My very first day on the job, I went to the mall. I went to every store in the mall and talked to everybody who worked there and tried to get them to let me quote their auto and homeowners insurance. But I signed a non-compete agreement with my employer. And it was under the understanding that, I'm going to be given an opportunity here to learn this industry and go out and make money and establish myself and build a base of customers. But in exchange for that, my boss owns the customers. And I was happy with that. And I signed my agreement with him willingly. And I certainly didn't make anywhere near the numbers that we're talking about when I first started in that industry. I don't know that I ever reached even 90 grand back then. But the point is, I would not have been able to have that job, and that industry would not have even existed in those terms. And that opportunity would not have occurred if it were not for two willing citizens who knew full well what they were doing, being able to engage in that activity. So for some experts to come along and advise the government to use the force of government to tell people they can't enter into a voluntary private contract, to me, is an absurdity in America. And all of the arguments withstanding about protections and so forth, no one needs to be protected from themselves in the case of exercising their freedom. This is before us, and the reason why it's a big issue for me and why I'm speaking up on it is because of what's happened in recent years in the homemaker provider, Medicaid provider area. I'm trying to think of the exact term, but home health aides, that kind of thing, where we have effectively done tremendous damage to an entire industry by suggesting that they can't use non-competes. That business model works like this. They hire people, many of them without any experience whatsoever, and train them and place them with a family who pays the agency, who then pays the employee for their services. And the business does a tremendous amount of good because they are creating a mechanism in the marketplace to provide a service that wouldn't otherwise exist, training people, giving recourse to consumers. They're creating a lot of things, and they're also creating a job opportunity for someone. When you say that those people cannot have non-compete agreements with their employees, what you're doing is you're opening up the door for those employees to make contracts with the families they're placed with right after they were placed, and essentially cutting out the people that provided for that connection in the first place. And what happens then is that connection disappears and the people that are in that industry disappear, and then the whole thing disappears. And I think that's the danger here, is that if we pass a law like this, eliminating even more opportunities for freedom between private citizens to engage in this activity, we will end up with more. So I would like a reaction to the home health aid arena, where people are probably making somewhere in the maybe $40,000 to $70,000 a year ranges would be a approximate guess of mine. But they're getting a job opportunity, they're getting training, and they're getting access to something that they wouldn't otherwise have. And I think it's a benefit to our society and the people that are served by those workers. Through you, Madam President.
Thank you, Senator Sampson. I do want to remind all of our committee members, we have 87 people signed up today, and I appreciate questions and probing, but I think we should probably reserve our argument to the committee meeting. So I would encourage folks to do that, all of us, to restrain ourselves. I know we have a lot on our mind and strong opinions on these matters. I'm not sure that our witnesses are familiar with the Connecticut state law on homemaker and companions. And the prohibition does exist on non-competes. However, they are allowed to ask employees to sign non-solicitation agreements, I believe. And so that is something that is a significant, it significantly restricts the ability of a person hired by the agency to bring their clients with them if they were to move to a different agency, or to, as some have suggested, work independently for that client. So, but I don't know if our experts are familiar with Connecticut state law in this area, or if Patrick Hewlin, if Mr. Hewlin, you want to respond.
Sure, I'll just respond quickly, and you know, the panelists can offer any input if they wish, but basically I think this bill takes an I think the important approach of kind of carving out non-solicitation agreements and making clear that businesses can protect the key interest there, right, which you mentioned, Senator Sampson, and thank you for those comments, that businesses can protect their customer base, but they can't. They can do that through the direct action of protecting the customer base, right? It isn't about preventing the worker from moving jobs, which you know, as Professor Anna Richmond said, is kind of an antitrust matter that, you know, even under a pretty kind of aggressive capitalist framework, my understanding is that most folks think, and you can certainly feel free to disagree with me, Senator, that there's a role for antitrust enforcement and preventing enforcement of certain contracts between private parties, which I think is the right analogy here. You may disagree, that's fine. You know, that's we can certainly keep talking about this topic.
Thank you very much.
May I respond as well, or is there no time?
You certainly may respond since you were asked.
Thank you. So just a couple of points in response to the senator's arguments and concerns. First, I just need to call out the concept of freedom of contract and freedom of competition as sort of being a universal goal for freedom in all varieties and all flavors. Unfortunately, that's just not the reality. We have 15 years of economic data that show that this is a situation where freedom of contract left to its own devices will create a race to the bottom that impedes competition. So policy is required, and it is appropriate for policymakers to make those kinds of choices when the data shows what it shows, and when those tensions and values, when those priorities and values are in tension with one another. Second, I wanted to just reiterate the point about the nature of the underlying interest and the various ways that employers can address their concerns and protect their business model besides what is clearly an over-inclusive, I dare say draconian method of dealing with the problem. There is robust protection available for loss of trade secret and misappropriation of trade secret, both at the state and federal level. In fact, we've increased penalties at the federal level and have a much more aggressive model thanks to the Defense of Trade Secrets Act in recent years. On the customer interest, yes, non-solicitation agreements are available, no business agreements are available, a variety of instruments are available, including, I believe, if I'm not mistaken, certain training repayment clauses are permitted by this bill. It is a very light hand. And what I wanted to add to the array of options that employers have for protecting their interests is providing beneficial, competitive terms of employment to keep their workers happy in their jobs. That is sort of that ability that I alluded to before, the ability of workers to negotiate for better terms is completely eliminated. That freedom that we value, the ability of the worker to do the types of sort of bootstrapping and aggressive self-promotion that the senator described, are completely made impossible by these restraints once they're in place. And then the last thing I'll just add, and this somewhat reiterates what I said at first, is that the model that the senator describes, that employees and employers are sort of free negotiators in this picture. Ms. Gerstein sort of explained why that is not the reality. What I wanted to just add to that is, it is that sort of economic image, that sort of belief, or that model, which is a fair way to describe it, is what enabled non-compete law to develop the way it has, and has resulted in the permissible use under existing law, and explains the deviation from antitrust law that has permitted this exception. But what we now know is that that is not the model of how it works. And economists, the defenders of the freedom of contract principle, those that support the economic freedom that the senator described, have documented that that is not the reality of how this evolves, that this is not a knowing trade-off, and that every indicator that we might be concerned about, such as industry growth, resource, company entry, particularly this idea of new businesses and the ability to sort of, throw in and pursue that American dream and create a new entity. Those values are harmed by non-competes, and we now have the data to show that that is the case.
Thank you. I will allow Senator Sampson to make one brief comment, but I do want to encourage everyone. I would love to have an opportunity to put the three of you in a room, the four of you in a room, and we could spend all day, but we have, as I mentioned, 87. Well, now we're down to 84 members of the public that have asked to speak today, and I want to make sure we get to them. So if you could be brief in your closing comments.
Madam Chairman, I appreciate the opportunity, and I will be brief. But let me just point out that these bills are important, and the purpose of this public hearing is for us to get as much information as possible and have a dialogue with the people that are opposing and supporting this legislation, so that we can understand all of the facts. I didn't put this agenda together. I didn't create this number of bills on this agenda and generate the number of people coming to testify either. So I please don't hold me responsible for the fact that there's 80 people waiting. That's not my fault. I do want to respect them, and I will, refrain from engaging in more questions, although I have dozens more questions for these particular witnesses. I'll just close by saying that I do disagree. And I think that a lot of the rhetoric that we heard in the testimony is more political than the people on the dais here. Using words like draconian and disparate bargaining power, et cetera. That's all fluff. The fact of the matter is that it's a very progressive and socialist view to suggest that the government should interfere in private agreements among citizens. That's what's draconian, not the voluntary agreement between willing participants. Thank you, Madam Chairman.
Thank you. Next, I will recognize Representative Hughes.
Thank you, Madam Chair. Just two quick comments or questions to especially Director Gerstein. You mentioned something about that these are not enforceable except in narrow circumstances. Is it your view that this adds to the confusion then in terms of the landscape? What's enforceable, what's not? And also, I wanted to flag that you said that the threshold is too low and that this is too narrow. Is it your view then that a simple ban on non-competes would bring it to a more bring it to the federal level, hopefully, but that's going to be prospective in the future and simpler for both employers and employees to implement?
Thank you for that question. So in terms of banning virtually all non-competes, that is what the FTC proposal would do. But that proposal is at this point still a proposal. They're accepting comments through May 20th. Then there's going to be a whole, process, and then presumably there will be a lawsuit challenging it and some kind of judicial review. So in terms of that being the, that is what the FTC is proposing. Your question about confusion, I think, is a very, very good one. And in all of my years enforcing minimum wage and other workplace laws, employers, I heard that a lot, and I really take that to heart. That I think for both employers and for workers, it's good to have clear lines and straightforward rules that make it very easy for people to understand what are the rules of the road. Certainly, straightforward prohibition on non-competes, except in very limited circumstances, such as in relation to the sale of a business, by a partner selling a business. I think that would be the most clear, readily comprehensible by the public, readily comprehensible by employers and workers, and most easily administrable. In terms of the question of the salary thresholds, again, I think that a clear threshold that is at a relatively high dollar amount is something that just makes it very easy for people to understand. And for employers to understand, I make more than this, I make less than this. And in terms of, I'll also share one interesting piece of research that is forthcoming, which has been discussed in the New Yorker magazine. Professor Evan Starr of the University of Maryland, who's really the foremost expert on these as an economist, he did a study of the state of Washington, and this is again reported in the New Yorker, looking to see there was at that point the initial dollar threshold was, I think, $100,000, but it's been increased since then. It's been indexed, and he did a study to see once it came into effect, did employers whose workers were sort of near that threshold, like $98,000 or $99,000, did they pay them a little more to be able to impose a non-compete on them and not be subject to the ban? And from what the New Yorker magazine reports, he found that employers didn't pay more, suggesting that it really did not have value to them, that it was just sort of being included in, broad boilerplate employment agreements, just sort of thrown in, but not related to any particular assessment of whether there's any real legitimate business interest for restraining this worker's future employment.
Thank you. Representative Hughes?
I'm good.
Thank
Thanks.
you. Any other questions? Yes, Representative Acker.
Thank you, Madam Chair, and thank you for that testimony. This is the bill that I've been trying to read and understand for quite a while since not being on the Labor Committee. This is when I could have, we could have a meeting just on this one bill, as far as I'm concerned, just to digest this. I have two situations that took place. I had a barber that had a non-compete clause, a barber, and they went to leave, as mentioned, for a different venue, and found out that they had to be a certain miles away and so on and so forth. And I thought that to be very odd that this person was handcuffed in a way from the barber in another location. And so this has been an interesting discussion on this. Do you think that a barber, I'm okay, this shop is going to offer me more, I'm going to open up my own shop, whatever it may be. I get the solicitation of customers piece, and I think that should stay intact. Another situation took place where a doctor, a specific doctor for a patient, left to go to another facility, and the facility had to be 10 miles away. And I thought that that was not the best for the patient, because now the patient had to drive much further away to see their doctor. And I thought it was not the best for our healthcare system that, you know, we're imposing such an issue. So again, I think this is hopefully going to listen to some more dialogue, not really looking to get more answers, because I think the answers are longer than the questions at some point here. So, but I do truly appreciate the panel that's bringing this to us. And I'll have to take some of the sidebar and work on this a little bit after this dialogue. But thank you, Madam Chair, for the opportunity.
Thank you. And I assume that if any of our committee members would like to have another opportunity to speak directly with either of the expert witnesses or Mr. Hewlin, I'm sure that they can make that possible. So thank you very much for your testimony today and being with us today. And I think we're finished with you this morning. Thank you.
Thank you, everyone.
Thank you.
I do not see Senator Looney in the room. Am I correct? Or is he going to? Excuse me? Okay, we can come back to Senator Looney. Next up, we have Kate Farrar. Is Kate available? Okay, next we have Gary Turco. Okay, yeah, I am looking online and I assume if there's someone online that you will admit them. Next we have Robin Porter, Representative Porter. I should have said representative for all these folks, and Representative Rachel Kahana. Yes, I see you're there. Thank you. Please speak. Good morning, and please unmute yourself. Great, and you can proceed.
Good morning, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, Senator Cabrera, and Representative Wilson, and members of the Labor and Public Employees Committee. My name is Rachel Kahana. I represent the 149th District of Connecticut, and I appear before you to speak in support of Senate Bill 937, an act providing workers' compensation benefits for certain cancers in firefighters. In the line of duty, firefighters are routinely exposed to smoke, heat, and toxic substances. As a result, firefighters are far more likely to contract cardiovascular disease, lung disease, and cancer than other workers. In 2022, the World Health Organization's International Agency for Research on Cancer declared firefighting as a cancer-causing profession. For decades, the IARC has classified firefighter occupational exposures as Group 2B, meaning the exposures were possibly carcinogenic. The new classification, Group 1, carcinogenic to humans, now puts firefighting on a par with tobacco and benzene. Firefighters have long been exposed to PFAS substances known as forever chemicals because of how long they take to break down. These have been used in firefighting gear and firefighting foam used in emergencies. Although PFAS are now banned from firefighting equipment in Connecticut, their impact may take decades to manifest in firefighters' health. Cancer, heart disease, lung disease, and infectious disease are among the leading causes of death and disability for firefighters. And numerous studies have found that these illnesses are occupational hazards of the job. As of 2022, federal firefighters will for the first time automatically qualify for compensation benefits when they are diagnosed with certain types of cancer. But the law only applies to firefighters who work for federal agencies and respond to emergencies on public lands or military installations. Furthermore, 48 other states offer presumptive care coverage for firefighters. Connecticut already offers presumptive care coverage for firefighters for illness or death caused by hypertension or heart disease. It is time to expand this coverage to cancer. Adopting presumptive coverage for firefighters for the occupational risk of cancer will remove the heavy burden of proving causation that often deprives our first responders of critical care and allows us to take care of those who put their lives on the line to save ours. Thank you for your time.
Thank you, Representative. Any questions? Thank you for your testimony. At this time, I'd like to bring up Representative Farrar and Turco. Floor is yours.
We're glad to be here in person. I'm Representative Kate Farrar, proudly represent the 20th District in West Hartford and Newington, and I'm joined by.
I'm Representative Gary Turco, representing the 27th District of Newington and New Britain.
And we're here today on behalf of ourselves and Representative Robin Porter in support of a bill that we co-introduced, which is House Bill 6273, which is an act concerning disclosure of salary ranges on public and internal job postings. And we're here today because although Connecticut has taken steps for efforts to close the wage gap for women across our state, we still know that Connecticut's women working full-time, year-round, typically only make 83 cents on the dollar to men. And this gender gap continues to be most severe for Black women, 57 cents to the dollar, Latinas at 48 cents to the dollar, and Native women, 55 cents to the dollar compared to the white men of our state. And sadly, plus the research really demonstrates that even as students are graduating college, are women who are in the same majors, same occupations as men working full-time end up making 7% less than their male counterparts. So the gap that we're talking about is really an everyday gap for women in our state, and it does impact how they support themselves and their families. So there's approximately $9,000 less in their pocketbooks per year to spend on their most significant basic needs, be it childcare, be it healthcare, be it rent, be it student loan payments. And the wage gap as it exists today is a true economic barrier for the economic security of our women and their families, but also detrimental to our economy. This is why we're here today, because in 2021, we did pass a law, became Public Act 21-30, which did take some steps towards greater pay transparency in Connecticut, but we can continue to do better by our workers and better by our employers. And several states, including Colorado, California, and Washington, have passed laws that have salary ranges to be provided on all job postings, which is what our proposal does. I'm going to pass this to Representative Turco to kind of explain why this bill in particular really strengthens, again, our laws for workers and employers.
Thank you, Representative Farrar, and hello, committee members. It's wonderful to see you today in person. As Representative Farrar said, in 2021, this legislature did pass legislation towards more pay transparency. Now, other states have exceeded that, and it's shown to make even more improvements with closing that pay inequity. This bill would strengthen our current law by increasing transparency and helping level the playing field between the employer and the employee. And what it would do is require that any job posting include in that posting the salary range. And again, it's a range, because I've read the testimony from some of the opposition who say this bill would take away an employer's ability to negotiate. We're still allowing a range. This bill, being a concept bill, doesn't say what the parameters of that range should be. I think that's something the committee should discuss. You can't have $100,000 range that defeats the intent of the bill in improving transparency and closing inequities. But it still allows that employer some of that negotiation. So we're saying, because right now the law that we passed, it says that an employee has to request to the employer when they're applying for a job what the pay would be. And then they would receive from that employer the range. And this is saying right away in that job posting, you have the range. Because any requirement from a job seeker, and we all know this, we've sought jobs, to have to request that information reinforces the imbalance of power between the employer or the employee. I know when I was applying for jobs, when I was a lot younger, and out there first in a very competitive job market, I was told, don't ever mention money. Don't ask what that job is going to pay, because that will just make the employer think that that's all you care about. It will put you at a disadvantage. Women and people of color already face bias when interviewing and negotiating compensation package. And when women and people in color are paid less due to discriminatory practices that sometimes happen by employers, it makes it even harder for them to make up the gap over time. So House Bill 6273 before you will help reduce the problem and that unexplained wage gap. This bill helps all job seekers with increased transparency, but it not only helps employees, it helps employers. This is a pro-business bill as well.
Why would an employer want to go through days, weeks, months, sometimes of an interview process, then to accept this employee, offer them the job, and then find out that the pay is way different than what the employee was expecting? I have heard stories from constituents where they've gone through this process and then they were offered a job, let's say it was $60,000, when they thought that this job paid $80,000 based on what they've seen elsewhere in the market. And now they wasted months and the employer, is not going to offer them the position any longer. So this bill will help prevent that. And there's been a Glassdoor study that showed that 2 out of 3 employees prefer to work for a company that provides that transparency and discloses it up front. So I wanted to get to any questions that you have. But in closing, this bill really helps employees and employers. It provides the needed transparency that will help reduce inequities and, just helps make long-term economic stability and security for our workforce here in Connecticut. We thank the committee so much for allowing us to speak today and really appreciate your consideration. So Connecticut can join those other steps, the other states in taking those additional steps that have been done since the last legislation we've passed. Thank you.
Thank you all.
Thank you. Any questions? Representative Hughes.
Thank you, Mr. Chair. A couple of questions. One is it your contention that especially state workforce is having real difficulty filling open positions, including especially in the healthcare female-dominated professions?
Are you saying that is absolutely the reality, right, Representative Hughes? And I think as Representative Turco was sharing, we know in hearing from employer after employer who need to fill jobs right now, women especially are more likely to pursue and stay in jobs where they know they're being paid fairly and where they know that this job is contributing to their long-term economic security. So through the pandemic, we lost more women in the workforce than ever before, and we're still kind of trying to gain that ground back. So this is definitely a recruitment strategy when you think about keeping workers in our workforce as well.
And two other questions, if I may, Mr. Chair. One is that I've heard from Gen Z that they will not even apply if there is no wage transparency up front, right off the bat. They're not going to waste their time going through 10 or 20 web pages of process. Are you hearing that as well?
Yeah, I mean, we've heard from people of all ages and all backgrounds. I mean, part of the intent of this bill is really to help reduce inequities for women and people from color. But really, like I mentioned, this affects everyone who, is looking to help fill the open positions that our workforce desperately needs, and our businesses and our nonprofits and our state desperately needs. And hearing from people exactly that, Representative Hughes, that they don't want to go through this long and lengthy competitive process at times to find out there's a big discrepancy in what they were hoping to get paid with the job. They're more likely to apply if there is at least a competitive range up front.
Thank you. And finally, I just wanted to point out that this the gap, the wage gender gap and racial economic gap has been normalized in behind this lack of transparency. And it's not necessarily the intent of entire industries to discriminate, but this practice and this policy that we are trying to change, we're basically trying to modernize what has been normalized as gender and racial and economic discrimination. And it's not intentional, but that's what we're attempting to do here with mandating wage transparency. Would you agree?
Well, and I would just add that in the public sector, we've had wage transparency for quite a long time, and we've fully accepted that. And we can look at all the research that shows that there's a smaller wage gap for folks who work in the public sector. So this is taking that practice and making sure, as you said, that it's really a part of our daily lives for all workers.
Thank you. Representative Ackert.
Thank you, Mr. Chair, and thank you both for being here and advocating for something so strongly that you're working for here. And I struggle with how this is actually going to help close the wage gap. I get posting job notices. As a matter of fact, I just went on the state website because if you notice, finally the state is posting jobs. Hey, come work for the state. And I looked at a business that I'm very, very familiar with. It's in the contracting firm. Then they posted their wage. Nobody's going to apply for that because the private sector is paying much more. But because the benefit package with the state is far better than that of the private sector. So sometimes just posting the wage means very little when what the real jobs are looking for. What's the benefit package? Because even though the wage is, range is a certain value, but if they're offering a lot better in a benefit package that would attract more people, and that's one of the concerns. If you're just posting, and not that I want to mandate anything, to be honest with you, but sometimes it is different than what benefits are going to come along with the job. I know if that person knew what the benefit package would be like, oh, wait a minute, it is better than the private sector. So when I talked to a recruiter, headhunter in depth, and he commented about all of this. He said, there's some good aspects. He says, but there's some aspects that I'm concerning that and actually it was in some of the testimony that if a business does post their wages, that they may not attract anybody because the next business is posting more. And Gary, you brought up two things that I'll comment on, Representative Turco, to be wage percentage, right? So if we're talking about the individual that we're trying to help here, those that are getting paid less and closing that gap, I'm sure it's going to be more than a 10 to 13% wage gap from the individual. So we have to, as you mentioned, you focus on what that percentage gap may be in that. And so, but there was a lot of concern that this headhunter brought up because that's all he does for a living. He probably places 20 people a week. And he said there's some good aspects of this, but he could see some concerns that might not actually help that company or the person applying for the job. And then you mentioned about 2130, Representative Turco. So when you mentioned filling out tons of forms and spending a lot of time and doing this, actually, all you need is contact and find out what the wage actually is. That's one of the part of the good work that we did in Public Act 2130. So you're not wasting a ton of time filling out applications and going through a process, for hours and or days, because you can just find out what the actual wage that when we put that in the legislation. So I'll continue to listen to the dialogue on this and hear more about how. But my issue really comes down to, I would like to see the proof that this actually helps close the wage gap, or find something that actually does. That's really my concern, is that what actually is the target. We know what the target is, but how do we get to that? And is doing stuff like just mandating on a business actually going to work? I don't know. I'd rather see the proof in that. I don't think the numbers show it in a certain amount of time that those other states have that out there. I'd like to see it though. And if we can show that this is actually working with the efforts that we're doing, I'll support whatever we can get to actually make that happen. So again, thank you both for your advocacy and for being here.
And I just want to thanks Representative Ackert for those comments. And just a couple of things I just want to mention is nothing in this legislation or any previous legislation we've passed would prohibit that employer for also posting and being transparent about their benefits package. So if a particular employer was worried that they might be paying a little less than what the other industry competitors are paying right now, but they have better healthcare benefits, they're helping with student loan repayment and childcare, they should post that as well to equal out, because some people, those benefits are more important and worth more. And I would say also that just increased transparency, having more information for prospective individuals, I believe, and from the research and what we're going to hear from today, will help with reducing some of the disparities that exist. And it is intimidating for some people to make a call, even though legally they can do that now, and the employer has to tell them what the salary range for that job posting is. But it's intimidating for some people to call and ask that, so they either don't apply for that job or go through the lengthy process and then maybe be disappointed at the end. So we're trying to prevent those situations.
And thank you, Representative Ackert, for your thoughtfulness on this. As you kind of noted a bit in your questioning, if it was one thing that we could do to solve the wage gap, I hope we would have done it by now, right? It's not one thing, right? We know that it's a compounding effect of discrimination, of pay secrecy practices, of women being overrepresented in lower wage jobs than higher wage jobs. Often women who are mothers facing even greater penalties in the workforce, which is one of the reasons why in this state, our paid family medical leave program will have such an impact on reducing the wage gap. But in regards to the steps that we take, if there was one thing, as I said, I would hope we would have done it, but it really is all of these approaches that we could take. And I'd be happy to share a little information. Colorado, since the passage of their law, has started to do some research on the impact of their law in the salary transparency. So I'm happy to follow up and send that your way. And I would just say as well, anecdotally, I've certainly heard from many folks that I've worked with over the years in the nonprofit sector, even after passing the law that we did in 2021, having, real intimidation in the hiring process and being fundamentally concerned still about how it would be perceived in asking for the salary range early on in the interview process. And unfortunately, that is something that we've seen in all the research about why women don't negotiate their salaries, why often they haven't asked for more in the workplace. So this is just trying to kind of get us all on the same playing field when it comes to us not only seeking a new job, but also seeking a job even internal to our current company. So thank you again.
Representative Weir.
Thank you, Mr. Chair. Representatives, thank you for the presentation. I have a couple of questions and a statement. What is the size of the range that you're proposing from what to what? Any thought on that?
So this bill, the way it was drafted, does not specify what that range is. I think talking to Representative Farrar earlier today, we mentioned that we should really take a look at all of the other states that have passed this to see if they included any ranges we may use as a guideline. But I'd ask this committee, if you move forward with this legislation, which I hope you do, to listen to all the testimony today and consider including some sort of range. Because if there's no specification and the range is just too large, I used a hypothetical example of $100,000. Okay, that's really large. But if it was something like that, it kind of defeats the whole purpose of having to put a range, right? So there probably should be some sort of percentage in there to really get at the intent of the bill and having true transparency.
Thank you. And I have a follow-up question. So having been a business owner myself and also currently an employee, I'm all for transparency. And I also am concerned with any mandates because I know as a business owner, it behooves me to be transparent when we're advertising, putting those advertisements out there. So that's a philosophical difference, I guess we have, that that any business who, if you're Representative Hughes referenced Gen Zers not even considering applying to a job where the salary isn't posted or the range isn't posted, those are the businesses are losing out. So any business that wants to be competitive, I think would want to do that voluntarily versus a mandate. And then I'll leave it with a concern, and maybe you can let me know if this has been considered. So if I think of a business, former business owner, as I'm posting a job on LinkedIn or Indeed, and I leave that out. If I errantly leave that portion out, okay, with the best of intentions, what types of penalties as a business owner would I be looking at? My intent was to be transparent. We posted an ad and it didn't include the salary range. What type of penalties would I be facing?
Thank you, Representative, for your questions and your thoughtful remarks as a business owner and as a current employee. There's no reference in this draft concept about any type of repercussions to the employer. I would hope that we could look at some of our current statutory language that exists in the current Public Act, and also have a conversation that could be helpful with our Commission on Human Rights and Opportunities, who already plays a role often in any wage kind of discrimination concerns that employees might have. But right now, there's nothing in the language that specifies what any type of result would be of an employer not having that there. But I think it's a thoughtful question, and I think we should look again at our current statute and have a discussion with CHRO of what their suggestion might be. I don't know if you can.
Thank you, Representative. I don't think anybody has any more questions. Thank you both for your testimony.
Thank you all so much for the time. Oh, Representative Ackert's back.
No, Mr. Chair, if you could forward that research,
Yes.
I think the committee might, but I won't speak for the committee, but I know I would really appreciate that, and any language that you have from Colorado law would be fantastic. Thank you so much.
Yes, please forward on that information
We
to
will,
Cameron,
for
please.
all the
That'd be
committee
great, and then we'll get
members.
that out. Thank you both.
Thank you so much.
Thank you so much again.
Next up, we have Representative Tammy Nuccio.
Thank you, Mr. Chair. Thank you for the opportunity to testify today. I am here to testify in behalf of SB 197. So I would like to just thank the chairs, Senator Kushner and Representative Sanchez, and also the ranking members, Representative Acker and Sampson, for having this public hearing and raising this bill. Here to testify in support of SB 197, which would be allocating money to pay off the federal loan balance for the unemployment fund that we currently have. I'm supportive of this measure to help our businesses, which increases the opportunity that we have for employees and the opportunities to be self-sufficient and make money. Also supportive of us using the Connecticut Invest, drawing down the Connecticut Invest funds that we're using to pay for other initiatives, such as the possibility of extending school meals, which is a direct effect of COVID. And I would just suggest that this paying off of the unemployment fund is also in direct effect of COVID, and using these dollars to do such a thing, I think would be very beneficial to our business environment. I'd like to suggest either using the balance of the Connecticut Invest Fund or the Medicaid surplus money that has been kicking around. We know we've seen significant Medicaid surplus funds, again, getting back to COVID, because we're getting a higher reimbursement from the federal government in direct relation to COVID. So just using these dollars to offset the increases that we're going to see in the businesses for this unemployment insurance, I think would be a wise usage of the money, and it would follow in line with the terms that were set forth for us receiving these dollars from the federal government, which is COVID relief. So going to keep it short and sweet. I know Senator Kushner said you guys have about 80 something people on your list still. So that's my testimony.
Thank you, Representative. Any questions? Representative Acker.
Thank you, Representative, for taking the time. I did not see if you could forward your written testimony on, would be also helpful for us. Also, I didn't see it show up on the on this. I know you're working on legislation in another committee on this also. Has businesses reached out to you? I know that in the past that we've had a penalty, I don't want to call it a penalty, that business owners, when the fund got in trouble, that many businesses, all businesses in the state of Connecticut had to pay a stipend, sort of say, to recoup the money back into the fund. Is this something what you're seeing, how that we can help resolve this?
Absolutely. So I've actually had quite a few businesses in my district, which is Willington, Tolland, and now part of Vernon, have reached out to me. I have business meetings, like a business advisory meeting with local businesses, and this is a universal level of concern. In the past, when we've had this type of situation, it results in increased rates, unemployment insurance rates that the business providers have to pay, and that's not something that is passed down to employees or anything like that. It's a cost of doing business. So them having to pay higher taxes or rates for this prohibits the money that they have available to give raises or to grow their business or to hire new people. So this is definitely one of the top things that businesses have reached out to me on, how detrimental it's going to be when they have to pay these increased rates. And I just like to point out, before I was elected, I was the chairwoman of the Tolland Town Council, and I was on a lot of meetings during COVID with the Lamont administration. And there was a lot of talk around not punishing these businesses. for the layoffs that the government forced them into, right? So we had to close a lot of businesses because of COVID and the uncertainties. And there was a lot of talk around making sure that these businesses did not get dinged for being forced to close down. I feel like this is kind of a reversal on that. We are going to ding them, right? In the beginning, you know, there's been a lot of talk about this not being used as a way to increase their rates, but it is going to increase their rates because we have to pay the federal government back. So that's why I'm kind of linking this to the COVID funds and the Connecticut Invest funds that are there, or the Medicaid surplus, which is generated because of an increase in the reimbursement from the federal government in relation to COVID. So trying to keep these dollars kind of centralized and aid these businesses and follow through on our promise that we're not going to ding them for something that was outside of their control.
Thank you, Representative. Thank you for your advocacy for your businesses in your community and for the state of Connecticut. I do agree 100%. When COVID first hit and we talked about the unemployment, I myself and many other legislators approached the governor's office and say just that your experience is going to go to the max, which means you pay a much higher percentage into the unemployment fund. In a way, I'm glad you brought this up. We may be doing that inadvertently by then making sure that the businesses pay into it more, whether through a stipend or a one-time fee, that they're going to have to help fill that fund back up. So, and I know that at one time, we had borrowed so much, or got so much from the federal government that we were only paying the interest. That's all we could pay back, and we couldn't even pay the loan back. So, thank you for bringing that point across, and we'll listen to further dialogue on this. But thank you.
And I will submit written testimony. It's in the works.
Representative Weir.
Thank you, Mr. Chairperson. Thank you, Representative Nuccio, for bringing this topic to the forefront. I think it's incredibly responsible, a piece of legislation to take some of the burden off small businesses. I heard a couple of years ago from a constituent who runs a small business, has for over 30 years, who recounted, as Representative Ackert brought up, that our unemployment trust fund, we were basically barely able to make the minimum payment. So if you think of your credit card at 25% or ridiculous interest amounts, that's essentially what the state was doing with the unemployment trust fund. And so businesses bore the brunt of that. And he was saying to me that, geez, if I knew this was going on, maybe if businesses had the option to all get together and pay $10,000 today and cough up a check today instead of bleeding this out over years, that really hurt us. So I think this is great that you're bringing this up now, so we have the opportunity, and also the advocacy for many of these businesses that were shut down through no fault of their own. They were mandated to close through the actions of this government, and now small businesses bearing some of this responsibility. So thank you for looking into this, and look forward to seeing this continue.
Thank you. I think it's really important that we hear the voice of business on this. A lot of states have used their COVID money and such to replenish their unemployment balances. And I think one of the things that we're always working for here in the state is to make Connecticut more competitive, especially from a business perspective, from a business development, and from just kind of living and working in the state. And I think this is a fair representation. It's a fair ask to use the COVID money to do that, because this is going to be, even if it's a temporary blip, as you said, we were having a hard time paying the interest, and we've done a good job of paying some money down, but there's still I believe it's about $100 and something million that are left of these dollars. If we could pay this down, it would create a better business environment for our businesses. And the last thing we really want to do is be making business harder right now, especially in this time of recovery and with the potential of a recession on the horizon. We want to make business opportunities here in Connecticut easier, better, and more accessible. So I just really ask that everybody kind of ask some questions on this to other people, understand the impact, and think about the use of these dollars, whether it's from the Connecticut Invest Fund or the Medicaid surplus or any other ARPA dollars that are out there. And think of this as a way to increase and help the businesses, which in turn helps every one of our residents.
I don't see any other questions. Thank you, Representative Nuccio.
Thank you. Have a good day, everyone.
You too. Senator Looney. So next up, we have to make sure I'm on my correct list. Yep, thank you. So we have Representative Amy Moran-Bello. Floor is yours.
Thank you. Good morning. Chairs Kushner and Sanchez, Vice Chairs, Ranking Members, and Committee Members. I'm Amy Moran-Bello, representing Weathersfield's 28th District, and I am speaking today in support of HB 6273, an act concerning the disclosure of salary ranges and job postings. I proposed similar legislation this session in HB 5243. Much of my testimony was already said by Reps Farrar and Turco, so I will just summarize some of my prepared statement. But basically, I just want to mention the lack of salary range transparency and how it does hurt applicants, and it can disproportionately harm women and people of color who often fall victim of the discriminatory pay practices. And as far as all applicants are concerned, including the salary range in a job posting, assists candidates in determining if the pay will meet their expectations and whether they want to apply for a given job. This upfront transparency can also save time on the employer's end by having these potential employees applying that are interested in a job within a given salary, so that HR isn't reviewing applications and interviewing potential employers only to later find out that the salary isn't what they're looking for. But I do want to reiterate some of the concerns that others had mentioned, that companies may use a workaround and not follow the spirit of the law by listing large pay ranges. I read a Bloomberg article from January that showed in California where the salary range transparency law was implemented in January, they found that there was a software engineer posting with a salary range from 83,000 all the way up to 417,000. And there was another job posting with a pay range that actually listed the pay range between $90,000 and $900,000. So I hope this committee, when considering this bill, will look at safeguards so that Connecticut doesn't have these similar issues. And just some ways we might be able to work around that is to have a salary range that represents the actual pay range of current employees in the position, or to use a percentage-based scale. The upper and lower salary range shouldn't exceed a given percentage. And if a job posting had a salary range that went outside that percentage, that they could somehow write that this salary range represents the actual employees in the position, to explain the difference in that salary range. So just a few ideas I have that maybe we can look at when the Labor Committee is discussing this bill to give it a little more strength. So I thank you for your consideration today, and I look forward to following this bill in your committee, and I hope I get a chance to vote on it on the House floor.
Thank you, Representative. Any questions? Seeing none, thank you, Representative, for your testimony.
Thank you.
Next up, we have Representative Hubert Delaney. Next after him is Representative Christopher Rosario. Next up, we have Ed Hawthorne.
Thank you, Representative Sanchez, Senator Kushner, members of the Labor and Public Employees Committee. My name is Ed Hawthorne. I'm proud to represent over 200,000 working men and women as the president of the Connecticut AFL-CIO, and I'm here to testify on their behalf today. I'm here in support of multiple different bills, 5 total. I promise I won't go through all of them. You do have my written testimony. The first one I'd like to cover is SB 983, an act concerning unemployment benefits for striking workers. Now, I just want to emphasize the strike isn't romantic or poetic. It's difficult, it's anxious, and it's a terrifying time for all involved. This bill will reduce the number of strikes, in my opinion, by encouraging employers to bargain in good faith. In addition, it will lessen the financial impact. on Connecticut striking workers by providing them with some modest economic relief. It won't make them whole by any means. There is a 2-week waiting period in it, which is unique for unemployment compensation. Unemployment compensation is something before I took this job that I did for over 10 years, proudly serving as a employment security appeals referee for the Department of Labor. So I'm very well versed in this. If you have any questions, please let me know. But this bill is fair. It really is. And, one criticism of the bill and something I believe has been testified to in the past, it may affect the solvency of the unemployment compensation fund. I put the figures in my testimony. You can read them there. But what it amounts to is less than 0.5% of all claims filed over the last 2 years that would have actually been eligible for this payment, because so few strikes go over 2 weeks and they're much smaller numbers. And I would submit to the committee that if it would affect the solvency of the fund, we have much bigger problems, because that means there are tens of thousands, maybe even 100,000 people out on strike. And the last thing we're going to be worrying about is the solvency of the fund. Another bill that I'd like to go over is HB 584, an act concerning the number of wage and hour inspectors at the Department of Labor. Wage theft is something that occurs often, but often there's not enough people to enforce that. I mean, we're talking about getting paid less than a minimum wage, prevailing wage or standard wage not being paid, not paying overtime, not allowing workers to take meal breaks, requiring work off the clock, things that people should be paid for. These employees have a right to file a complaint. Unfortunately, right now, by DOL's own admission, they can't keep pace with the number of claims they receive. On the website, and I've included a screenshot in my testimony, 4 to 6 months to process a claim. Never mind adjudicate it, go through the process. That is just to process the claim. These wage investigators, although hardworking, cannot keep up because we don't have enough. And oftentimes they are budget positive, which means they take in more than we actually pay them. There's no reason why we shouldn't have at least 45 wage investigators at any given time to make sure all businesses play in a level playing field. It helps businesses following the rules, and it helps employees. And the last bill I'd like to go over is SB 937, an act providing workers' compensation benefits for certain cancers and firefighters. And I'll be brief on this. You do have my testimony. When you go into a fire, you're exposed to gas vapors and toxic chemicals. Now, the ventilation system protects pretty well. I mean, it's really good. I've gone through fire ops myself, but the clothes they wear to protect them from the fire, to save our house or our business, is actually killing them. Because what happens is those toxic chemicals seep through the clothes and into their skin. What if the suits that we're wearing today caused us to have cancer? I believe we would do something about that. And firefighters are no different. I believe they deserve the respect and acknowledgement. And really, the Connecticut's an outlier in this. We should be on board with this, and we should be respecting our first responders. So I thank you for the time, and I'm happy to answer any questions you may have.
Thank you. Any questions? Representative Acker.
Thank you, Mr. Hawthorne. Thank you for your advocacy. And I just got to go back. You brought up some good points on 938 and solvency. And you mentioned that the strikes that took place recently, very few would qualify for this. And I'm wondering if it wasn't part of the coming to the table, maybe it was like, hey, our members aren't getting paid. Now, maybe we're going to excel the conversation to get them back to working, because both lose in a strike. The production of a company isn't making the products or servicing their customers, and the employees not getting their revenue, they're getting paid. So what are your thoughts on that?
But my thoughts are, I don't think it'll make strikes longer. I think it'll make them shorter, because it'll bring the employer back to the table in order to negotiate in good faith. If you look at the balancing scale of it all, the employer always has more money than the employees. That's just the fact of it. So it would often level the playing field and bring these parties back to work. Because as you said, nobody wins in a strike. No one wants to be out on strike. And I know of no strike where there wasn't an unfair labor practice complaint that was filed with the National Labor Relations Board that that cause these employees to go out on strike. People don't just, oftentimes it's years of negotiating and, multiple votes and then the authorization and then actually coordinating to go out on strike. It's not something that just happens as like, oh, I feel like we should go out on strike today. So I really do think that this would encourage everyone to sit down, bargain in good faith, and really come to an agreement that everyone not could be happy with, but everyone can live with. And that's what a lot of collective bargaining agreements are.
Thank you, Mr. Hawthorne. Thank you for that, for your comments and your thoughts on that. Greatly appreciate it.
Thank you, sir.
Any further questions? Seeing none, thank you, Mr. Hawthorne, for your testimony.
Thank you.
Next up, we have Brooke Foley.
Representative Sanchez, Representative Ackert, Representative Weir, and other members of the committee, thank you so much for the opportunity to testify before you today. My name is Brooke Foley. I'm the General Counsel of the Insurance Association of Connecticut. The IAC represents Connecticut's property and casualty insurance industry, as well as Connecticut's life insurance and financial securities industries. The IAC would like to testify today in opposition to Senate Bill 937, an act providing workers' compensation benefits for certain cancers and firefighters, and House Bill 6594, an act concerning non-compete agreements. I also submitted written testimony, and I would ask that you please read that as well. First, the IAC opposes subsection B of the proposed language of SB 937, which would create a rebuttable presumption in a firefighter's diagnosis of cancer arose out of and in the course of employment as a result of exposure particular to the duties performed as a firefighter for purposes of awarding of workers' compensation benefits. The IAC appreciates the contribution firefighters have made to the community, and we are sympathetic to those who suffer from cancer. However, we caution this committee on creating a rebuttable presumption because it is unnecessary and it will cause claims unrelated to work to be accepted as work-related. Under the Connecticut Workers' Compensation Act, employees are entitled to workers' compensation benefits when they are able to demonstrate that their illness or injury arose out of and in the course of their employment. Our presumption is unnecessary because firefighters who contracted cancer at the workplace are already eligible for wage replacement benefits under section 7-313I and 7-313J of the general statutes. Under this bill, firefighters with an extensive list of types of cancer diagnoses would be presumed to have contracted such cancer during the course of their employment. Employers and insurers may become liable for indemnity and medical benefits throughout the claimant's life without the claimant having to prove their illness was related to their employment. This is contrary to longstanding public policy that requires there be a causal connection. If enacted, this bill would likely lead to a significant increase in workers' compensation system costs, complex claims, and prolonged litigation that would result in exorbitant legal expenses for employers, insurers, and claimants. Additionally, the creation of a presumption for one profession would likely lead to the creation or expansion of presumptions for other professions and would establish a precedent that would seriously expose the workers' compensation system to exorbitant cost increases. Additionally, the IAC opposes House Bill 6594. Non-compete agreements provide protection for businesses that use them, including insurance companies, for the loss of trade secrets, emerging technologies, and other confidential and proprietary information. The courts, as well as other sections of the general statutes, have already restricted use of these agreements in a way that balances the interests of employers and employees while ensuring appropriateness of scope, geography, and duration. The restrictions proposed in this bill would remove the protections non-compete agreements provide to businesses in circumstances where they need it most. The bill also makes unenforceable any non-compete agreement where a worker terminates the employment relationship for good cause. This would lead to situations in which a worker who mistakenly believes they had good cause to end an employment relationship could cause irreparable economic harm to an employer before a court could validate or invalidate their claim. Non-compete agreements and exclusivity agreements provide critical protections for insurance companies and other businesses. Again, these agreements are already highly restricted to protect employees and are critical to preventing economic harm caused by the loss of a business's most important assets. We urge the committee to reject these two bills. Thank you.
Thank you. Any questions?
Yeah.
Representative Acker.
Thank you, Mr. Chair, and thank you, Ms. Boldy, for being here. Is there language change that would work in the 937 or no? You say about rebuttable presumption, and then it continues that language further. Is it that what we have currently in statute now with workers' comp and firefighters is adequate to your thoughts, or that we can help do more by changing some of the language and what has been presented?
In Public Act 22-139 from last session, this bill created different plan that focused on a subcommittee of the Connecticut State Firefighters Association to consider these claims, and also explicitly removed rebuttable presumptions in section C, subsection F. And so we would urge the committee to look at that public act and get any information and ideas from the public act.
Okay, thank you. So, because I know that they worked long hours and a lot of stakeholders from that legislation. So, and that became public act to help address this issue. So
Yes.
coming right back to it this year. So thank you for your testimony, and I'll look forward to others' comments. Thank you.
Thank you so much.
Thank you, Representative. Any further questions? Seeing none, thank you for your testimony.
Thank you very much.
Next up, we have Joshua Goodbaum.
Thank you, Mr. Chairman. Can I be heard?
Yes, you are.
Thank you, Chairman Sanchez, Ranking Member Acker, distinguished members of the committee. My name is Josh Goodbaum, Goodbaum. For the record, I'm a partner in the law firm of Garrison, Levin, Epstein, Fitzgerald, and Parati in New Haven. Senator Kushner, I'm happy to see you as well. I'm the chair of the Employment Law Committee of the Connecticut Trial Lawyers Association, and I'm a former chair of the Labor and Employment Law section of the Connecticut Bar Association, as well as many other acts of service and bar participation you can find on my website if you like. I'm speaking today in enthusiastic support of HB 6594, an act concerning non-competes. I will say at the outset, I'd be very happy to have a conversation with any member of this committee who wants to discuss non-competes. My phone number is 203-777-4425. Please feel free to call me. That's not marketing. I'm happy to talk with you. I litigate non-competes on behalf of employees. I've been doing so for over a decade in Connecticut, and I want to make just a few quick points. One is, there is no clarity in the Connecticut law about whether any particular non-compete is enforceable. And I should know, I'm the person to whom employees come when they say, I've got a non-compete and I don't know if I can take another job. And I say, I read the non-compete and I talk to them and I give them general principles of law. And then I say, yeah, I'm not really sure. Let's maybe go to court and try to find out. But what I also have to tell them is it's quite expensive to do so. It's expensive to hire me or any other lawyer who's going to advocate for you trying to invalidate a non-compete. In most areas of the common law, we get development over time, right? So non-competes in Connecticut are governed by the common law. That means judge-made law. In very few areas is there a statute that governs non-competes. It just evolves over time, case by case, until lawyers can figure out what the rules are and judges can figure out what the rules are. Non-compete law has basically not developed since the announcement of the 5-factor reasonableness test by the Connecticut Supreme Court in the mid-1970s. And that's because of the nature of non-compete litigation. The cases only really get litigated at the preliminary injunctive stage, at which point everybody figures out a way to move forward. They very rarely get to final judgment. They almost never get to an appeal. And it's at the appellate courts, the Connecticut Appellate Court and the Connecticut Supreme Court, where this law is made to try to clarify in what circumstances is a non-compete more likely to be enforceable and what circumstances less, right? You could show me a non-compete that is 6 months and I could say, well, it's definitely not enforceable for the following reasons, or 5 years and I could say, well, that one's got a strong chance of being enforced. There are no, other than the people who do this every day, day in, day out, the lawyers who handle this work, it's very hard for a normal person to figure out whether their non-compete is or is not enforceable. It's an area that is really ripe for legislative intervention. And that's why I think it is so important that the governor is promoting this bill, and why it's important that this committee is holding this hearing. I have many more things I could say about non-competes, and I'd be happy to say them, but I understand there are many people waiting to testify, including a former client of mine who is up in two, Dylan Marcus, to talk about his experience with non-competes, which I hope the committee will find useful. Thank you for listening to me. I welcome your questions if you have any. And again, I would be happy to speak with any member who wants to talk about non-competes in Connecticut.
Thank you. Any questions? Senator Kushner.
I am curious to know, so what, I mentioned this, I think, at the outset, but I've always thought of non-competes for proprietary information. And yet I've heard that there are low-wage workers now who are being asked to sign the non-competes, or being required, I should say, not asked. And I wondered if you could give us some examples of industries or jobs in particular where workers are frequently signing non-competes in order to have a job.
I can't think, thank you, Senator. I can't think of any industry where I have not seen a non-compete. They are not in every employer, but they're the kind of thing that's very difficult to track, because how do you, employers don't disclose their handbooks. They're not publicly available in most employers, particularly in small and medium employers. Representative Ackert mentioned a barber in asking questions. I've consulted with a number of people who work in the hairstyling industry, people who wanted to open a barber shop in a neighboring town, and said, listen, I don't want to poach any employees. I don't want to poach any employees. I don't want to poach any customers. I'm not going to solicit anybody. But, I've been cutting my dad's hair for 10 years, since before I was working at ABC Barbershop. And if I go open my own shop, is my dad allowed to follow me and get a haircut from me? There are customers who are loyal to me, I've been working with for a long time, who might want to follow me. And, it's important for me not to have to drive too far, because I've got childcare responsibilities. I need to be close to home in case my kids need me. This is just a part-time business. There's all kinds of ways in which non-competes, in my experience, are hampering entrepreneurship and innovation. So the barber or hairstyle industry is one. Mr. Marcus Dillon is going to talk about his experience as an intro, a burgeoning exterminator, and how he had a non-compete that restricted his ability to work as an exterminator in at least lower Fairfield County, but in my view, most of Fairfield County, and the litigation that came from that ultimately was thankfully resolved, but not before Dylan paid me, frankly, money to try to work it out. I have talked with employees who work in the mechanic industry or the auto body industry, fixing dents in cars, painting cars. I can't think of a blue collar industry or what you might think of as a core American business for working and middle class folks where they're not faced with issues around non-competes. My exposure might be skewed because I'm just speaking with the people who do have these issues, not with people who don't. But to me, this is a serious problem affecting a lot of real working people, and having clarity on this issue would be really useful to those folks.
Thank you for that. Thank you, Mr. Chairman.
Thank you, Senator. Representative Ackert.
Thank you, Mr. Chair and Attorney Goodbaum. Thank you for being. I wrote your phone number down, by the way, just so I got it. You said it pretty quick, but guess what? I wrote it down. So I will be reaching out to you.
I look forward to your calls. I look forward to your call, Mr. Representative. Thank you.
And so my comment was more in the healthcare area. Access to healthcare has always been important to me, and I think all of us that serve in this building. And I mentioned that, the person that left, it was actually a cancer doctor, and I don't know if there's proprietary in serving, a patient, but they had to set up their office 10 miles away from where any other location where that health facility had a location. And some of our big health facilities in the state of Connecticut. They have offices everywhere. So to find a location that might be 10 miles, it really did a disservice to the patient, as far as I'm concerned, that they had to travel to follow their cancer doctor quite a ways more than they typically would to get their treatments. So is there any thoughts on that at all? Or I don't think this reflects that, because the pay scale, I believe, for a doctor is much higher, but your thoughts on that?
Yes, thank you, sir. Physicians in Connecticut have their own non-compete law. It's one of the very few areas in which the General Assembly has regulated non-competes. That is at section 20-14P as in Peter. And that law says that a physician can be forced to sign a non-compete as a condition of employment, but the non-compete can only last for 1 year and can only restrict them to practice within 15 miles of the primary site at which they previously practiced. So we don't have a situation in which a large healthcare entity, say Yale or Hartford Healthcare, can prohibit a physician from practicing in more than a 15-mile radius. Now, 15-mile radius can be a fairly large radius. It's not driving. It's usually as the crow flies. That's how we think of a radius, and that could be inconvenient for some patients. But that is a judgment that the General Assembly has made in 20-14P, and of course could revisit if it chooses to do so. I will add that 2014P, like the bill you're considering today, is prospective only and not retrospective. So I still consult with physicians who signed non-competes before, I believe it was 2016, that section 20-14P went into effect. And those physicians are still struggling with non-competes that say things like, you can't practice within X number of miles of any place where you practiced in the last 5 years, or any place where our organization has a location, even if you've never practiced there. So that can be quite inconvenient for physicians, and even more importantly, can be really inconvenient for the patients who need continuity of care. So that, again, that's a judgment the General Assembly made to make the bill prospective rather than retrospective only. But I think the details of the physician non-compete law are pretty clear. There's relatively little uncertainty for the physicians who are subject to it. So it is more administrable than in almost any other area of the economy, which is governed by the common law.
Thank you for that answer, and it is for the patient is the real issue there. You know, somebody has to see regular visits, you know, weekly or bi-monthly. A year is a long time, but thank you for that, and I appreciate further dialogue with you.
Representative Weir.
Thank you, Mr. Chair, and thank you, Mr. Goodbaum. I too did write down your number and would like to be in touch. Representative Ackert's not the only one with the fast pencil. I do appreciate the opportunity to talk about clarity, because I think when Senator Sampson talked about private contract between two willing parties, and I do agree with that premise. At the same time, making sure that everybody knows what they're getting into, that somebody's not signing something under duress, under fear of perhaps losing out on an opportunity. So I think I'm open to listening, certainly, to how we can provide clarity to any of that process that, certainly we don't want to keep take away your customer base, but at the same time, we want to make sure that people know where they stand. You referenced auto body people working on dents, some of the mid-level employment. I believe that's how you described it, auto mechanics. And, presumably some of those people may come in without some of the skills that an employer is going to provide them with, perhaps tools, knowledge, maybe not the secret sauce, but certainly potentially industry skills. And I think for that, an employer has some expectation that they're not just somebody's not going to up and take that that knowledge down the road at the first opportunity. And again, I have to mention that I am currently an employee. I've been a small business owner. In my current position, I had the opportunity to negotiate my salary, my benefits, wages, car allowance, and my non-compete. So from my perspective, all of those things are up for negotiation, should be done so under clarity upfront, not after the fact. And I'm definitely willing to listen more as we proceed down on this topic. Thank you.
Thank you, sir. And I would be delighted to speak with you. Please call me. I'll say for the record, please take my client base. I'd be very happy for Connecticut citizens and employees not to have to deal with this issue over and over and over again. I have plenty of work to do. So please don't worry about me. I'll note one more thing for the record, which is the only sector of the economy that doesn't have to deal with non-competes at all are lawyers. It's in our rules of professional conduct that we can't sign non-competes and that we can't be bound by non-competes. And you know something's fishy when only the lawyers have exempted themselves and everybody else is governed by the laws that we seek to enforce. To me, that's a sign that something is wrong. I don't see why the relationship between a lawyer and a client is any more important than the relationship between a physician and a patient, or between a therapist and a patient, or between somebody who cuts your hair. These are all important relationships to customers, and everyone deserves the opportunity to be able to earn a living. I think you raise a good point, Representative Weir, about training. And I think that's a countervailing factor. It's one I would welcome the opportunity to consider, but having been trained at an enterprise, having been a new mechanic, a fledgling mechanic who starts working in a garage, doesn't mean you should be tied to that garage forever. And that's the functional result of having a 1 or 2 year non-compete on a mechanic. If you can't go work at another garage within 25 miles, what are you going to do? Take 2 years off from being a mechanic, go do something else, and then come back to it? That's not practical for most working people. So I tend to err on the side of people being able to work and earn a living. I understand there are folks who err on the side of business owners. I think that's also fair. Ultimately, policy judgments are what you all are elected to make. So thank you for your time again.
Thank you. Any further questions? Seeing none, thank you, sir, for your testimony.
Thank you.
Up next, we have Andrea Johnson.
Thank you, Chair. Andrea Johnson with the National Women's Law Center. I'm here in support of HB 6273. The Law Center has been working for decades with policymakers across the country to strengthen laws that will help close gender and racial wage gaps. We've really identified pay transparency as a leading tool for closing these gaps. And to the question earlier, I wanted to note that my written testimony provides several citations to research that shows that when employers are transparent about pay, this helps close gender wage gaps in many ways, really, including by narrowing gender gaps that arise in negotiations and also incentivizing employers to regularly look for and fix unjustified gaps. So please take a look at my written testimony. I just want to say that because of Connecticut's current transparency law, Connecticut businesses are already accustomed to having to provide job applicants pay ranges for a position. But what we really learned in the years since is that Connecticut businesses aren't reaping the benefits that come with having to provide the pay range specifically in job announcements. The recruiting edge and the cost savings that really come from that specific requirement. Nor does the current law create a strong of employer accountability for paying employees fairly. But we're excited about HB 6273 because that will change that. And we're seeing laws like HB 6273 that specifically require pay ranges be placed in the job announcement are really taking off in states and cities across the country because of how they help close wage gaps, but really in large part because employers and lawmakers are seeing how sharing pay ranges helps businesses attract and retain talent and save time in the hiring process. We've heard from more and more businesses over the last few years, small and large alike, that pay range transparency helps them more efficiently and effectively find and match with candidates who are actually interested and would take the position. And this helps save costs and really give small businesses without an HR an edge. And I want to flag that several jurisdictions that have passed these laws have specifically required a general description of benefits be provided in the announcement alongside the pay range. And we've heard that small businesses in particular appreciate that piece of the law. And I'll just end by saying that we've heard, as others have noted, that we've seen survey after survey over the last few months that 98% of workers want or expect employers to share pay ranges and postings, that large percentages of employees prefer to work for transparent companies, and many wouldn't even apply for a job that does not include the pay range. So this is really a necessary measure for attracting talent and being a competitive business. And we all really want to feel that we're being paid fairly. This is a simple measure that will go a long way in helping Connecticut businesses stay competitive. It's just saying, be transparent about what generally you are hoping to pay, that might be the minimum, and what you are willing to pay, maybe the maximum, the minimum and maximum amount. And we think this will go a long way in helping Connecticut businesses and working people feel confident that they are being paid fairly. I'm happy to answer any questions.
Thank you. Any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Up next, we have Dylan Marcus.
Can you guys hear me okay?
Yes, the floor is yours. Thank you.
All right. So as Josh referenced, I was a former client of his. Just speaking out in support of HB 694. Please forgive me. I'm not the most polished speaker, but I'll just kind of try to tell my story here. And you know, you guys take that for what you will. So basically, I worked for someone in the pest control industry where I was making about as highest was $19 an hour, about $30,000 a year. When I was asked to sign a non-compete contract that basically stated I could not work in the majority of Fairfield County, which is where I lived and have lived most of my life, for a period of 5 years. It also included a non-solicitation of former clients and some other things. And I was told I couldn't continue to work until I signed the contract. I tried to, you know, seek legal advice through a family member. I basically was not able to get in contact with them, and just basically through pressure, you know, eventually, you know, I put it off for a little while, but then, you know, ended up signing it, you know, thinking that, you know, if I left, I was going to do something different. Anyway, you know, I worked there for a little over a year and a half, and then I ended up leaving, more so because I just didn't enjoy working at that particular place. Took a job where I was making $8 less an hour, working an insane amount of overtime to try to, you know, pay my bills and things like that. And as I got further and further away from it, I really missed the work. So I looked into, you know, how feasible it would be for me to get back into things. And, you know, I spoke to a different attorney who basically told me that, you know, the law says that they have certain interests to protect as far as their clients and things like that. But that it's unreasonable for you to not be able to work in such a large area for such a long time. So they recommended that, you know, a year and a half would be an appropriate amount of time. And as long as I showed, you know, that I wasn't going after any former clients, that I would be in a decent position to be able to work. So, you know, I ended up starting my own business, and I had all my clients, both, you know, I asked them, did you work, you know, for the company while I was there or ever? And then, you know, had them sign on the invoices that they did not, you know, do business, you know, with the company while I was there. So I even have a family friend who I actually used to babysit her 5 children growing up, who's a client and is still a client with my old company, because I told them, you know, it's, you know, this is the law. So fast forward a little over a year, I'm into the business. I think it's pretty clear that I had been performing the business. I was doing a little better, and I purchased a new service vehicle that, you know, my former employer had saw. And then, you know, I get a summons saying, you know, being served by the marshal for violating this contract. And basically, you know, so this is super stressful. So I'm sort of scrambling what to do. I find Josh through, you know, a referral of a family member. And he basically explains to me that, you know, yeah, the law is on your side, but it's not going to be super cheap to fight this thing. And it wasn't. The long and short of it was, we get it resolved to basically agree to what I was already doing, which is not go after any former clients. But this was an immense financial expense that you know, I didn't get back. And I think for most people, you know, I was really lucky in that, you know, I did have some savings and was able to figure out, you know, a way to get these things paid off.
Mr.
But
Marks, your time is almost up. Please conclude your remarks.
so yeah, I'll just say that, you know, I support it. I'm all for the non-solicitation, but I think it's unreasonable to restrict people, especially lower level employees, from, you know, working in the area that they live.
Thank you. Any questions? Representative Acker.
Thank you, Mr. Chair. Dylan, thanks for being here. What was the time frame, if you can briefly describe the time frame from when you left and then when you started your business?
So I left at the conclusion of August of 2018, and then I started my business March 31st of 2020, so about a year and a half after I had left.
So what you signed was longer than 1 year non-compete?
Yeah, and again, I, you know, sought some advice from a different lawyer who basically explained to me that that is unenforceable, that length of time is only used for people who are, I guess, selling their business. You know, and so again, I wasn't sure. I don't really have a background in any of this sort of stuff. But, and I thought, you know, because I was talking to people basically and was just like, oh, I have to wait this 5 years if I want to ever do this again. And then, you know, someone suggested, oh, talk to this person, you know, see what they have to say. And then they kind of showed me some of the previous like cases and precedents, I guess they're called, of how like for all these different criteria, like too big geography or like unreasonable length of time, that the law was on my side as far as that goes. And they recommended that I was in a position to start it.
Thank you, Dylan. Thank you so much. Thank you, Mr. Chair.
You're welcome. Thank you.
Further questions, Senator Kushner.
Thank you, Mr. Chair. I have a couple of questions that are kind of personal, and I apologize, but I think it will help us have a little perspective on the parameters of the bill that's been proposed. When you were working for the employer, you were doing exterminating work, is that right?
Yes.
And can you tell us roughly how much money you earned in that position?
At the height of it, if you extrapolate it out for the course of the year, it was about 30,000 a year before taxes.
And again, I apologize, but when you say that it was expensive, and we heard that from the attorney who spoke previously to fight the case, do you know roughly how much money you spent engaging an attorney and fighting for your rights under existing Connecticut law?
Yeah, I think roughly it came out to close to $30,000.
Wow. Okay. I
Yeah.
apologize for having to ask you that, but I think it's really important for us to know. Thank you.
Of course.
Thank you. Any further questions? Seeing none, thank you for your testimony. Next up, we have Jose Anaya. Thought he was on the call. Might be coming back. Next up, we have Brian Simmons. Oh, he's there. I thought I saw you on the call. Sorry. Jose Anaya, thank you.
Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Acker, and the distinguished members of the Labor and Public Employees Committee. My name is Jose Anaya, and I live in Bridgeport. In December of 2022, I began working as an organizer with UFCW Local 371. Prior to that, I was an employee at Stop Shop since 2016. Thank you for the opportunity to testify in support of SB 938. In April of 2019, as a newly full-time employee at Stop Shop, I walked out along with over 10,000 of my coworkers in Connecticut and thousands more in New England. I had watched my union leadership bargain for nearly 4 months before telling us we had no choice but to stand up and walk out. I walked out on strike despite being the only wage earner in my home and without substantial savings to protect me. I did it because I was proud of my work in my store, and I knew I deserved to be treated better by my employer. I also did it because I trusted my union leadership and my coworkers. I did it because as a union member, I made a promise to stick together, and if my coworkers were to strike, I knew I was going to strike too. The strength of my coworkers and the support of my community is something that I will never forget. However, the loss of 11 days of income is frankly something that took me over a year to catch up from. If I had to do it again, I would. I know my actions and the actions of my coworkers not only protected our benefits for the workers in Stop Shop who will come after me, but it also set the standard for non-union supermarket workers throughout the area, pressuring those non-union employers to increase their wages and benefits as well in order to attract the workforce. Unionized workplaces raise standards for all workers. When striking workers can access unemployment benefits to help sustain themselves and their families, it empowers them to advocate for protections that benefit all workers. Thank you for the opportunity to testify. I am happy to answer any question you may have.
Thank you. Any questions? Senator Kushner.
Not a question. I just have to say a quick comment. I think, did you say you worked in the Bridgeport store?
I worked in Milford during the time.
Milford, okay.
Yeah.
But I know the first day of the strike, I went to Bridgeport and
That's where we had one of the rallies there.
exactly, I was there that day. And I think that the importance of what you all did went way beyond your own personal situation and really impacted wages and benefits for workers throughout our state and throughout the New England region. You took a stand on a principled issue and everyone saw it. You got tremendous support from the community, and it's that kind of courage, I think, that really moves us forward. So I just wanted to thank you.
Thank you. I appreciate it.
Thank you. Any further questions or comments? Seeing none, thank you, sir, for your time.
Thank you.
Next up, Brian Simmons. Officially.
Good afternoon.
Afternoon.
Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, and distinguished members of Labor and Public Employees Committee. My name is Brian Simmons. I live in Waterbury, Connecticut. Since 2020, I have been a union representative for the UFCW Local 371. And prior to that, I was a member of Local 371 for over 20 years. Thank you for the opportunity to testify in support of SB 938. In the spring of 2019, my coworkers and I voted to go on strike from our jobs at Stop and Shop. This was not a decision we took lightly, and the last strike lasted one day in 1988. We were naturally afraid to take this vote, but our employer left us with no choice. We were faced with the elimination of our pension as we knew it, the elimination of insurance benefits for spouses, and unacceptable wages. For those 11 days in April 2019, I was a strike captain for several stores around the Waterbury area. Our shoppers were incredibly supportive, and it quickly became apparent that our employer was not going to be able to find enough replacement workers to keep most of their stores operable. However, as the days stretched on and 1 week turned into 2, I could sense the panic in the faces of my coworkers. Many of us live paycheck to paycheck. I don't know many people who don't. If we had been able to collect unemployment, one of two things would have happened. Perhaps we would have been able to hold on just a bit longer and secure a better agreement, as it was clear we were winning the strike when it came to our shoppers, the store's business, and in public opinion. But more than likely, it would have meant we never would have had to go on strike in the first place. I believe our employer thought we would fold sooner than we did. I have never been prouder to be a member of our union, and ultimately our resolution was good. But I would have preferred that the employer knew we were strong before pushing us to the point where we had no choice but to walk out. If they knew we could have held out for an even longer and stronger deal and collected unemployment benefits after 2 weeks, they may have reconsidered their proposals to decimate our benefits. I thank you all for the opportunity to testify. I am happy to answer any questions you may have.
Thank you. Any questions or comments? Representative Hughes.
Thank you, Mr. Chair, and thank you for, your collaboration with your fellow workers to demand decent working protections for all workers. I'm wondering if if the parent company that owns Stop and Shop, I think it's foreign, right? Is it Swedish or Dutch?
Dutch.
It's Dutch, right? And in Dutch society, I believe they do have retirement and sick pay and healthcare protections. And so what American workers are demanding is no more, no less than what the parent company normalizes in their own company. But I think what they expected was that American workers, like you said, would fold quicker because we have not raised that floor. And how do you think being able to collect unemployment insurance would change that equation for foreign companies, foreign parent companies that are profiting off of American labor?
Well, I think for workers to be able to have collected unemployment after the 2 weeks, I think it would take the pressure off of what's truly in front of you. It would give you more time to concentrate on the bigger picture instead of the bills that are coming at you in the short term. So when you're thinking about the bills that are already waiting for you at home, you have to weigh your options on how far you want to go. And that truly, it doesn't make a successful strike because you're thinking about other things.
That's all. Thank you.
Thank you, Representative. Representative Acker.
Thank you, Mr. Simmons, for being here and telling us that story and what you went through. How did that labor agreement work out? Was it, did you get to where you wanted to, or was it, just because I know you're out for a while. What was the total length of that strike, by the way?
11 days.
It was 11, okay. And so, and how did that work out for the workers?
Well, a strike is never good. But I will say, considering where we started and what they wanted to take from us, we would say we were proud where we ended.
Thank you. And again, thank you for being here and on behalf of your colleagues. Thank you.
Thank you.
I just, chairs, as you know, people have other meetings to go on. I do have to step out. I do apologize. I will read the legislation and I'll be back though. I'm leaving my stuff here. So thank you, Mr. Simmons, for being.
Thank you.
Thank you. Further questions, Senator Kushner, comments, questions?
I don't want you to feel left out. I know I commented on the previous, your colleague, your union brother who spoke before you. And but let me just make a straight up comment about all of the people who participated in that strike and your union leadership who led that strike. It was tremendous effort. And thank you for everything you did to move us forward and make sure that workers are treated fairly.
And we
I
thank you for
really
your support.
And I appreciate that you mentioned the pension and the healthcare because those are so critical to every working family. So thank you.
Thank you. Thank you for everything.
Thank you, Senator. Thank you for your testimony, sir.
Thank you.
Next up, we have Elisa Correa.
Good afternoon, Senator Kushner, Representative Sanchez, and Senator Sampson, Representative Acker, and the distinguished members of the Labor and Public Employees Committee. My name is Lisa Correa, and I live in West Haven. In December of 2022, I began working as an organizer with the United Food and Commercial Workers Union. Prior to that, I was an employee at Stop and Shop since 2016. Thank you for the opportunity to testify in support of SB 938. In April of 2019, as a florist manager at Stop and Shop, I walked out along with over 10,000 of my coworkers in Connecticut and thousands more in New England. Not only did I walk out on strike with my coworkers, I walked out on strike with my entire family. My husband, my father, and my sister are all employees at Stop and Shop. We have over 50 years of, we have over 50 years of service between us. My husband and I were newly married with 2 children without substantial savings. We made the decision to walk out on strike despite it all. We knew that what we stood to lose was much greater. After our union was in bargaining with Stop and Shop for over 4 months, they were still bent on making substantial cuts to our health benefits and pension, things we've worked our whole lives to earn. We had no choice but to go out on strike. I was a picket captain at the Stop and Shop in Bridgeport. Over the 11 days on strike, the support from our community was amazing. There was power and unity in all of us to stick up for ourselves, our family, and our community. However, the loss of 11 days' pay was a heavy hit on my family. 4 incomes were lost for 11 days. With that being said, if I had to do it again, I would. I know that the only way to have protected my family's benefits and to secure our future was to walk out on strike. We set the standards for workers to come into the grocery industry. Going out on strike taught ourselves and the community what can happen when we all stick together. This strike turned me into an even prouder union member. We won our strike, but I can't help to think how much easier it would have been to hold on longer, knowing that we could receive unemployment benefits after 2 weeks. Thank you for the opportunity to testify. I am happy to answer any questions you may have.
Thank you. Any questions or comments? Seeing none, thank you for your testimony.
Thank you.
Up next, we have Emily Sabo.
Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, and the distinguished members of the Labor and Public Employees Committee. My name is Emily Sabo, and I'm the organizing director at the United Food and Commercial Workers Union Local 919. Thank you for the opportunity today to testify in support of Senate Bill 938. Today, I want to take you back to April of 2019. I was finishing my degree at Albertus Magnus, and I was new on staff at my job, a union organizer for the union that benefited my family for over 40 years. When I came on staff that year, I knew we would be bargaining with Stop and Shop. On April 11th, 2019, our nearly 7,000 members went out on strike, along with thousands of our union siblings across New England. 2 of those members were my mom and dad. For the past 24 years, I had listened to my mom and dad praise their union job. This job was the reason they had a career after high school, the reason they could buy a house and raise 4 kids, the reason we had good insurance and braces, the reason we went to Disney World every other year. They, just like many other employees at Stop and Shop, are proud of their job and their union. When I found out that Stop and Shop was threatening to slash their health and retirement benefits and propose unacceptable wages, I knew we had no choice. Our members worked tirelessly for many years to earn those benefits. They couldn't lose them now. After months of bargaining, we had to take a strike authorization vote. I watched as the strike vote passed, and thousands of hardworking people, just like my mom and dad, prepared to go out on strike. When that day came to go out on strike, it was actually an amazing feeling. Together, union members from all backgrounds, with all different amounts of service, banded together to stand up for their future. My job was to direct the strike lines while our union leadership and negotiators did their part. We received community support that was unimaginable. After 11 long days, we won our strike in an acceptable contract. And although we won our strike, the decision to go out was not taken lightly, and clearly something that's still emotional for me today. And it was not without consequence. Many of our members lived paycheck to paycheck, and it took some a long time to catch up. Members weighed out losing pay for 11 days against future cuts that would change life as they knew it. But we stuck together as a union family because that's what we are: moms, dads, siblings, grandparents, and pieces of our community. Today, I'm here to urge you to pass Senate Bill 938 so that future workers are able to hold out just a little bit longer on the strike line to get the best deal possible for themselves and their communities, with the peace of mind knowing that they will be able to collect unemployment benefits after 2 weeks out on strike. Thank you for the opportunity to testify today, and I'm happy to answer any questions you might have.
Thank you. Questions, comments, Representative Hughes?
Thank you, Mr. Chair, and thank you, Emily, for your testimony, your intergenerational testimony. Can you tell us really what a serious decision and impact it makes to actually be on strike? That I think most of us don't understand what that uncertainty and hardship looks like to most families and most workers and their families.
Yeah, so our members had to vote to go out on strike. It was not a decision taken lightly after leadership had been negotiating with Stop and Shop for quite a bit of time. And we realized that we were getting nowhere. And without going on strike, workers would never be able to keep the benefits that they had. And the threat of losing those was bigger than the fear of going on strike.
Thank you. I think that the opposition to this is going to say that people will just strike, casually. And I just wanted to say that it is a real hardship. I know with joining so many of the striking workers, they were losing their voice from laryngitis, from rallying on the street and really educating the public, the consumers that were coming to the shop at what unfair exploitive practices this big company was taking advantage of this workforce in a very, very difficult climate where it's very difficult to live.
Yeah, nobody wants to go out on strike. That's for sure.
Thank you, Mr. Chair.
Thank you. Any further questions or comments? Seeing none, thank you for your testimony.
Thank you.
Next up, we have Brandon Mancia.
Good afternoon, Senator Kushner, Representative Sanchez, Sampson, Ackert, and the distinguished members of the Labor and Public Employees Committee. My name is Brandon Mancia. I'm the director of UAW Region 9A, a union that represents over 35,000 workers across the Northeast and Puerto Rico, including over 6,000 members here in Connecticut. Thank you for the opportunity to testify in support of SB 938. Today, Connecticut workers who go on strike are unable to collect unemployment benefits as they are presumed to have left their jobs voluntarily. While workers do make the decision to go on strike collectively as a union, they do so only when they have exhausted all other options available to them in collective bargaining, and they have no other resort when up against a stubborn employer. They do not make this decision lightly. Though the right to strike is federally protected, it does not preclude certain risks. Workers know these risks better than anyone. They will almost certainly see a loss of income. Their employers will threaten that they will hire replacement workers who then stay on permanently. And nevertheless, when they make that choice, it is important for the community and allies of labor to know that a strike may be the only option they have to resolve differences with their employer. As a UAW member and former local president in Massachusetts, I've been on strike twice as a graduate worker at Harvard University for fair wages, healthcare, and an end to workplace harassment. As a union rep in New York, I have also prepared workers to go out on strike over issues ranging from pay and benefits to workload and generally winning greater control over their working conditions. I have seen firsthand how difficult a decision it is, but ultimately how necessary it is to strike in order to win fair contracts that improve living and working conditions for the members. But when I discuss the possibility of going out on strike with members, workers' main concerns across all industries is how to prepare financially when they lose pay. The right to receive unemployment insurance would help workers endure a situation in which their employer is not negotiating in good faith. SB 938 follows the example set by neighboring states, such as New York and New Jersey. As the UAW Region 9A director, I can speak to the fact that my members who receive unemployment insurance in the event of a strike in New York State have allowed workers to win better contracts. Moreover, after the GM strike of 2019, the UAW got to work to reduce the waiting period to receive unemployment insurance from 7 weeks to 2 weeks in 2020. UI during a strike allows workers to have the confidence to remain on the picket line to win what they deserve. And yet, this is not the most significant impact this law would have. If passed, SB 938 would give workers greater leverage before a strike were to even occur. This may seem counterintuitive at first, but the more power workers have before they go out, the more they can avoid a strike altogether. We often see that employers will immediately change their tone and tact at the negotiating table once the workers take a strike vote, as we saw at UAW Local 405 at Triumph a couple of years ago. If an employer understands that striking workers will be eligible to collect unemployment benefits after a 2-week waiting period, likely resulting in a small increase to their unemployment insurance rates, they will be more likely to bargain in good faith and avoid a work stoppage altogether. Unions built the middle class by winning fair collective bargaining agreements. Strikes are a best reminder of the sacrifice it takes for workers and communities to win dignity and respect. The standard of living workers in this country have been able to win was not the result of charity nor nobility, but earned through their efforts and sacrifice, often on the picket line. When striking workers can access unemployment benefits to help sustain themselves and their families, it empowers them to advocate for protections that benefit all workers. Stronger unions lead to stronger communities. We urge the committee to support this bill, which will go a long way towards building the middle class and protecting workers' rights in this state. Thank you for the opportunity to testify. I'm happy to answer any questions you may have.
Thank you. Any questions or comments? Seeing none, thank you for your testimony.
Thank you.
Next up, we have Carl Fortuna.
Good afternoon. Thank you for having me, members of the Labor and Public Employees Committee, Senator Kushner, Representative Sanchez. My name is Carl Fortuna. I'm first selectman of the town of Old Saybrook for the last 11 and a half years. I'm here on behalf of CCM and the town of Old Saybrook to speak in opposition to SB 937, workers' compensation benefits for certain cancers in firefighters. I oppose 937 as it would, among other things, create a rebuttable presumption for firefighters bringing a workers' compensation claim for cancer. I believe, and I think it's no doubt, the bill would significantly change the workers' compensation laws, thereby imposing significantly elevated costs to municipalities. In addition, the bill is a result of a task force that disregarded some municipal input and ignores the bipartisan agreement that was reached in 2016 to assist firefighters diagnosed with cancer. Last year, CCM worked with all the stakeholders to ensure that improvements were made to the Cancer Relief Fund. I know because I was on that subcommittee. Through Public Act 22-139, CCM worked collaboratively to address funding and safety issues, including crafting a maintenance and remediation plan for toxic substances on firefighter turnout gear, requiring the Workers' Comp Commission to maintain a record of all firefighter workers' comp claims made due to a cancer diagnosis, and requiring each town to make annual contributions of $10 per firefighter, a small amount, but a start, starting in 2024. As we work together to address these issues, there was a commitment that this year we would try to secure state funding, a state funding stream for the Firefighter Cancer Relief Fund. This fund has been working. The application and corresponding education has been disseminated to all firefighters throughout the state, includes the availability and process they need to follow to secure funding. To date, at least 3 firefighters have had their claims reviewed with payments processed by the state. No firefighter has been denied benefits. In fact, the committee responsible has done so in a timely fashion, working with each applicant to ensure they get appropriate funding. The Office of Fiscal Analysis has concluded that the costs associated with providing this type of care would be higher than any other category of claim in the workers' compensation system. As we all know, a single cancer claim can exceed $1 million. Town workers' compensation rates, which have been relatively flat for many years, businesses and municipalities, I believe, would see a tremendous spike in our workers' comp insurance. That would affect property taxes. It all comes down to property taxes when we have these type of mandates put on the towns. The bill, in addition, shifts the burden of proof onto the municipality to provide a clear and convincing evidence that the cancer was related to other factors. And again, as we all know, Connecticut once before tried rebuttable presumptions with heart and hypertension and found that the repeal of that law was the only way to keep towns solvent. I'd prefer not to go down this path again. Old Saybrook has a very robust firefighter department. We have about 80 or 90 volunteers, and we take care of them. We have a pension plan. And we make sure they have the proper equipment, and we're grateful. But I would suggest the following to strengthen the current efforts. We should maintain the state's commitment in supporting firefighters by increasing and securing a reliable funding stream for the Firefighter Cancer Relief Fund.
First
Unfortunately,
Selectman Fortuna, your time is almost up. Please conclude your remarks.
Thank you. I'd like to have the stakeholders pull together again like we did last year, and we were able to get to a conclusion on that. And there's also some class actions right now against DuPont and 3M, which I'd like to see Attorney Tong, State's Attorney Tong, Attorney General Tong, perhaps take a look at. I don't know if he already has. And with funds recovered from that, perhaps the class action, we can not only fund the firefighter cancer fund, but turnout gear that doesn't have PFAS materials in it. So thank you for hearing me. I think there is a way forward that we could all work together on.
Thank you. Any questions or comments? Senator Kushner.
Thank you for your testimony here today, and appreciate your remarks about the work that we did last year on the task force regarding Cancer Relief Fund for firefighters. I think that we did make some improvements last year, but the concern is, and we're going to hear a lot of testimony today, I believe, that the fund itself cannot support the families of the firefighters who we've lost in the way they would be supported by workers' compensation. And I think that's really critical, so I think that, I just want to say, I think there's tremendous support amongst my colleagues to really address this issue. I know you mentioned your concern about the rebuttable presumption. I think it's really important. We know that it is very difficult to prove you got cancer from a single source, but we think there's still an opportunity for towns to make the argument if there are factors that would indicate that the firefighter, didn't contract the cancer from fighting fires. There's just a lot of evidence out there that this is, in fact, we know that firefighters are contracting cancer on the job. And it's, I know I'm making a comment here and I shouldn't, because I asked our colleagues not to make comments, but it's really hard for me this is such an emotional issue because we ask firefighters to risk their lives, to save our lives, to save our property, to protect our property. And then we don't want to pay. And I think that's just wrong. And the workers' comp system, it's not just been stable. In fact, the rates have gone down historically. And it was as a result of some of the way workers' comp is calculated. It was before my time in the legislature, but I understand there were changes made that benefited municipalities and employers in the way formulas are calculated for workers' comp. So, it just seems to me that we haven't solved the problem yet. And I appreciate all the efforts of those who worked on the task force. I appreciate the efforts of the Connecticut Firefighters Association and creating this and maintaining the fund. I'm happy to know that 3 firefighters have had their claims addressed this year, but I think we all recognize the limitations as well. So, I apologize that it was a comment and not a question. And I thank you for being here to testify today. But hopefully this is the year that we will actually completely address the needs of our, very heroic firefighting force.
Thank you.
Any further questions? Seeing none, thank you for your testimony, sir.
Thank you.
Up next, we have Dave Vivieros.
Hi, folks. Can everyone hear me? Hopefully. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, and Representative Ankart, and all the distinguished members of the Labor and Public Employees Committee. My name is David Viveris. I live in Norwich, Connecticut. I work at Foxwoods Resort Casino. and I am a chief steward and vice president of Local 2121 UAW. Thank you for the opportunity to testify in support of State Bill 938. First of all, I would just want to echo what Brandon just said. State Bill 938 is not a measure designed to enrich workers. Instead, it's designed to avoid a labor dispute. If an employer understands that striking workers will be eligible to collect unemployment benefits after a 2-week waiting period, likely resulting in a small increase to their unemployment insurance rates, they'll become more likely to bargain in good faith to avoid a work stoppage altogether. I'm going to go a little bit off the script because I have a personal story that I want to share with everybody. Long before I was a leader in the union, and long before I worked for Foxwoods Resort Casino, I was involved in a labor dispute with professional baseball in the 1990s. All right. I instead of going to college, dropped out of college and wanted to become a baseball umpire. I went down to umpire school in Florida, passed the course down there, and became a minor league baseball umpire and traveled this country. In 1990, their union, the AMLU, our union, went on strike because we didn't have good wages. We had horrible health care in the minor leagues. And you want to talk about unfair labor practices. I mean, if you got hurt, you were out of a job. You were considered an independent contractor without being a full-time employee. We went on strike to try to benefit the employees. And we were out of work for 3 months. And I can remember even being at Dodge Stadium, marching a picket line for the umpires back in the 90s. What happened was they got good health insurance after the strike. They came together. But I can tell you, being out of work for 3 months and not having any income, I can't imagine what collecting unemployment would have done for me and my young family at that point. It would have been fantastic. And I am in strong support of this bill 938. And I just want to say, it's been said before, New York and New Jersey already allow striking workers to collect unemployment benefits. New York reduced its waiting period for 7 weeks to 2 weeks in 2020. New Jersey has a 30-day waiting period, but is considering legislation to reduce the 2 weeks in order to mirror the New York law. And I got to say, this bill follows the example that's set by our neighboring states. We urge the committee to support this bill. And thank you for your time, and I will answer any questions that you have.
Thank you. Any questions? Senator Kushner.
I just have to say hi. It's good to see you.
It's great to see you too. Thank you so much for the work you're doing.
Well, I have to tell folks in the room that I negotiated at Foxwoods for a number of years and organized the workers there back at the earlier part of the century. And I know you guys are just terrific in terms of what you add to our economy and what you add to our community. So thanks. It's good to see you.
Thank you so much, Julie. Thank you.
Thank you for your testimony. The next person we have signed up to speak is James Case. Floor is yours, sir.
Thank you. Senator Kushner, Representative Sanchez, Senator Sampson, Representative Acker, and distinguished members of the Labor and Public Employees Committee. My name is Jim Case. I'm a proud member of CWA Local 1298, which represents about 2,000 workers in the state of Connecticut. Thank you for the opportunity to testify in support of SB 938 regarding unemployment for striking workers. Unionized workplaces have been proven to raise standards for all workers thanks to a collective bargaining process that allows them to negotiate fair wages, benefits, and working conditions. But that process is undermined when the balance of power shifts unfairly to the employer. That is exactly what's going on in our state because current law presumes that striking workers have left their jobs voluntarily and are therefore ineligible to receive unemployment benefits. In my 27 years on the job, I've been on strike twice, and my father struck twice before me. I can tell you from experience that no worker takes the decision to go on strike lightly. There is no casual striking. Given the risk to their livelihoods through loss of income and potential loss of their job, workers go on strike only when they have exhausted every avenue of the collective bargaining process. It is a last resort. But an employer who doesn't have to pay unemployment benefits has far less incentive to bargain in good faith, knowing that their workers' precarious situation could break the strike and bring them back to the bargaining table demoralized and financially diminished, or remove the option to strike in the first place. SB 938 is not designed to enrich workers. It's designed to help avoid labor disputes by creating the conditions for good faith bargaining. Our brothers and sisters in New York and New Jersey already have access to unemployment benefits when they go on strike. In New York, the waiting time was reduced from 7 weeks to 2 weeks in 2020. In 2021, when thousands of CWA healthcare workers in Buffalo were on strike for 40 days, unemployment insurance was a difference maker that allowed them to continue feeding their families while fighting for better patient care. In the end, these courageous workers won their strike and settled with a contract providing some of the strongest patient staffing language in the country, which we all know is directly related to better patient outcomes and healthier communities. In New Jersey, there was a 30-day waiting period, but they are currently considering legislation to reduce it to 2 weeks, as it is in New York. This is a proven policy with successful precedents of protecting workers and ensuring that they are able to fully exercise their right to fight for better working conditions and wages. Connecticut should remain competitive with our neighbors and follow these examples so that our workers aren't unfairly intimidated or financially imperiled by labor disputes and are able to fully exercise their rights. Thank you for your time and consideration. I urge the committee to support this bill, and I'd be glad to provide any answers if you guys have any questions.
Any questions, Representative Hughes?
Oh, thank you very much. And thank you, Mr. Chair, for your indulgence. I'm curious about the other states that have instituted 2 weeks or whatever that time period is, what impact that has had on these massive corporations, especially, multinational ones, in terms of coming to the bargaining table sooner.
I mean, I can only speak from our union's perspective, but I know in New York, when the nurses in Buffalo struck, had they not had the ability to get unemployment after 2 weeks, it would have been much more difficult for them to maintain the position of getting themselves a better contract. I mean, this is all about the workers, right? I don't know how it impacted. I don't know what hospital they worked for or how big a corporation that it was. If it was small or large, but I know it did impact the strike. And from my perspective, I believe the strike was shorter because the employer they had the impetus to bargain in good faith.
Thank you for that. And I just wanted, through you, Mr. Chair, just to raise that the landscape is changing, that we're trying to normalize just worker protections, normalize that instead of a landscape where companies have traditionally exploited nurses or other workers to have not adequate healthcare, not adequate retirement, and not adequate sick pay, that we're trying to normalize that is what we are simply demanding is a threshold of a floor. And it is sad that we have to go on strike to demand what should be a given for every worker today.
It's inexplicable. Actually, I'll give you an anecdote if it's okay. So my father was also a phone guy prior to me. I remember he went on strike for, I was younger, so I don't know how long. And I remember that I was supposed to get braces around that time, and that my braces were delayed because of us going on strike for whatever amount of time. As you can see from my sparkling crossbite, that the braces weren't great, but so it didn't impact my dating.
Thank you for that antidote. I'll remember that.
Senator Kushner.
I'm particularly interested in your comments about that the period of time that you wait until you get unemployment does create leverage or pressure on the employer to settle. And I know that's certainly my experience when I represented workers in and led workers on picket lines in New York State back in the day, which was quite a while ago when it was, you had the 7-week waiting period. But what that meant was it often, the strike would settle right before the unemployment kicked in. And so there's no question that was a factor. And I think that beyond just, what I think we've heard testimony about today about the importance of the benefit protections, the wage protections that people are fighting for, there is an impact on the community as well. And the Labor Relations Act was first enacted to really regularize and regulate interstate commerce and make sure that we as a country had an economy that worked. And I think that we've seen in New York State, it's a very productive state. Lots of people work and a lot of people make a lot of money in that state. And so I think the fact that they could do it and that it can be done in New Jersey really does, it creates a pathway for us to make sure that Connecticut is treating our workers just as fairly as the workers are treated in those other 2 states. So appreciate your testimony and
Thank you.
bringing us back to New York and New Jersey. Thanks so much.
Sure. Thank you. I don't believe we have any further questions, so thank you for your testimony.
Thank you.
Next up, we have Caitlin Car. I don't believe he's here yet.
Is Senator Looney in the room yet? Coming in, no, I
Yeah,
haven't heard, so, okay.
I'm on the lookout.
Thank you.
It's okay.
I have to be
Yeah,
respectful of my schedule.
absolutely. Next up, we have Caitlin Clarkson Pereira.
That would be helpful. Good afternoon, co-chairs Sanchez and Kushner, and all distinguished members of the Labor Committee. My name is Caitlin Clarkson Pereira, and I'm here to speak in support of Senate Bill 937, an act providing workers' compensation benefits for certain cancers in firefighters. A few years ago, I decided to follow my childhood dream and become a career firefighter. I'm sure it's not shocking to know there were some moments of surprise during my first few shifts at work, but there was one thing in particular I was shocked to see. Signs like these. Every day, we see signs like these when we arrive at work for our 24-hour shifts, hanging in our kitchens, bathrooms, offices, informing us of how to wash our hands, do our laundry, how to prevent bringing carcinogens into our living spaces, our personal vehicles, and back home to our loved ones. Imagine working in a space for 24 hours at a time, sometimes longer, where cancer is so typical and so common that you accept the placement of such signs as this, especially in a place you call a fire house, a place you sleep. So why do we have these signs? Because I have a 600% higher chance of getting breast cancer than my female counterparts who are not firefighters. The men on my crew and who are on jobs in other parts of the state have a 700% more likely to get testicular cancer and 3 times more likely to die of such a cancer. And that is only 2 examples. Other states have had presumptive cancer legislation for decades. California passed it before I was even born, and I'm 37. None of these states with presumptive cancer legislation for firefighters have declared fiscal exigency yet, or there haven't been mass exodus of residents due to property tax increases. So why can't we make this happen here in our state too? A past president of CCM said at the initial attempt of passing the bill back in 2015 that the bill was based on shaky science. Quote, "It's not good public policy for federal, state, or local people to pass legislation that has no scientific or medical evidence," end quote. But as we sit here today, there is a preponderance of scientific and medical evidence backing up the fact that firefighting causes cancer. So much so that the IRAC, a branch of the World Health Organization, classified firefighting as a group 1 carcinogen last summer. We've heard some other folks talk about that. That means it is just as dangerous. Firefighting, the profession is firefighting, is just as dangerous as benzene and tobacco. In 2015, CCM's executive director, Joe DeLong, also said this, quote, "We will come forward with a solution that we can support in a future legislative session if you give us the time to work on it. Meet with the firefighters, look at the science, find out how it's worked in other states and what hasn't worked, and try to put forward a sustainable solution. Right now, it seems to be there's more willingness to spend our way to prosperity. And I think all of us collectively believe that's a disaster. Mr. DeLong, it's been 8 years. We've had the time, we've looked at the science, we've looked at other states, and unfortunately, we still do not have a sustainable solution. While the wage replacement bill last year made some improvements, it's not nearly enough. It does not provide coverage for disability or the death of a firefighter. And it is to my understanding that not a single dollar has actually been paid to firefighter, career or volunteer from the Cancer Relief Fund yet. We need this covered under workers' compensation. And I should add, there is nothing prosperous about watching your brothers and sisters get sick and die from occupational cancer. I think all of us can collectively agree that the real disaster is we are still without this here in Connecticut. Plus, we see the shortage of firefighters both here and nationwide so clearly that even CCM listed recruiting and retention of firefighters as a legislative priority this session. Lack of cancer coverage and being without enough firefighters is not a coincidence. Let's work together on this and find solutions for both of these issues. The letters that you'll see submitted in opposition to this bill are done so almost exclusively with company headers, not individual names. The same was the case for Senate Bill 313 last year. These letterheads belong to lobby groups and insurance companies. Yet as firefighters, we take our jobs so seriously and the commitments that we made to the public with such pride that we wear our names on our turnout coats in reflective, bold block letters. There are no headers there, just our names representing the livelihoods and the lives of us as individuals. We swore an oath to protect perfect strangers and their families and their property and even their pets. Now we are asking you to ensure we are protected when our years of protecting others finally catches up with us. Thank you.
Thank you, Senator Kushner.
Thank you so much for your testimony. It was right on point and very clear, and I think causes us to feel pretty emotional that we've let down our firefighters. We recognized you all as heroes during COVID for taking risking your own life and the lives of your families by going out there and helping us when there are emergencies during that critical time. I think that may account for why today we hear from our colleagues a lot more, really vocal support for making this change in law and protecting our firefighters with workers' compensation. And so, I really appreciate everything you've done. Every point you made today is well taken. And, hopefully this is the year that we'll get it done. 8 years is too long. Thank you.
Thank you, Senator.
Representative Hughes.
Thank you, Mr. Chair, and thank you for your testimony on behalf of a multi-generational profession. Can you tell us more about why the bill we passed last year didn't go far enough?
Absolutely. So last year's bill is wage replacement. That is covered by that fund that the first selectman of Old Saybrook was speaking about, the $10 per firefighter. And especially for those of us who are career firefighters, wage replacement doesn't necessarily do anything for us, right? We have sick time, we have vacation time, we have personal time, we have sick banks sometimes to tap into from the towns that we're a part of. So we're not losing wages while we're out getting treatment. But what it does not cover is if we are disabled and unable to come back to the job, or even worse, if we die from our occupational cancer. And we use a lot of levity in the fire service. And something I hear people say relatively casually is if I end up getting cancer on this job, I should just climb a ladder and fall off. Because if I break my back or my neck and I'm considered disabled because of that physical disability, then I'll be covered. But if I end up with bladder cancer, I won't be covered.
Thank you for that. And so that is why this presumptive language is so critically important. The other thing that you said that really struck me was that 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 there is such a big anonymity in opposition to this, whereas you're individually and collectively putting your lives and your names on the line to demand this minimum protection, which, by the way, it doesn't protect you from getting cancer, right?
Absolutely.
So clearly we need to do more to protect workers who are giving their life to this career. Can you say something about the stringent physical standards therefore to be a firefighter, and if you were diminished in having some kind of cancer, so forth, how that would impede your ability to function in this job?
Absolutely. The job is extremely physically demanding, and I can't imagine trying to do this job with a bad cold, right? Let alone going for radiation or chemo treatments. We often hear about firefighters doing that on a Monday and coming back to work on the line on a Wednesday. So I would argue it's not only not in their best interest, but if they're not going to be as effective on the fire ground because their bodies are going through hell and back, then that's not fair to the citizens either.
Thank you.
Thank you. Senator Kushner.
One last question. You talked about the limitations on the firefighter fund that we have now, the Cancer Relief Fund, and some of the benefits that would be covered under workers' comp. Can you also address, I think we've heard testimony in the past from family members who lost a spouse to cancer, who was a firefighter. And I believe what I remember is that not only there was no coverage, healthcare coverage that would have continued in a workers' comp, it did not exist in this fund for the children or for the family. There was no ongoing resources brought to that family. That's something that I think you probably know about, and which I'd like you to highlight because it really concerns me.
Absolutely. So right now, these are not considered line of duty deaths. So anything that would come from a line of duty death, for example, in the town I'm from, if I were to die on the job, let's say in a building collapse, one example of something that would be taken care of per our contract is my funeral. But if I'm out, let's say for 8, 9, 10 months going through treatment for breast cancer, and then I don't survive that battle, no one's paying for my funeral. And that's just one example of what we tell firefighters time and time again. We appreciate what you do and the risks that you take and what you put your families through to be able to provide for the citizens of our towns, that if something bad happens to us, that you will take care of our families. You don't take an oath to save people you've never met before and not care immensely about the people that you are desperate to come home to in your house after every shift. That's what matters most to us.
Thank you so much for your testimony here today.
Thank you, Senator.
Further questions? Thank you so much for your testimony.
Thank you, Representative.
Next up, we have Mark Natty.
Okay. Good morning, Senator Kushner, Representative Sanchez, and members of the Labor and Public Employees Committee. My name is Mark Natty, and I have worked at Pratt Whitney since 1985. I'm a proud member of the International Association of Machinists and Aerospace Workers. Since I began my career, I've been through 12 collective bargain negotiations and have been on strike twice, once in 1985 and again in 2001. Once the union as a whole decides to strike, you really do not have a choice but to honor that picket line. For those who have crossed the picket line, their careers were never the same. They are never looked well upon by their coworkers, or for that matter, the company. After they cross their line, their careers are never the same, and they're so despised by their coworkers. It's terrible. And no one's going to cross the picket line, or very few ever do. But now how do we get to that point where we feel we have no choice but to go on strike? It comes from the company not treating us fairly in negotiations. They do not listen to our concerns. They really do not engage us in true negotiations. It is this is what it is, take it or leave it attitude from the company. There is no good faith bargaining going on. The company feels they have all the leverage. They know most of the workers live paycheck to paycheck and cannot afford to strike, and they use that. A strike puts great financial hardship on the striking workers. That is why it is so hard to get 66% of the workforce to vote to strike. But when the company fails so badly to bargain in good faith, workers still find the courage to strike. We've done it twice at Pratt & Whitney since I've been there. What will Senate Bill 938 do? I believe it will force companies to bargain in better / good faith. They will not have as much power over the worker as they do now. Workers will not be in jeopardy of losing their homes or having to take money out of their 401k retirements to save them if they vote to strike. They'll let workers decide if their employer, who is making millions, or in my company's case, billions of dollars, what the employee's fair share is. We're the ones making the products, providing the services. We deserve a fair share of the profits. This bill, Senate Bill 938, will help level that playing field. Companies will still have the advantage, and a strike will still be very costly to workers. But they will not lose everything they've worked for or put their career at risk by crossing a picket line. Workers in this great state deserve this protection that only helps the state as a whole, puts more money back into the state's economy. I urge the committee support this bill, and thank you for the opportunity to testify here. Respectfully, Mark Natty.
Thank you, sir. Any questions? Thank you for your testimony. Next up, please forgive me if I do not pronounce this last name correctly. Olivia Rinkus.
She's supposed to be remote. Check in.
Nope. Okay. Next up, Elizabeth Frazier. Floor is yours.
Thank you very much. Good afternoon, Senator Kushner, Representative Sanchez, and esteemed members of this committee. My name is Liz Fraser, and I'm the Policy Director for the Connecticut Association for Human Services, where we advance multi-generational policy and program solutions, promoting family economic well-being and fostering equitably resourced communities. And I'm here today in support of proposed Bill 5858, which would establish a state-administered flexible spending account to be used to pay for the costs of childcare. Providing flexible savings accounts to help pay for early care and education programs could not come at a better time. The cost of childcare for many families is more than the cost of housing. Yet childcare is a necessary expense for parents to work, to purchase a home, and to earn enough money to support their families. Passage of this legislation will do several things. First, flexible spending accounts will help defray the high cost of early care and education for parents with young children. The federal government indicates that a reasonable amount for a family to spend on childcare is 7% of household income. Yet a recent parent survey conducted by the Office of Early Childhood and the University of Connecticut indicates that less than 20% of families with young children fall into this category. In Connecticut, using the federal affordability standard, A family would need an income of about $190,000 to afford tuition, which would be about $13,000 for one preschool age child. And infant toddler care is even more expensive. The other thing that this will do is give many more families the additional buying power associated with flexible spending accounts. According to the Bureau of Labor Statistics, just 43% of employees across the country have reported having access to dependent care FSAs. And unless your particular employer has one in place, you can't participate. Instituting a state-run program will increase access to this benefit. Many who work for small businesses in the gig economy or are entrepreneurs, these individuals will have the same opportunity as those working for larger companies to use pre-tax dollars to pay for the cost of childcare. A $5,000 deposit by a family with a 20% federal tax rate and a state tax rate of 4.5% will reduce their yearly federal tax by $1,000 and their state tax bill by $225, giving the family $1,225 more in buying power, which they can put towards that early care and education. Cause program work, my company's program work, includes providing financial coaching and facilitating the VITA Income Tax Assistance Program throughout the state. Our financial coaches and VITA volunteers see clients every day. When the cost of medical care or dependent care, such as childcare, is a known and planned expense, flexible spending accounts have been extremely beneficial to the families, making more of the family's earned income available to cover these expenses. In closing, as many members of this committee might know, the childcare industry is in crisis. Parents can't afford the cost of care, providers can't afford the cost of doing business, and teachers are leaving the field for higher paying opportunities, and it's a lot to fix. But instituting a flexible spending account to defray some of the cost of care for families is one step in the right direction. Thank you very much.
Thank you. Questions, Senator Kushner.
Thank you for your testimony. And
You're welcome.
I remember when the federal government passed the tax changes to allow for flexible spending accounts, and, you know, familiar with setting them up. And sometimes they are a little complicated for an employer, especially a small employer, to set up if they haven't got the resources of a large corporation. I'm curious if we had testimony earlier this year about the retirement security plan that the state of Connecticut now offers through the Comptroller's Office. And to me, this seems very similar, that it is designed to offer a vehicle for employees to save money. In this case, they would be saving tax dollars because these are pre-tax dollars that they would then pay for their childcare. I'm just curious if you've had any conversations with the folks at the Comptroller's Office, because it seems like a very similar program. Of course, I see the bill is the proposed bill has this established under the Labor Commissioner, which, you know, we have a great DOL department too, but I'm just curious if you've given any thought to looking toward a similar mechanism that's already in existence at the Comptroller's Office.
Yes, I think that where they do this work already, they know how to implement these things. And if it's one portal for families and or providers to use, I think it's a better option. We actually had the Comptroller's Office come and speak on our early childhood Monday Zooms that have over 200 people on any given Monday morning, 200 providers. And it was met, having a retirement account was met with a lot of positive feedback. So yes, I think that would be a really good option. They're very well prepared. This is just my observation. They were, you know, really ready to have this program and to make sure it was available and easily accessible for programs. I don't believe it's fully in place yet for early childhood. They were doing larger businesses first and working down. So I'm not sure of the results yet, but that is a good thing for me to look into in the future months and see how it's working. But I think that folks, as long as it is an organization that is running it, that has the capacity to do this and the knowledge on how to run a program effectively, and easily for families, I think that would be great.
Thank you. Just, to be clear, I believe that the retirement plan is, that's now run by the state, is offered to certain small employers, but when you get to the level of 5 employees or less, then it doesn't become available to them, which I think unfortunately would exclude some home care providers that are
Yes.
currently, doing such essential work. So hopefully someday we will see a change in that so that everyone can participate. But in terms of setting up a flexible spending account, again, I think because the state comptroller's office already has experience with these kinds of setting up these kinds of systems, I think it might be worth a conversation. Hope the proponents of the bill, maybe all of us can look into that, because that might be a better home for a program like this. So just a thought.
I absolutely agree with you. I think that that's a great idea. I was not, I didn't know about this bill. I saw it, and we do this work with family coaching, financial coaching at Cause and VITA, and we know how important this is to families. And from my work in early education, I know the cost of early education is really keeping some families from going back into the workforce, some moms especially. So we really need to start looking into how we're going to fix the whole system. And this is one step in the right direction. So I thought it was a great opportunity to testify.
Well, I'm so glad you did testify, because I was hoping somebody would come and testify on this bill so I could ask that question.
I think there's a few more people.
Great. Thank you so much.
You're welcome.
Thank you for your testimony. Next up, we have Jody Barr. Take your time.
You need to turn on the mic.
I screwed that up anyway, so I'm glad it wasn't on. Good afternoon, Senator Kushner, Representative Sanchez, Ranking Board members, and members of the Labor Committee. My name is Jody Barr, and I'm the Executive Director of AFSCME Council 4, which represents 30,000 public and private sector workers, including those dedicated workers at the Department of Labor. While I'm here speaking on behalf of AFSCME Council 4, I can also tell you that I speak in this case with the support of CBAC Coalition as well. I'm speaking on behalf of 2 bills, SB 938, an act concerning unemployments for striking working members, and Act 5854, an act concerning the number of wage and hour inspectors of the Department of Labor. Having been here most of the day and watched the testimony around the unemployment benefits for striking workers, I don't think I need to recap anything else that's been added in that area already, except to say that it's common sense. We do support it, and it's actually good for both sides. I am also here, though, to testify on the number of wage and hour inspectors for the Department of Labor. Most state employees and municipal employee jobs are understaffed at this time. We urge the governor and the legislature to fully staff all of these public employee positions. The Department of Labor wage and hour inspectors are vastly understaffed. These inspectors work to protect workers from having their wages stolen from them. Wage theft is endemic these days. Our members at the Department of Labor do important work for the state of Connecticut, despite being understaffed. This bill would help that by requiring a minimum of 45 wage and hour inspectors at the Department of Labor. Wage and hour inspectors provide an important service that ensures that businesses are on a level playing field. These workers investigate complaints when businesses are exploiting workers and levy fines so that businesses who do the wrong thing are held accountable. By having more wage and hour inspectors, it would allow DOL to better investigate complaints that were made by workers. I urge the committee to support both of these bills. Thank you.
Thank you, Representative Hughes.
Thank you for your testimony. I'm so glad you used the word wage theft. Can you tell me how, in your experience, you think endemic this is, and what appropriate staffing will do to change that, change that equation for Connecticut's workers? And what would that as appropriate staffing look like?
So, but by putting it at 40, I believe that would double it from where it is now. And I can give you an example, and there was testimony earlier that related to it, but I actually saw it firsthand. The inspectors now are 20, 25 cases deep. So when you
Okay.
put and these are not just like walk in and like, oh, they gave you $1 and they were supposed to give you $1.50. There's investigations that go behind it. There's documents, there's a long process. So when a wage inspector is 25 cases behind, it's months before they get to that case. So the impacted people by that are waiting months to have it rectified.
And through you, Mr. Chair, does that mean that employers are just counting on the lack of, enforcement and lack of responsiveness to kind of continue to normalize that practice?
Yeah, so let's be clear. I think most employers would like to do the right thing.
Of course.
But there's just some of them that are not. And it's the ones that are doing the right thing that are being, it's an unfair competitive advantage for those that are providing the same services, but yet paying their members less or doing wage theft to them. So they're able to bid on jobs that are different. They're
Oh.
able to do things that a good abiding company is not able to do. And that's where the DOL inspectors come in and help level that field. It's not just about, going after companies. It's about going after the ones that are not doing the right thing, which helps everyone in the end.
Yeah, thank you for really level setting what that does to the entire work, employer-employee workforce landscape, because again, once there's enforcement, then it really sends a signal to the the offending employers to shape up or this'll they'll be penalized.
Yeah, and I think the record shows that last year it was over $3.3 million that members were ripped off. So I mean, think of how many people that really is and how much just $10,000 would mean to an average family. So it's very important.
And just one last question. Do you have any idea of whether these were low wage or, in terms of wage theft, what workforce income did that impact the most?
I would suspect that people working at large corporations are a little more refined and not doing this. It's typically low wage workers.
Thank you.
Thank you, Representative. Any further questions, comments? Seeing none, thank you for your testimony.
Thank you.
Next up, we have to speak is John Brady. Floor is yours.
Good afternoon, Representative Sanchez, Senator Kushner, Ranking Member Sampson, and Eckert. My name is John Brady. I'm a registered nurse and the Vice President of AFT Connecticut. I come here today in support of SB 938, an act concerning unemployment benefits for striking workers. The decision to go on strike is never an easy one for the workers. It usually comes after months or even years of intense negotiations and buildup. AFT Connecticut healthcare locals have gone on strike 3 times in my memory. In 2013, the nurses and technicians at L&M Hospital struck for 3 days. In 2020, the nurses at Bacchus Hospital made that difficult decision and went on strike for 2 days. And this year, the nurses, techs, and service employees at Wyndham Hospital struck for 2 days. All these strikes came after months and months of negotiations and after months of planning and hoping not to strike. Our members were fighting for adequate staffing, for a lack of PPE or personal protective equipment during COVID, and for safe working conditions. Strikes have always been an important in America to achieve the well-being of American workers and the people those workers care for, educate, or otherwise support. That's why the National Labor Relations Act recognizes the right of private sector workers to strike. As the 3 examples of AFT Connecticut healthcare strikes show, they promote the well-being of patients also. But the employer-employee relationship is inherently unequal. The employer controls the livelihood of the employee, making standing up for principles very difficult, even when it is for the well-being of patients. That inherent unequalness has been multiplied in recent years as hospitals consolidate under fewer and fewer patient healthcare systems. Now more than ever, we must work to level that playing field as best we can. Providing unemployment benefits to striking workers is the beginning of leveling that playing field. It will lead to more collaborative discussions at the bargaining table and, I believe, result in fewer strikes. More importantly, it helps recruitment and retentions of nurses and other health professionals, and it improves the likelihood of safe patient care. The most important thing I learned in nursing school, and what every nurse learns in nursing school, is that advocating for our patients is our primary function. SB 938 will help us do that, and I urge your support, and I thank you for listening to my testimony.
Thank you. Any questions, Representative Hughes?
Thank you so much for your testimony. How do you think this could really leverage the crisis of safe patient ratio for the nurses?
I think it increases the chance and the likelihood that nurses will be able to stand up and advocate. Right now, the threat of a loss of income, threat of loss of insurance is dangled before nurses and other healthcare professionals, both when there's a contract campaign going on or when there's an organizing campaign going on. And that threat is dangled out there like you realize what could happen if you went on strike. And I think that most of our strike, none of our strikes have lasted 2 weeks. But, you know, as the gentleman said, the Buffalo strike, that led to an improvement of patient care in Buffalo, and taking that threat away from a bad employer, I think is a good thing for patient care.
Thank you. And through you, Mr. Chair, is there any difference do you see in that landscape between the consolidated healthcare systems and the small independent ones?
Yeah, there is, Representative, I think, because the consolidated systems have more power, more control, but they also have the threat of if you don't like it here, you can't go to one of our sister hospitals, where that was at one time when they were all independent hospitals, they could. So they control, in the case of Yale or Hartford, they control, you know, half of the systems across half of the hospitals across the country. So standing up for your rights in one healthcare system can make a difference, not just in that one hospital, but across that system.
Thank you.
Thank you, Representative. I don't see any other questions, so thank you so much for your testimony, sir.
Thank you.
Next, we have Carla Esquivel. And for translation purposes,
Hi, how are you?
I'm good. How are you?
Fine, thank you.
Good.
Estimados presidentes y miembros del comité, mi nombre es Carla Esquivel, vivo en Stanford desde hace 15 años, tengo 2 niñas y soy líder de Nosotras, una organización que lucha por los derechos de los trabajadores inmigrantes en Stanford.
Good afternoon, co-chairs and distinguished committee members. My name is Carla Esquivel. I have lived in Stanford for 15 years. I have 2 daughters, and I'm a leader of Nosotras, an organization that fights for the rights of immigrant workers in Stanford.
Mi testimonio es a favor del proyecto de ley HB 5854 para hacer valer los derechos humanos de las y los trabajadores que han sufrido en carne propia la explotación laboral.
My testimony is in support of HB 5854 to assert the human rights of workers who have experienced labor exploitation firsthand.
Mi infancia fue terrible porque mi mamá se quedó viuda cuando yo tenía 15 años. Entonces era una mujer que siempre luchó por nosotras.
My childhood was terrible because my mom became a widow when I was 15 years old, and my mom became a woman who fought for us.
En Guatemala nunca carecimos de comida o un techo, pero de alguna forma siempre había limitaciones. Y no era que mi mamá no trabajaba, porque siempre lo hizo.
In Guatemala, we never lacked for food or a roof over our heads, but somehow there were always limitations. And it wasn't because my mother did not work, because she always worked.
Mi mamá trabajaba limpiando casas, siempre trabajaba para familias norteamericanas que eran managers para compañías farmacéuticas como Pfizer, Bayer en Guatemala.
My mother worked cleaning houses. She always worked for U.S. families who were corporate managers for pharmaceutical companies in Guatemala, such as Pfizer Corporation.
Una de estas familias me trajo a los Estados Unidos para trabajar cuidando a una niña.
One of those families brought me to the United States to work as a nanny.
Yo tenía 17 años.
I was just 17 years old.
No conocía a nadie en los Estados Unidos. Siempre había explotación laboral. Ni a $2 la hora me pagaban. Trabajaba 6 de la mañana a 10 de la noche.
I didn't know anyone in the United States. I was just 17 years old. There was always labor exploitation. They didn't even pay me $2 per hour. I worked from 6 in the morning until 10 o'clock at night.
Ahora yo me dedico a educar a las trabajadoras inmigrantes sobre sus derechos.
Now I am dedicating myself to educating immigrant workers about their rights.
Las niñeras, las trabajadoras de limpieza y las cuidadoras de Connecticut nos encargamos del trabajo que hace que todos los demás trabajos sean posibles. Mantenemos los hogares seguros y limpios. Ayudamos a criar, a educar a la próxima generación y apoyamos a las personas mayores y a las personas con discapacidades para vivir con dignidad.
Connecticut nannies, cleaners, and caregivers do the work that makes all other work possible. We keep homes safe and clean. We help to raise the next generation of children, and we support seniors and people with disabilities to live with dignity.
Es urgente que el Departamento de Labor de Connecticut tenga más investigadores de robo de salarios para educar a los trabajadores, educar a los empleadores y trabajar juntos para garantizar que ganemos los salarios que merecemos.
There's an urgent need for the Connecticut Department of Labor to have more wage theft investigators so they can educate workers, educate employers, and work together to ensure that we earn the wages we deserve.
Quisiera cambiar las leyes para asegurarme que mi historia no se repita. Somos miles y miles en este estado que experimentan la esclavitud moderna. Todos merecemos trabajar, vivir con seguridad y dignidad, y esta legislación garantiza que nadie se quede fuera.
I would like to change the laws to make sure my history does not repeat itself. We are thousands of thousands in this experiencing modern day slavery. We all deserve to work and live in safety and dignity, and this legislation ensures that no one will be left behind.
Que hagamos conciencia y contengamos nuestra historia para que sea escuchada. Somos personas esenciales y debemos tener dignidad.
Let's raise awareness and tell our stories. We are essential people and we must have equality.
Gracias.
Thank you.
Thank you. Any questions? Representative Hughes.
Thank you so much, Carla, for your testimony. I would like you to speak to us about how pervasive that type of exploitation that you described, and also harassment. That's another thing that the Department of Labor can enforce in your experience and among your colleagues.
Muchas gracias, Carla, por compartir su historia. Mi pregunta es, ¿qué tan común es este problema del robo de salario y también podría usted hablar sobre qué tan común es el acoso en el trabajo.
Pienso que es más común de lo que imaginamos. Suele pasar casi siempre. En los 15 años que llevo acá, lo he experimentado en más de 4 ocasiones el robo salarial y también hay acoso con nuestras trabajadoras, pero tienen miedo a reportarlo.
It's more common than you might imagine. In 15 years, I experienced wage theft 4 times. Harassment is also very common against women workers, and they're afraid to speak out.
Thank you. And just one final question. Have you had any experience with the Department of Labor wage and hour inspectors coming into a situation or among, folks that you work alongside and enforcing the law?
Gracias. Y otra pregunta. ¿Alguna vez los investigadores del Departamento de Labor llegaron a tu lugar de trabajo y te ayudaron? ¿O lo has visto?
No, siempre tuve miedo antes de reportarlo. Siempre nos amenazan, pero por eso estoy acá representando a nosotras, a las trabajadoras, para que no tengan miedo como el que yo he tenido a hacerlo hasta este momento.
Well, no, when it happened to me, I was always afraid to report it to the DOL because the employer threatens us. But that's why I'm here today, because I want to encourage workers to speak out.
Thank you for your courage. Thank you, Mr. Chair.
Thank you, Representative. With no further questions, thank you for your testimony. Next, we have Jess Corbett.
Can everyone hear me?
Yes.
Great, thank you. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Eckert, and the distinguished members of the Labor and Public Employees Committee. My name is Jess Corbett. I live in New Haven. For the last 22 years, I've been employed at Yale University and a leader of Unite Here Local 34, the union that represents 3,500 clerical and technical workers at Yale. I want to thank you for the opportunity to testify in support of SB 938. Deciding to go on strike was one of the scariest things I've done. Back then, I was young and single. I didn't have the same responsibilities a lot of my coworkers had. Lots of moms, some of them raising young children on their own. I can't imagine how scared they were. It must have taken a lot to make them risk so much to go out on strike. And it did take a lot. In 2003, we were working without a contract for over 2 years. So I and a majority of my fellow members voted to authorize the leaders of our union to call for a strike if Yale didn't negotiate in good faith. Yale still didn't negotiate. After going out for a week in March, we went out on a strike in August and didn't know when we'd be back or if we'd be back. We went on strike to improve our lives. We needed better work rules, job security, opportunity for advancement, and the ability to retire with dignity, and very importantly, better wages. We needed a better standard to buy groceries, pay bills, keep roof over our heads, and support our families. The union was a great support. People could bring their bills down to the office for financial help. We would call banks and lenders ask for leniency or mortgages while on the picket line. Set up a food bank for members to bring groceries home to feed their families. But it was difficult and scary. We won a great contract. We doubled our pensions. My mom was able to retire from Yale last year. Our members, my mom including, were able to quit their second jobs and spend more time at home with their loved ones. In subsequent contracts, we helped turn what were once low-paying jobs at Yale into some of the best jobs in the region. We won local hiring that are going to help stabilize New Haven communities. Actually partnering with Yale on many initiatives inside and outside the workplace. I definitely wouldn't have predicted that all those years ago on the picket line. It was one of the scariest, but also one of the best decisions I ever made. If there's a law like this in the books back then, it would have saved a lot of sleepless nights and stress on families and individuals. It would have made it easier to make the right decision that has had so many ripple effects over the last 20 years on generations of Yale employees and New Haven residents. It might also change how employers negotiate in the future and bring them to the bargaining table sooner to work together. Thank you for the opportunity to testify. I'm happy to answer any questions you might have.
Thank you. Any questions? Seeing none, thank you for your testimony today. Next up, we have Diane Lauricella.
Yes, hello, can you hear me?
We can.
Great, thank you. I'll turn up my volume. For the record, my name is Diane Lauricella. I live in Norwalk, Connecticut, and have been there for 37 years. Today, I wanted to thank both Chairs Kushner and Sanchez, the vice chairs, ranking members, and esteemed members of this committee. Very interesting and compelling testimonies that I've listened to. Today, I am here to discuss briefly and in support of SB 937, providing worker compensation for benefits for certain cancers in firefighters. Just in a very brief background, many years ago in the 1980s, I worked for the Department of Environmental Protection before they picked up that extra E for energy. And I was in the Hazardous Waste and Materials Division. We had noticed as employees that we did not have any of the respiratory protection and we were all of childbearing age. Long story short is because I was in the union of the state employees, I was the founding first chair of our I think it was P4 Health and Safety Committee. I don't even know if it's still operable. My point of telling you this is also later I became the OSHA, or the Health and Safety Officer, of 2 private consulting firms that were housed in Connecticut. And the reason I'm speaking today is my read. I'm in full support, and I do agree with everyone that spoke about this bill, this Senate bill, especially the female firefighter who gave very detailed and compelling testimony, in my opinion. The thing is, I looked at the bill and I just have some thoughts. On line 40, number 6, this is a list of things where a firefighter would not be able to get workers' compensation. And I'm quite concerned about the wording because, as we know, the devil's in the details. First of all, let's just admit science is always changing on what causes cancer, what works with other chemicals and other incidents to cause cancer. But line 40, number 6, it says that firefighter would not be eligible if they fail to use respiratory protection. And then they list the OSHA the Code of Federal Regulations, point 134. I'm very familiar with that in my former life professionally. Because I compare that to what happened with the pile after 9/11. And one is assuming that the line managers who should and are supposed to set the level of protection of any fire, any rescue, it doesn't always happen that way, right? Because we had people running to the pile to try to rescue without proper respiratory protection. And now we have lots of cancers over 20 years later. Also, line 50, section C, it says that firefighter would not be able to be eligible for workers' comp if they were no longer employed and applied for benefits. Now, maybe I'm reading this wrong, but it says if they don't apply not later than 5 years after date of such individual was employed or last served as a firefighter. I think that needs to be either struck or changed, because we all know that many of the
excuse me, ma'am, your
Yes.
your 3-minute marker is just about up.
Okay, I will wrap up right here. Good point to wrap up. Thank you. We all know that the chemicals encountered by firefighters, many take much more than 5 years to show themselves. So please ask for modification of this terrific bill, but some of the devil in the details is counterintuitive to what I think the bill is trying to achieve. Thank you for your time.
Thank you. Any questions? Seeing none, thank you for your testimony. I do see Senator Looney here. I'm just going back into our order of folks who were not here present at the time. The floor is yours.
Thank you very much, Mr. Chairman. And good afternoon.
Mr. Chairman, Representative Ackert, other members of the Labor and Public Employees Committee. I'm Martin Looney, State Senator from the 11th District, representing the city of New Haven and the town of Hamden, and would like to express my support for Senate Bill 938, an act concerning unemployment benefits for striking workers. And this is a matter, I think, of equity, because I believe that workers who are exercising their right to strike should not be required to suffer economic catastrophe if the strike goes on for a significant period of time. I think that's an unreasonable price to ask them to pay, and really is coercive against people who are exercising a right and making it so punitive for them under current law to exercise that right, so that they may in some cases decline to do so. And the pandemic and the subsequent tight labor market has begun to allow workers to assert their workplace rights. And it is important, I think, to recognize that workers in a bargaining unit can strike only by a majority vote. Generally happens after failed negotiations. Strikes do not happen lightly. They happen only after there has been an impasse with many efforts to resolve it short of a strike. It takes extraordinary courage to strike. Strikers can face losing wages, losing their jobs, facing illegal retaliation when the strike ends, and they know all of this going into it. Workers have to believe that the chance to achieve long-term improvements in pay, benefits, and working conditions are worth the risk. And Senate Bill 938 would lessen the economic impact on Connecticut striking workers by providing them with unemployment benefits after a 2-week waiting period. Many frontline workers, after working hard and risking their lives during the pandemic, deserve substantial raises and improved working conditions. And unfortunately, for too many employees, this goal has not been realized. And Senate Bill 38 is not any kind of a radical policy. It would align Connecticut's unemployment policy with that of 2 neighboring states. New Jersey and New York have enacted similar legislation in 2018 and 2020 respectively. And thank you for hearing this important bill.
Thank you, Senator. Any questions? Representative Acker.
Thank you, Mr. Chair and Senator. Good to see you, sir. Saw you early, chilly Saturday morning in the meeting that we were at. So good to see you. So you brought up the other states. Are you aware of any strikes that went beyond the 2 weeks after that in those states? If you happen to know that, that was actually enacted, that they got the unemployment.
Oh, thank you for the question, Representative. And no, I am not aware of any strikes where this benefit actually wound up being invoked. Historically, most strikes do settle in less than 2 weeks. And so I'm not aware in either state where any benefits have actually been drawn down pursuant to the statutes that were adopted in those 2 states.
Thank you. And I just can go back, and I remember my dad, union member, went on strike, and it was lengthy, and it was rough. So, you know, we need 2 incomes typically in most households in the state of Connecticut. Do you know of any recent, and I can't think of myself, not that I know everything regarding strikes, but do you know of any recent strikes in the state of Connecticut that went beyond 2 weeks?
No, I don't. I know there was one a few years ago. I forget the name of it. It was I think a wire manufacturing company in New Haven that went on for 3 or 4 weeks, but that was several years ago.
Thank you.
I remember joining the workers on the picket line to try to help buck up their spirits, but that was several years ago.
Thank you. And then there was a comment made. You know, we have obviously right now unemployment fund is not in the greatest of shape, and there was part of one of the testimonies that came up with the solvency of the unemployment fund, because as a small business myself, I know in the past we've had to contribute when the fund got hurt, and we had to, all the businesses had to per employee we had to pay into. These are non-union regular that aren't striking, they're other companies. So there was testimony that said that concern if this were to go into place, that the solvency of the unemployment fund could be stretched and burdened more. Any thoughts on that?
I don't think that that's likely to happen, because I think the number of strikes that would go on beyond 2 weeks and have the benefit be actually invoked is small enough that it would not have a big enough impact to measurably affect the fund.
Thank you, Senator, and thank you for being here.
Thank you, Representative, and thank you.
Representative Weir.
Through you, Mr. Chair. Thank you, Senator. Just have a question. In New York and New Jersey, where these laws were enacted that are similar to what we're proposing, is there any data, even though it was never invoked, is there any data that shows the length of a strike before the law was enacted versus after?
Not that I'm aware of, Representative. I know that some of the discussion in New York and New Jersey basically talked about this in terms of a protection act for households that might otherwise run into extremists about inability to pay rent, having to maybe rely on food banks for food, obviously if they're without benefits for a significant period of time. Very often, even where there are strike funds, they're often very inadequate and cover only a very, very small portion of wages. And in fact, in many cases, there aren't strike funds at all. But so the concern was about families avoiding being put into extremists and perhaps jeopardizing their housing situation and their access to food. So it was seen basically as preserving the capacity for people to purchase things in the economy. But I'm not aware of any data from New York or New Jersey as to whether or not there's been any impact on strike length. So as again, the laws have not been in effect all that long in either state.
Thank you.
Thank you, Representative. I don't see any other questions. Senator, thank you for your testimony.
Thank you, Mr. Chairman. Thank you, members of the committee.
Next up to speak, Eric Jed.
Good afternoon. My name is Eric Getty here on behalf of CBIA. I'd like to testify on 5 bills today. The first is here to oppose Senate Bill 938. As we all know, especially during the last 3 years, the Unemployment Trust Fund is an incredibly important safety net. It provides benefits and preserves those benefits for individuals who lose their job through no fault of their own. And to qualify for unemployment benefits, you need to meet 3 requirements. You have to become unemployed through no fault of your own, you have to be looking for a job, and you have to be available for work. Our concern with this bill is that striking workers meet none of these requirements. Further, as has been alluded to a couple of times during this public hearing, this, we believe, would have a significant fiscal impact on the Unemployment Trust Fund at a time when we had just borrowed $1 billion from the federal government to ensure that everyone received their benefits during the pandemic. And we continue to borrow in the short term to pay new claims. And we will continue to have this balance likely until the year 2026. So this will be a long-term issue for employers in the state of Connecticut. Also here today to oppose House Bill 6594 on the non-competes. You know, I agree with a lot of those who have already testified on this. You know, non-compete agreements simply are not appropriate in every circumstances. And there's some industries where they simply do not belong. But using a multiple of a wage or employment classifications is not the appropriate metric to determine the appropriateness for these non-compete agreements in certain industries. HB 6594 seeks to invalidate these agreements, exposing employers to potential loss of their proprietary or confidential information or the loss of their client lists. These agreements are already heavily restricted by the courts in terms of their duration, geographical scope, and so we urge this committee to take no action on this bill. Also here to oppose 6273. Our biggest concern with this one is that it's actually going to cause greater harm than good to both the employer and the employee. I think there's going to be a lot of circumstances where if an employer posts the salary range, employees will not bother to apply at all. But often an employer's situation may change or there may be flexibility based on an employee's skills. Secondly, and it's been alluded to earlier today, in 2021, we passed a bill that requires employers to tell the salary range either when the applicant asks or when the job is being offered. CBIA supported that bill at the time because at least that allows for the conversation between the employer and the applicant about the job details, the benefits, other working conditions, and to determine whether there is that flexibility. Finally, Here to oppose 6285 on union membership. We're just a little bit concerned about this one, about the practical and policy implications of putting union membership on par with inquiries about other protected classes like race, sex, religion, disability, etc. I don't think it's good policy to be treating membership in one type of organization as a protected class. And further, employers are already heavily restricted in terms of the speech they can use under the National Labor Relations Act, which we think has exclusive jurisdiction.
Excuse me, Mr. Getty, just a heads up, you're at your past 3-minute marker.
Absolutely. I'm about to finish up right now. So finally, just here to support SB 197 on unemployment loans. This is obviously very important to us. We had 1.2 million claims for unemployment during the pandemic. And we should not be leaving the business community with the bill for shutdowns related to the pandemic. And every year that this federal debt remains, businesses see taxes and interest rate increases. So thank you very much for the extra few minutes. Happy to answer any questions.
Thank you, Mr. Getty. Any questions? Representative Acker.
Eric, great to see you here. Thank you for your testimony and your time and your advocacy for your members. Back to 197 to start with. Have your members reached out to you regarding we've gone through this in the past. I'm sure you're aware of that, but elaborate a little bit on what your members are discussing regarding 197, because most of them can't be here to tell us it.
Absolutely. So first of all, I got to say, I had to guess a little bit about what 197 is. It appears that it is looking to provide additional funding to help with employers with the federal debt that came as a result of the pandemic. Obviously, the business community borrowed $1 billion. And for every year that we fail to fully repay that debt to the federal government, the federal unemployment tax on businesses go up by 0.3%. Now, thankfully, the Connecticut General Assembly, all of the folks on this line included, voted the last 2 years to provide some relief related to this, about $195 million. But obviously, it's $1 billion problem. And while we certainly appreciate that help, if more is not done, if more funding is not provided to help businesses with this, they are going to see come January 1 of this upcoming year, their federal unemployment taxes increase by a significant amount, by 0.6%, which doesn't sound like a lot, but is significant dollars. It's on a per employee basis. So we were able, thankfully, to prevent employers from feeling that pain this year by reducing the state unemployment tax by an amount equal to the rise in federal unemployment tax. We kind of made the impact not be felt by the business community, but they will continue to see their federal unemployment taxes rise every year until this is repaid. And as I mentioned earlier, that is not predicted to happen until 2026. And if we have any sort of economic downturn in the meantime, employers will be in even worse shape, likely borrowing significantly more dollars and extending this problem out a long time ahead. And these are all dollars that could be used to invest in the workforce, growing jobs, paying better wages to employees. But unfortunately, instead, we're stuck with this problem.
Thank you. And I went through, and obviously all the businesses did, that when we had to pay off the interest-only portion of the unemployment compensation, that we are all hit with a per employee fee. No fault of our own, because we weren't laying them off, but it was shared by everybody that did have layoffs and non-layoffs. So. And then you mentioned 6285. I haven't heard anybody touch base on this one. And so I had pause on 6285 myself, mainly because if I ask somebody for their work history as part of applying for my job, that I'm sure that the discussion would come up that I worked for, such and such a company. And, it doesn't take, knowing if you do any research on what the person is applying for, that you would probably know that they would have union membership. Your thoughts on that?
Yeah, as I said, we're just a little bit concerned about why one membership in one type of organization is being treated as if they are a protected class, versus membership in any other type of advocacy organization. So that's our initial concern. I just don't think they should be treated on par with other protected classes in our Commission on Human Rights and Opportunities sections of this Connecticut General Statutes. And then also, I do think this already falls under the National Labor Relations Act, employer speech in this area. So I was just pointing that out for the benefit of the committee.
Thank you for that follow-up and thank you for your answers. Thank you, Mr. Chairman.
Representative Weir. Oh, I'm sorry. Okay. All right, Eric, I don't see any other questions. Thank you for your testimony, sir.
Thank you.
Up next, we have Heather Merrick.
Morning, my name's Heather Merrick. Morning, members of the Labor and Public Employees Committee. I am going to beat a dead horse as I speak in favor of Senate Bill 938. I'm a proud union member. I started at my job in 1998, and our very first contract negotiations, we were recommended to and voted to strike in 2001. I was a somewhat new employee, a young employee, and a new mom. My daughter was 9 months old. So for my very first contract vote, we packed up the diaper bag and the stroller and we hit the picket line. Even then I understood the importance of a good contract and what it meant for our future. And I had a pretty good idea of what unity and solidarity was. This decision was hard, but necessary. It continues to be a tough decision, especially to young families, to be able to have the security of unemployment benefits for striking workers would be a huge asset to our negotiating committee and our union. In essence, a huge asset to working families. And I urge the committee to support this bill.
Thank you. Any questions? Seeing none, thank you for your testimony. Next person we have up to speak is Kevin Cunningham. Move on to Anthony Soto.
Can you hear me okay?
Yes.
All right, perfect. Good afternoon, Senator Kushner, Representative Sanchez, ranking members and members of the Labor and Public Employees Committee. My name is Anthony Soto, and I am a wage enforcement agent with the Connecticut Department of Labor, as well as a chief steward with AFSCME Council 4 Local 269. I strongly support House Bill 5854 and not concerning the number of wage and hour inspectors at the Labor Department. In November of 2014, I began with the agency's Wage and Workplace Standards Division as a wage and hour investigator trainee. At that time, the division had 33 field staff. This included 3 supervisors, 20 wage enforcement agents, and 10 wage and hour investigators. Today, we have 25 field staff. This translates to less complaints being handled, longer wait times for a resolution, and increased power to the employers that are taking advantage of Connecticut workers. To be clear, I do not believe that all employers are bad. Many of them are doing things correctly and treat their employees fairly. However, the majority of the employers I deal with are not. My colleagues and I are combating wage theft on a daily basis. It is a major problem across the country, and Connecticut is no exception. From fiscal year 2019 through fiscal year 2022, our division recovered nearly $16 million in wages for Connecticut workers. These represent wages that workers earn that were not paid to them, wages they need to pay for housing and put food on their tables. Last year, I investigated an electrical contractor that had been in business for about 12 years. The workers that filed the complaint were referred to us from the apprenticeship division. The representative that assisted them believed they were being paid incorrectly. Through the information gathered in my interview of the 2 workers, my supervisor and I decided that a full audit should be done. Upon review of the records, it was determined that the employer was paying the incorrect classification on prevailing wage projects. Ultimately, I recovered $225,000 in wages for 21 workers. Unfortunately, we can only go back 2 years from the date a complaint is filed with our office. But these payment practices were in place since day one, meaning this employer stole millions of dollars in wages from their workers over the course of 12 years. An increase in the number of wage and hour investigators will increase the recovery of wages, putting dollars back into the hands of the workers that earn them. It would allow for strategic enforcement in industries that have a high propensity for violations. It would allow the agency to educate workers on their rights and employers on their responsibilities. And it will level the playing field for the vast number of employers that are already doing things correctly. Unscrupulous employers should not benefit from a business model that exploits their workers. I urge you to vote in favor of House Bill 5854 and stand with the working people of Connecticut. Happy to take any questions you may have.
Thank you, Representative Acker.
Thank you, Mr. Soto. Thank you for being here. You said, you had 25? Is that what you have with the number right now?
Yeah, currently we have 25 field staff. That's representative of, at the moment, we have one field supervisor, I believe 17 wage enforcement agents and 6 or 7 wage and hour investigators.
Thank you. And is your department allocated to have more already?
It's hard to say. I believe that there are probably some, at least 2 or 3 unfilled positions. Now, because of the nature of the work, you start off as a wage and hour investigator, then progress to a wage enforcement agent. So anytime there's a fulfillment of one of those positions, we're usually pulling from the pool of wage and hour investigators. So currently there are 3 field supervisor positions that are about to be filled that were lost to either retirement and 1 extra that was allocated. And there was a posting for a wage and hour investigator a couple of months ago. I know that they're just waiting for the supervisors to be hired and then the wage enforcement agent to be promoted and then move on to the wage and hour investigator. But I believe that's only 1 position that was posted for that.
And are these through the Department of Labor positions, state positions?
Yes, sir.
Yeah, we have a very slow process in the state of Connecticut in hiring, by the way, that needs to be looked at for more importantly. And then is most of your cases that you find, are they typically on the prevailing wage payments, wages?
No, there's a mix. I mean, a lot of what we find are probably private businesses. We could have a whole team. We could have 10 or 12 investigators and agents just investigating prevailing rate in terms, not necessarily the propensity for violations. Those do exist, obviously, but just because of the volume of work, there's projects everywhere in every town throughout the state. And if we were able to have increased staff, the proactive enforcement of that, we would find that the violations exist. Luckily, our partners in the building trades help police that and they bring cases to us. But it's not enough.
Thank you. And then is there fines imposed if you find negligence on the business?
Yes. So we do issue civil penalties. It also depends on the course of action that we take. If we're having difficulty collecting these wages on behalf of the workers, we could pursue civilly with a referral to the Attorney General's office, or criminally, we can apply for an arrest warrant. Those are usually reserved for worst case scenarios. Obviously, we're not trying to arrest every employer that has a minimal violation, but sometimes when they're uncooperative, they tie our hands and we're forced to do so. But most of our cases are handled administratively and they are, those violations are associated with civil penalties, which we collect. We probably collect anywhere from $800,000 to north of $1 million in civil penalties per year.
So would you say you're probably not, you're not a heavy cost to the state to have more license, to more wage inspectors, because you do offset that cost but with revenue?
Correct. I would agree with that statement. And additionally, the funds that we're recovering, the majority of these workers are spending the money in the state. So I think when you take all of that into consideration, you'll find that it's more expensive not to do this than it is to do this.
Thank you for your time. Thank you for your advocacy for those wage earners out there. Thank you, Mr. Chair.
Thank you. Any further questions? Seeing none, thank you, Mr. Soto, for your testimony.
Thank you very much. Have a good afternoon.
Thank you, you too. Next up to speak is Xavier Gordon.
Good afternoon. I hope you can hear me. I'm wearing my headset because I'm in the office this afternoon. So good afternoon, Senator Kushner, Representative Sanchez, ranking members and members of the Labor Committee. My name is Xavier Gordon. I am president of AFSCME Local 269, which represents the dedicated workers at the Department of Labor. I have worked in the Department of Labor for more than 30 years and currently work as a career development specialist. In 2015, I became president of the Local 269, and during my tenure, I've seen the Department of Labor lay off employees due to budgetary concerns. This has placed increased stress on DOL employees as the department didn't reduce the number of work when employees were laid off, and we have been asked to do more with less. Despite this, we still provide services to the public and are proud of the work we do. And definitely what we did during the pandemic, during in 2020, definitely tells you a lot. One of the areas in which the Department of Labor is vastly understaffed is the wage and hour inspectors. And I am here to testify in support of House Bill 5854, an act concerning the number of wage and hour inspectors at the Labor Department. This bill would require a minimum of 45 wage and hour inspectors at DOL. Wage theft is a pervasive problem that enables bad businesses to exploit workers and pay them less than the wages that they have earned. Wage and hour inspectors exist to protect these workers and to hold bad businesses accountable. They work diligently to investigate complaints and deliver results to workers that have been taken advantage of. In 2022, wage and hour inspectors in DOL recovered millions of dollars for workers who suffered wage theft. I urge the committee to improve staffing at the Department of Labor to support House Bill 5854. I'm also here to support Senate Bill 938. An act concerning unemployment benefits for striking workers. We believe this expansion of unemployment benefits would be positive for working people and would allow them to maintain some wages during a labor dispute. Workers do not take the decision to strike lightly and is often the last option available. Department of Labor would be able to administer this program using our current resources. Under current law, workers who are locked out by management in a labor dispute are still eligible for unemployment benefits. This is a common sense progression that follows New York and New Jersey, while striking workers can collect unemployment benefits. I urge the committee to support Senate Bill 938 and let it be administered through the Department of Labor. Thank you for your time and consideration.
Thank you. Any questions? Representative Acker.
Thank you. Thank you for being here. And isn't there a process to have jobs? Wouldn't that come from the executive branch typically, that they're going to expand, job classifications in the Department of Labor and then go through their commissioner and then put it in the budget normally?
Well, yeah, and again, I don't want to speak for our commissioner, but I'm hoping they're doing exactly that. I firmly believe that we should be doing more. Hiring more inspectors would make all the difference in the world, because again, we have a timeline right now where I believe that we're behind 5 or 6 months and that work alone. And so imagine if we can definitely speed up that process, get those fees, those fines. And again, and believe me when I say it pays for itself. I mean, why not? We need to bring this into focus and to really allocate those funds so that we do have the right number of workers for the wage and hour division, because then it makes sense. It's always made sense to make money, to bring it in and make sure that those individuals that are taking these losses right now recover that money, and at which point in time these working families can spend it here in the state of Connecticut. And again, we will keep people here as opposed to driving them out, because it's taking so long for the process to come to full circle, that they get served and they get their money back.
I appreciate that answer. And, I think that one time when we have enough enforcement, there's less people doing wrong. Right?
Correct.
Like what,
Absolutely.
Hey, Look at, they're gonna do something about it, whether it's on our roadways, whether it's, in construction, or whether it's in this area here. So I just think that it makes a simple move that the administration says, we're gonna do this. I'm gonna put in the budget and we're gonna do it. So, but we'll follow this process for right now. Thank you for your testimony. And thank you, Mr. Chair.
Thank you, Representative Becker. I really appreciate that, and I agree with you.
Thank you, Representative. Senator Kushner.
Thank you for bringing this to our attention. And while I respect the role of the commissioner in bringing forward proposals through the governor's office to appropriations for filling of positions, I've also served on appropriations now for a number of years, and the process is quite, we ask every commissioner to come in and explain their position on positions, and we often revise the budget to address needs that we see. So it's really important that you bring this to our attention, because otherwise we can't play our vital role in putting together the budget from the legislative branch. And so I really do appreciate you being here today. I think, I don't know if you submitted written testimony, but I think it would be helpful to have from you and your colleagues the written testimony that will really enumerate what you had, what you have now, what you think is sufficient, and the monies that you recover and how much more could be recovered for working families and for the state of Connecticut. So if you could submit written testimony to that effect, it would be very helpful to us.
That won't be a problem. We'll definitely get that to you.
All right. Thank you so much.
Thank you.
Thank you. Any further questions? Seeing none, thank you for your testimony, sir.
Thank you. Have a good day.
You too. Next up, we have Bill Adamson. See you, Bill.
Good afternoon. Can you hear me?
Yes, we can.
Okay. Thanks for the opportunity to testify. My name is Bill Adamson. I participated last year in the task force to study cancer relief benefits as an industry expert. I have 47 years in the insurance business in various leadership roles. In 2015, I founded 7710 Insurance Company, an insurance company that writes workers' comp for firefighters, and that alone. We now write in 34 states. We have 3 firefighters and an EMT on our staff, which we think gives us unique insight into the fire industry. One of our main goals as a company is injury prevention. It's an important component of what we do. In my written testimony, I mentioned that I thought there should be a lot more investment in screening for cancer. In last year's discussions and the bill that was put forward, we even have had something in there about that it'd be mandatory for fire departments to have 2 sets of turnout gear, which is a preventive measure. That didn't pass, so we still have some fire departments in Connecticut that are not operating under best practices for cancer. There are things out there now that a lot of people aren't aware. There's something called a Gallery 1 test. That is about $600, and that tests for 50 different cancers. And our view is that more work could be done if there was a funding to try to detect cancer early for firefighters, because if you detect it early, your chances of a good result are greatly enhanced. My written testimony outlines some other approaches other than workers' compensation. Workers' compensation is the most costly approach to providing these benefits. Workers' comp, in case you're all really thought about it, is the only insurance, for that matter, is the only business where you don't know your cost of goods sold at time of sale. In workers' comp, because the way the policies are written, we many times have injuries that have payouts that go over 30 to 35 years. And the rates for the industry reflect that, and cancer certainly complicates that. I offered in my written testimony a couple different alternatives that would be significantly less expensive to provide comparable benefits, the benefits that firefighters are looking for and need. And I believe that by focusing on an approach, an alternative approach, that would certainly facilitate some money to be able to spend on screening and regular analysis of people's physical situation every year to make sure we're doing whatever is possible to prevent and mitigate the cancers for firefighters. So with that, I just ask if there's any questions.
Thank you. Any questions? Senator Kushner.
Hi, Bill. I just wanted to be sure and say hello to you. I haven't seen you since last year when we spent so much time together on the task force. It is good to see you again. And I know you are advocating for measures that will help firefighters fight cancer, particularly the early screening, which I think we all agree with. I think some of the things that you mentioned that we would have liked to have gotten out of the task force and through the legislature last year are clearly still high on our list of 2 sets of turnout gear and other measures. I do think, though, that it's just hard for me to comprehend how you could provide all the benefits that a firefighter would get under workers' compensation for less money. And that's something I think, I think everyone would love to have us not have as great an expense, although I'm not sure that we've really heard definitively what the expense would be to workers' comp. And that's something that is important to note. But I don't know how we would end up providing all of the same benefits. And I think that's what's really critical here, is that we need to make sure that we're not shortchanging our firefighters with a program that is lesser than. And that's really the problem I have with the current program of the Cancer Relief Fund that we're currently administering. It doesn't provide the benefits that a firefighter and their family would get from workers' compensation. So, I think we'll continue this discussion. I always enjoy hearing from you. I know that your heart is in this. We just have a different approach to it, but I do appreciate the amount of time you've put into helping us, look at these issues. So thank you so much for being here today, as well as your past service.
Senator, would you mind if I comment briefly on your question on the rating? I think what's not understood is that workers' compensation, we front end the cost. So for example, if we have an injured worker, we pay until that injury either is fixed, or if it's permanent, we pay until they basically pass away, which could be 30 years. By moving it into an alternative, the healthcare, the critical illness policy, disability policies, all those policies are rated annually and they only pay for the policy year. So they're able to re-rate every year. The issue is comp has to front end the cost, and that's a difference. If we move it from try to guess what's going to be cost an insurance company over a long period of time for workers' comp versus do it with products that provide the same benefits in the form of death, disability, medical, the co-pays and everything with insurance protections that are rated annually, and it's not upfront. It's just much cheaper. And we went through some of that last year. I'd be happy to spend time offline with any of you to talk about how those costs. I mean, the state of Florida went to carved out cancer from their workers' comp law, and they used a critical illness policy. They buy those, they mandatory disability coverage, the critical illness provides the death benefit for whatever limit you want to choose. They also even pay, in the example in my written testimony, they pay upon diagnosis $25,000 to pay for all those nuances that, you've got to go here, you may have to get a babysitter, go testify to the doctor, all those things that aren't thought of. And that amount could be even increased depending on what people want to pay. So there is a viable alternative to provide comparable benefits, even better benefits in some instances, at a much cheaper cost. And maybe actually, if thinking about this, because it's less cost, maybe it's actually something to get implemented. It was in Florida, and I've got another state where they went and we've got this basically strict liability for cancer, and that rate increased to 100%. And now the fire departments are struggling because they haven't been able to increase the tax base. And, salaries are going up, equipment's going up, and they're between a rock and a hard place with nowhere to go.
Thank you for that. But I do have another question that you made me think of. When a firefighter files a claim under these insurance plans, say in Florida, is it then considered a line of duty death? so that the other benefits that would be afforded the firefighter fall in place in their families?
Well, they would get the death benefit, whatever limit was chosen. I think we talked about on the committee that I did some research, and I think the average death benefit paid out in comp in Connecticut the last 5 years is about 465. So we arbitrarily said 500,000 when we're talking about, but you could pick a much better. So the benefit would be in whatever limit that was purchased in that critical illness policy for a death benefit for the firefighters. And it's not that expensive to increase the limit.
So is there any benefit that a firefighter would currently get under workers' comp, and also from, you know, the resulting establishing that this is a line of duty death? Is there any benefit that the firefighter or the firefighter's family would receive?
Well, I think the idea that, you know, in comp, you don't get an insurance payment of $500,000, whatever they pay till the children reach majority, and spouse up until they generally either they remarry or, you know, pass away. So the idea is designed a death benefit high enough that would contemplate meeting all those needs of a firefighter. And I think that can be done.
Thank you for that answer. Thank you, Mr. Chairman.
Thank you, Senator. Any further questions? Seeing none, Bill, thank you so much for your time.
No, thank you, everybody. Appreciate the opportunity.
Next up, we have Michelle Evermore.
Hello, thank you, Senator Kushner, Representative Sanchez, Senator Sampson, and Representative Ackert for holding this hearing today on SB 938 on unemployment insurance for striking workers. My name is Michelle Evermore. I'm a national unemployment insurance expert with the Century Foundation, recently departed the U.S. Department of Labor, where I served as Deputy Director for Policy in the Office of UI Modernization and have been a national champion on UI prior to that. I've also adopted Connecticut as my home state. I strongly believe providing UI to striking workers meets the goals the framers of UI intended. In fact, I believe that not providing UI coverage to striking workers makes it harder for workers to participate in concerted activities that the majority of members in their shop have voted to support. So here are the goals of unemployment insurance: alleviate individual suffering, provide wage stabilization, avert layoffs, provide macroeconomic stabilization, and maintain attachment to employment. Taken together, the explicit purposes of UI make a clear case for providing benefits to striking workers. One of the framers of the New Deal, New York Senator Robert Wagner, came from one of the handful of states that had a UI program before the federal one was passed into law. That program provided payment for striking workers and was considered an example for how the federal law should work. It's clear that framers of these policies wanted to be sure that states could pay benefits to any people it deems to have lost work involuntarily. So on alleviating individual suffering, workers whose union votes to go on strike need to support that decision for that action to work, and therefore are truly involuntarily out of work. Strikes are hard on workers. They do not make the decision to strike lightly. They do it because their backs are against the wall and they need to push hard for a sustainable future for themselves and their families. Providing them a modest UI benefit just gives them enough resources to feed their families and pay their rent. Another goal of the program is to ensure periods of unemployment do not erode overall wages. In a state with a large racial wage gap and an overall much larger than average pay gap between high income and low income earners, it's clear that we need this tool. This brings us to the point about macroeconomic stabilization. The case here is clear. When there's a dispute in a community and many workers are all without income simultaneously, keeping workers afloat helps their community. To that end, Connecticut's weekly benefit is probably not high enough to meet program goals. The benefit is around the national average in a state with a higher than average cost of living. UI is intended to keep workers attached to work. Well, it can keep workers on a prolonged work stoppage from having to go accept other work to make ends meet. It's quite exciting that Connecticut is considering joining New York and New Jersey as a state that provides UI to striking workers. This is the kind of support that the program was built for, and I'm happy to answer any questions.
Thank you. Any questions? Representative Ackert.
Thank you, Mr. Chair, and thank you, Ms. Evermore, for your testimony. Just following back, so are those the only two states that now do that in the country?
Yes.
Okay, and we know we talked about this, and nationally, then I think you're probably coming more from the national. How long do typical strikes last?
That is a good question. One maybe for the NLRB. But in response to the question that you asked Senator Looney earlier, I would say that it's important. So I looked at states that I looked at New York and New Jersey since their laws have been enacted. And there was one strike in New York at Mercy Hospital in Buffalo that went on longer than the 2 weeks. So I wouldn't say it had a significant impact.
Thank you. And I guess when we look at, and I'm listening to this dialogue, I'm very intrigued by this concept. But when we look at our unemployment benefits now, obviously this doesn't fit, as it was mentioned earlier by one of the other testifiers. It doesn't fit the definition now for an unemployed worker. So I can understand the goal here, and making sure that people get some ability to make their way and pay their bills. So just doesn't seem like we have an issue that we need to fix right now, but and maybe this would help divert that in the future. People striking for longer than 2 weeks. I know that's a lose-lose on both. I brought this up earlier. Both the worker and the business loses. You're not making a product or servicing your clients. A lot of times the public also is harmed if it's a healthcare facility that strikes, or senior housing or something like that. So striking really is a lose-lose on all ends for all of us. So if we can divert that, that's the best scenario. So, but thank you for your testimony.
Thank you.
Thank you, Representative. Senator Kushner.
Thank you. It's good to see you. Oh, I know you can't see me because I've forgotten to turn on my video. It's good to see you. I have a couple of questions. First of all, and I don't know if you're the expert to ask this to, but I don't know, and I was out of the room for a few minutes. If this question already came up, I apologize, but there have been some issues raised by others about whether or not this would be preempted by the National Labor Relations Act, whether there's any prohibition in federal law that would prevent us from enacting this. That's the first question. And I assume there is not, or somebody would have already stopped it in New York and New Jersey, but if you could explain that, it would be helpful. And then the second part of that question would be if you have any documentation on how it would impact the trust fund and whether or not it's impacted it negatively in New Jersey or New York, and particularly from the point of view of any assurances you could give us that this would also be okay with, the trust fund has to follow certain federal guidelines as well. I know that this is your expertise, so I'm not maybe saying it as clearly as I should, but if you could address that too, whether or not the federal government would be okay with us doing this here in Connecticut, or would it place more of a burden on the Connecticut end of things?
Sure. I'm glad you asked that question. Thank you, Senator. So unemployment for striking workers has survived 2 Supreme Court challenges. Probably the most notable is the New York Telephone Company, which raised this question in New York in 1981. And basically the courts said, when the unemployment insurance law was passed, it was very clear that it wanted states to have the ability to provide benefits to whomever it considers to be involuntarily without work. And I believe that, it's clear that striking workers don't have a lot of choices. They can either, cross the picket line and harm the, goal that their union is trying to achieve, or they can, at this point, struggle to make ends meet. And so it's not much of a choice. And yeah, the Supreme Court has basically ratified a couple of times now that this is in line with federal law and does not preempt the NLRA.
And great, if you could address the other part of that question in terms of the cost to the trust fund, if it would negatively impact the trust fund.
So given the number of strikes that have gone on beyond 2 weeks in Connecticut, it seems like a very, very small effect on the trust fund. I can do more analysis. I can look into however many strikes there have been historically that go past 2 weeks in Connecticut. But in general, you're looking at, hundreds of claims filed a week. And so, in comparison with the number of normal claims, it's a very small percentage. I think it would generally always be a very small percentage. I can also go back and look at all of the strikes in New York that have happened since the passage of the NLRA and the Social Security Act, and see how many strikes historically have gone on beyond the time period to get unemployment insurance benefits. But I'm sure it's small.
Thank you for that. And do you know if there have been any studies in New York and New Jersey that would maybe help us to extrapolate and identify perhaps the cost to Connecticut?
Yeah, I will definitely look at that. The New York legislature recently shortened the period from several weeks to 2 weeks to be eligible for unemployment insurance. And there was probably research conducted during that campaign. I'll go back and look. It was just prior to the pandemic.
Thank you. That's all of my questions for today. I really appreciate your testimony here today. And if you can get us that additional information, you can get it to the Labor Committee clerk, and we'll make sure it gets disseminated to all of the members of the committee. Thanks so much.
No problem.
Thank you, Senator. Any further questions? Seeing none, Michelle, thank you so much for your testimony. Up next, we have Rudy Marconi, First Selectman.
Good afternoon, Senator Kushner, Representative Sanchez. Thank you for your time this afternoon and the efforts you put in on behalf of all of us in the state of Connecticut. I'm here today representing both CCM and COST as a member of both boards of directors, 169 municipalities. And we have tremendous respect for all of our firefighters, but this bill places an unsustainable burden on towns and their taxpayers. And that's what I want to address today. Not the end goal of providing benefits to firefighters that deserve them, that we should be covering, but how do we provide the financial backing to achieve such a goal? Under current law, if firefighters can demonstrate a causal link between an injury and the job, workers' compensation benefits are available. SB 937, however, creates a rebuttable presumption that certain cancers contracted by current and former paid and volunteer firefighters are job-related and as such compensable under workers' compensation. This is a significant departure from current law and ignores longstanding public policy that requires demonstration of a causal connection between the job and the incident triggering the injury or illness. By shifting the burden of proof to municipalities, SB 937 will impose a huge unfunded mandate on towns and cities. In assessing the fiscal impact of similar measures in previous years, the Office of Fiscal Analysis has indicated that the cost of this mandate on towns and cities is highly variable depending on, number one, the frequency of the claims filed, and number two, the severity of the claims, for example, the extent of medical treatment and lost wage benefits. Recognizing the significant costs associated with the proposal, a working group, which included firefighters and representatives of both COST and CCM, developed a proposal to create a fund to provide financial relief to firefighters under certain circumstances. This approach was widely applauded and adopted into law. This resolution ensured that municipalities and local property taxers would not be overwhelmed with the cost stemming from the creation of a rebuttable presumption under workers' comp. Instead of moving forward with SB 937, the state should provide adequate resources for the fund and undertake other efforts to protect firefighters. And I draw your attention to the Heart and Hypertension Act that was passed years ago and finally withdrawn, only to allow those policemen hired prior to July of 1996 to be covered under heart and hypertension because of the cost implications. Thank you. Any questions?
Thank you, First Selectman. Any questions? Representative Acker. Sorry about that.
Thank you, Mr. Marconi, for being here and testifying. Has there been an actuarial report in terms of what this is actually going to cost? Because we hear about higher costs and I kind of want to, I know that my town manager reached out to me, who past president of CCM and cost, and said, this is going to cost a lot, and I'm not getting any numbers. So do you have some work that was done on that through? Thank you.
Kerma under CCM has currently hired an outside company to come in and do that actuarial table for us. As of today, we do not, but once completed, we would be more than willing to submit to the committee.
And I know, not speaking for the committee, but I know I'd be very interested in that information.
Yeah, one of the things that we deal with often under workers' comp is the IBNR, which is incurred but not recorded. For example, if I was a firefighter and my PSA count was high and I was tested and found to have a cancer, that treatment would take place and hopefully successfully. And we have had good success rate, but that's not the point. The point is that workers' comp now has established a liability. And that becomes part of the municipality's responsibility and is included in our rates every year. And your town manager, I'm sure, has elaborated on workers' comp and the costs associated with that as we go forward. The cost to the municipality will eventually get passed on and will in fact be passed on to the taxpayers. And in our state, we have worked so hard for so many years to try and lessen the burden of property tax on all of our residents. And this works in contradiction to that. It will only further the impact on property taxes. And I appreciate all the work being done, but last year's bill was a beginning, is how I would like to look at it. Allow us to continue the work and to increase the benefits if there are differences that exist between workers' comp and the recently passed bill. Let us take a look at that and let us come up with funding sources, like municipalities have agreed to pay $10 per firefighter, be it fire marshal, volunteers, paid, across the board. Allow us to have a hand in that. And please do not pass an unfunded mandate. It's just the wrong direction to head in.
Thank you. Thank you, Mr. Chair.
Thank you, Representative. Senator Kushner.
Hello, First Selectman Marconi.
Very formal. Thank you.
Can I call you Rudy?
Yes, you may, of
I have
course.
to say, I hate disagreeing with you. I just hate it. It's the worst. For anybody who's here, you ought to know that Rudy.
Oh, you don't have to.
represents Ridgefield, and I now represent a portion of Ridgefield, and I'm really proud to do so. And I so appreciate everything you do for the town of Ridgefield. You're a great leader, and it's widely recognized by the folks who live there and by those of us who live nearby.
Thank you.
I think there is, it's important to work together on these issues, and I appreciate your comments. I think that the comment that strikes me the most is that folks have waited so long, that this promise to try and work this out so that there are benefits for people, at least got expressed 8 years ago. And now even today, there's some concern that I heard in earlier testimony that there still hasn't been any payout from the Cancer Relief Fund. And so I think there is the challenge of providing the same level of benefits that a firefighter would receive as a result of the coverage under workers' comp. So far, we've not been able to duplicate that. If there's a way to do that at a lesser cost to the cities and towns, certainly that's a worthwhile endeavor and one that we'd want to pursue, but we haven't seen that yet. And I think if we can come up with that, there would be no reason to me, going into the workers' comp system now, seeing how it works, finding out, you know, if the fears about the cost to the cities and towns are serious and real, or whether, you know, that, as has been suggested by some, wouldn't be as great as been anticipated.
Right.
And then moving to a point where if in fact we can find another way to fund these benefits at an equal level for less money, I can't imagine that we wouldn't jump, you know, onto that. But right now, people have been waiting for so long, and we've lost firefighters along the way who have suffered themselves, and their families have suffered. So I think that's the concern about making sure that we're doing this now and providing that service. And, you know, I recognize that property taxes are a big concern to all of our constituents, but, you know, I think part of the deal is you live in a society where you rely on other people to risk their lives to take care of you. And we know that firefighters are suffering from cancer because of the relationship of carcinogens in their work. And so we're saying we expect you to risk your life, but we're afraid it will cost our property owners too much. I don't know where that takes us as a society. I just feel like we have that obligation.
Right. Unfortunately, I didn't mean that. I understand what you're saying. I would never imply that ever, but what I'm saying is there is an alternative way of getting there, and that we should explore it and put our heads to work, come up with a plan that we can all collaborate on, have it be very transparent, and solve this problem. Because I agree with you. Firefighters in the profession of saving others shouldn't put their own risks, own lives at risk beyond which is reasonable. Now, cancer is a very difficult situation for many people in our state, in our country. And if we can come up with ways to help people, I'm all in favor of that. But I'm also a realist as well, and know that one of the biggest issues that any municipality faces is the property tax, and what can we do to control those. I think if we looked at the alternative plan, as Bill Adamson was suggesting, there is a way to do this, and there is an opportunity. And why the payments aren't moving, I don't know. But if you've ever been through the workers' comp, it's not the fastest of moving entities in terms of getting claims settled. So that's why we appointed firefighters on the review board, reviewing the application. We're asking that the men and women of the fire service wear their turnout gear, wear their SCBA, their breathing apparatus, pay attention to everything, wash their turnout gear. And I can tell you from experience in going to many, many fires that is not always the rule that's followed. And we need to have that impressed upon all the members of the fire service, how critical it is that they take the protection of their neck, of their underarms, as well as their groin area, which are the most sensitive to this very, very difficult disease. But let's work together on it, because I think, honestly, if we do, we can come up with a plan that gives them all the benefits and helps the taxpayer as well, because we all benefit from the firefighters. Thank you.
I appreciate that. And I never meant to suggest that you didn't share my views about the value of our firefighters. So I apologize if that's how it came across.
Okay.
I would never suggest that, but I do think that it is, you know, something that I hope will move out of our committee with a positive report and a joint favorable report, and that we will continue to work on making sure that we're taking care of our firefighters today.
I'll leave it with just include the municipalities, include the organizations that represent all of the people on a day-to-day basis in the trenches.
Absolutely. But I do want to say that last year when we had the task force, I got hit hard because I don't believe CCM participated in the task force, and it really, and then I went back and looked at the original legislation, and there was a spot for them. We did have a spot for CCM. Unfortunately, the appointing authority did not make that appointment.
Right.
It was not anything within my control, and there was no reason. It was not intentional to exclude CCM from that process last year. And I agree with you. It's much better if they have a seat at the table. And we've worked hard to make sure that was true in some of the other task force that I'm working on now. But thank you.
Appreciate that, Senator. Thank you so much.
Thank you.
Thank you, Senator. Any further questions? Thank you, Mr. First Selectman.
Thank you. Appreciate the time.
Thank you. Next up, we have Frank Reese. That's not Frank. Okay. Next up, we have Kimberly Davis. Davis.
I was looking forward to her. I know.
Oh, really?
She's wait
Next
staff
up,
at- Oh,
she
okay.
is muted.
Ms. Davis, could you please unmute?
She might have stepped away for a second.
Oh, here she is.
There she is. Okay. Ms. Davis?
Yes, hello.
Hi,
Hi,
floor is yours.
how are you today?
Good, how you doing?
I'm well, thank you.
Good.
So I'm here to talk about SP 938.
Continue.
I'm sorry, can you hear me?
Yes, we can hear you.
Okay. So my name is Kimberly Davis and I'm a banquet server at the Hilton Hartford Hotel. I've been working here for 32 years. I've been in the union for over 40 years. I belong to Unite Here, Local 217, and we went out on strike a couple of times over 20 years ago. And we were fighting for good wages and health benefits, and we knew we weren't going to get them any other way. But back in those days, there were 3 union hotels and some unionized restaurants in Hartford that were independently owned, who would hire the workers on strike because they knew we were good workers. And even though we were out for weeks, we could go to work at the different hotels, working various banquets, various functions, and everything that was going on in the hotel. And after, we would be on the picket line and do both things. And because we had some income, we were confident that we could stay out as long as we had to. And we were together. We were a strong union. Hartford at that time was a strong union city. Like I said, we had the 3 hotels, everybody was unionized, and strikes were different back then. But because of our strikes and our union contract, we have medical insurance, we have vacation, we have personal time, we had everything we need for a decent living. And like I said, I've been here for a long time. I enjoy my job and I'm getting ready to retire in several years or so. I will have my pension. I have everything that I possibly need. My house is paid for. I put my son through college, and I have a feeling that we came a long way going through those strikes. And I want to defend our contract and keep improving on our wages and benefits. But if we had to strike today, things would be different. There's only this union hotel in the city of Hartford, and we wouldn't have other people backing us up and looking to absorb us in that manner. And without other income, it would be harder to be on strike for multiple weeks. But going on strike and winning a good contract changes life. Extending unemployment benefits will help striking workers stay out 1 day longer, 1 week longer. It will help all of us fighting for better wages and benefits for workers across Connecticut. Thank you so much.
Thank you, Ms. Davis. Any questions? Senator Kushner.
I just want to say hi. I know that it's too bad we can't see you on screen, but I know your service at the Hartford Hilton is it's amazing, and you've served many of us many good meals. So thank you for the work you do, and thank you for coming and testifying today.
Yes, thank you so much. It's so nice to hear from you again, and we miss you also. I'm actually at work. That's why I'm on my phone. So this is my break time. This is my good union break. And it was a pleasure to talk to all of you again. And, it's too bad that we won't have the events or anything that we used to have. But, we're here. We're all here, and we're fighting for this unemployment benefits for anybody that needs to go out on strike.
Thank you for serving us. Take care.
You're welcome. It was a pleasure.
Thank you. Any further questions? Seeing none, thank you, Ms. Davis, for your testimony. Next, we have.
Thank you. Have a good day.
You as well. Kareem Pimentel.
Thank you.
Karime. I just asked that both of you introduce yourselves for the record and turn on the microphone as well. Thank you.
Buenas tardes, damas y caballeros del Comité Laboral, copresidente, representante Sánchez y copresidente senadora Kushner. Mi nombre es Karime Pimentel y soy la organizadora principal de Nagatu Valley Projects.
Buenas tardes, mi nombre es Nelly Jara y voy a hacer la parte de la traducción en inglés. My name is Nelly Jara and I'm gonna assist Karime with the English translation. Thank you.
Thank you.
Estoy hablando esta tarde en nombre de Nagatu Valley Projects con oficinas en Waterbury, Connecticut.
Good afternoon, ladies and gentlemen of the Labor Committee, Co-Chair Representative Sanchez and Co-Chair Senator Kushner. My name is Karime Pimentel. I am speaking this afternoon on behalf of the Nagatu Valley Project with offices in Waterbury, Connecticut.
Hablo a favor del proyecto de ley de la Cámara de Representantes número 5854, una ley que aumentaría la cantidad de inspectores de horas y salarios en el Departamento de Labor para investigar casos de robos de salario.
I speak in support of House Bill number 5854, an act that would increase the number of wage and hour inspectors at DOL to investigate wage theft cases.
Nagatu Valley Project tiene muchos miembros trabajadores del hogar. Son limpiadores de casas, niñeras y trabajadores del cuidado del hogar, que trabajan muy duro por el salario mínimo o un poco más para mantener a sus familias y cuidar de las familias de los demás.
The Nagatu Valley Project has many domestic workers members. They are house cleaners, nannies, and home care workers who work very hard for minimum wage or a little more, supporting their families and taking care of the families of others. Very few domestic workers receive benefits.
Muy pocos trabajadores del hogar reciben beneficios y muchos son indocumentados y además no hablan inglés.
Many are undocumented and many do not speak English.
Hemos estado luchando por los derechos básicos de los trabajadores del hogar que muchos otros trabajadores han tenido durante muchos años.
We have been fighting for basic worker rights for domestic workers that many other workers have had for years.
En 2021, la legislatura aprobó un proyecto de ley y el gobernador lo firmó para proteger nuestros derechos al salario mínimo estatal, el pago de horas extras y una descripción del trabajo por escrito con nuestros empleadores.
In 2021, the legislature passed a bill and the governor signed it to protect our rights to a state minimum wage, overtime pay, and a written job description with our employers.
Gracias a todos ustedes por su trabajo para que se aprobara este proyecto de ley.
Thank you for your work getting that bill passed.
En nuestras conversaciones con los trabajadores del hogar, escuchamos mucho sobre abusos, siendo el robo de salarios el que a menudo encabeza la lista. Como por ejemplo, uno de nuestros miembros trabajó 6 semanas durante la pandemia para solo recibir un cheque sin fondos por su trabajo. Por temor a ser deportado, no quiso presionar para que se hiciera un control de ubicación.
In our conversation with domestic workers, we hear about many abuses, with wage theft being one of the top list. As a member
One of our members worked 6 weeks during the pandemic only to be given a bad check for his work. He was treated with a call to ICE if he pushed for a placement check.
Es desalentador para nuestros miembros trabajadores del hogar armarse de valor para presentar un caso de robo de salarios y luego tener que esperar muchas semanas antes de que se tomen medidas en su caso.
It is discouraging to our domestic worker members to sum up their courage to file a wage theft case and then have to wait on pins and needles many weeks before there is any action taken on their case.
Necesitamos absolutamente más inspectores de salarios y horas en el Departamento de Trabajo para que los empleados con casos puedan ser asistidos de manera oportuna y mientras esperan puedan estar en comunicación regular con alguien en el departamento para tranquilizarlos.
We absolutely need more wage and hour inspectors at the Department of Labor so that workers with cases can be assisted in a timely way and while waiting can expect to be in regular communication with someone in the Department of Labor, easy their peace of mind.
Gracias por aceptar mi testimonio hoy. En nombre de Nagatu Valley Project, quiero agradecerles por su trabajo en la expansión de los derechos de los trabajadores del hogar.
Thank you for accepting my testimony today. On behalf of the Nagatu Valley Project, I want to thank you for your work in expanding the rights of domestic workers.
We want to talk today bilingual because we want our voice as Hispanic could be here. Thank you so much.
Thank you.
Any question?
Thank you, Senator Kushner.
Well, first of all, I do appreciate you being here and testifying and referencing the bill that we did in 2021. And for the members of the public that are listening and committee members, when we passed a bill in 2021, you educated us about the fact that many workers didn't know their rights and didn't know they were already entitled to minimum wage and other wage and hour protections. And so your organizations partnered with the Department of Labor in educating workers and making sure that they had a written agreement with their employer as to what the job they were signing up for. So all of that is great. But what I hear you saying today is that you've taken the steps to educate the membership, to educate the people, the workers who are performing these jobs, but the abuse is still there. And that people, now we have a problem on the other side, on the government side, because we don't have enough wage and hour inspectors to really enforce the laws that we've passed. And so did I get that all correct?
Yes, right now, due to the work that we are doing with the DOL in our communities, we have 2 inspectors. If somebody from the domestic worker have a case, can go directly with them. And this is something awesome for us. And we are continue educating the employers and the employees, because we said if the employers know the law and enforcement, our employees can get better benefits and better life. But this is something that we are working, and we have 2 more years for continue developing this educational program.
And just I want to say that thank you for passing this bill for domestic workers. I think this was a victory for domestic workers in Connecticut. We are working with different affiliates, and obviously in coordination with the Department of Labor, we are filing cases to the Department of Labor. We create a good relation, collaborative work. But yes, we need more investigators, because after the education program that we had in 6 months, we have many people asking for support. And the main thing is here to we need DOL to recognize that we as a nonprofits are doing the work, and the people are coming directly to us, because at the beginning they were afraid of going directly to DOL. We are educating them. We are trying to have a good connection with them and listen to them, hearing everything that they may want to tell directly to DOL. So take advantage of this of the work that we're doing here and take advantage of all of these people who need putting more investigators, putting more money to DOL to do the work. To better improve the people's life, families' life, and workers are everywhere who are suffering. And I think it's on your hands, in our hands, the responsibility to support each other. But thank you.
Thank you very much for that answer. Thank you, Mr. Chairman.
Thank you, Senator. Representative Hughes.
Thank you, Mr. Chair. Just two questions. One, did I hear you say there are two investigators? Are they the only two that are bilingual that you can go to?
Honestly, we have one who got a connection, and he's a bilingual also. He speaks Portuguese and Spanish, because we have a community also from Brazil who are affected by Western. But the other person speak only English, but she tries to communicate back and forth, and we're learning together that and supporting each other. But the good thing is we are in now. So this is again a victory, but it will be.
We agree. We need more inspector, because the time between one another is sometimes more than a year, and it's too much waiting. And we need more inspector or go a little faster from the different cases that our families have at the DOL.
And these people need to be paid, because they have to pay bills, they have to buy food for the kids, they have to eat. And that's not fair that these people are taking advantage because you don't have documents, because you are working so hard and you deserve to be paid. Why those employers are taking advantage? Not only independent contractors, there are big companies, restaurants. So we have a variety of workers that are coming and asking for help. So I think it's an opportunity again for us to do this work together, and we are more open to learn everything that we can learn to support our family.
And get the better life, because our workers, they deserve.
Yeah, I thank you for, through you, Mr. Chair, underscoring the economic justice issue, because what you're telling me is because this workforce, which is vital, people are needing to use this workforce, especially direct care and essential in-person workforce, is getting disproportionately denied justice because we don't have appropriate bilingual or multilingual investigators, and therefore there may be entire industries that are taking advantage of the lack of enforcement in the law, or quite for the benefit of the doubt might be unaware of the law and the protections that we have passed. And because they are not being enforced, so they may be unaware. And that, like you said, it's an economic justice. If workers agree to take a job, to get paid in a timely manner, and if that is consistently being denied or delayed, it's a justice issue. Thank you, Mr. Chair.
Doesn't matter if the inspector only speak English, because we have bilingual in different languages people, but we need more inspectors for move forward.
Important point. Thanks.
Thank you. Any further questions? Seeing none, thank you for your testimony.
Thank you.
Next up, we have Sarah Parker McKernan.
Hi. Good afternoon, Senator Kushner, Representative Sanchez, and distinguished members of the Labor Committee. Thank you for the opportunity to testify today in support of HB 6594, an act concerning non-compete agreements. My name is Sarah Parker McKernan, and I am a legislative policy advocate for Connecticut's legal services programs, which include New Haven Legal Assistance, Greater Hartford Legal Aid, and Connecticut Legal Services. Legal services programs provide free legal services to low-income individuals in civil matters throughout the state. We have been particularly involved in developing policy to support low-wage workers and their families. We support HB 6594, which, among other things, prohibits non-compete agreements for those employees earning less than 3 times the hourly minimum wage. This proposal addresses the growing problems of low-wage workers who are forced to sign non-compete clauses prohibiting them from doing similar work after leaving an employer. Low-wage workers often feel unable to find new and better jobs because of non-compete clauses. Most employees in Connecticut are considered at will and have very limited bargaining power in their work environment since they can be terminated without cause. A non-compete agreement heightens a low-wage employee's fear of violating their employment contracts. Workers may very often assume that non-compete agreements are valid and enforceable and lack the financial resources to hire an attorney to challenge those agreements. Even a one-year restriction on engaging in the same type of work within a 10 to 15-mile radius can adversely impact employment opportunities. Many low-wage workers do not have skills adaptable to other jobs and depend on public transportation. Non-compete agreements can prevent workers from seeking or accepting better jobs with higher wages. Because of these negative consequences, 27 states, including Massachusetts, New York, Maine, and New Hampshire, have restricted employers' ability to require non-compete covenants in some way. It's important to note that HB 6594 contains provisions that help all workers in the workplace, not just low-income workers. And however, HB 6594 also balances constraints on employers with constraints on workers by allowing non-compete covenants to protect legitimate business interests, such as trade secrets, confidential information, or goodwill with customers, forbidding workers from soliciting a former employer's prior customers or workers after separating, and permitting non-solicitation clauses in exclusivity agreements containing reasonable parameters. In January of 2023, the Federal Trade Commission proposed a new rule to ban the imposition of non-competes after finding that they constitute an unfair method of competition. Importantly, the potential for federal action does not make enactment of state legislation moot. Enactment of a federal rule is not only time-consuming, but even if it happens, most likely will be subject to extensive legal and congressional challenges to its implementation. I'd like to call your attention to substitute language that I've attached to my testimony that clarifies what looks like a typo in section 2B, and we urge you to pass HB 6594. Thank you.
Thank you. Any questions? Senator Kushner.
I just want to thank you for your work, but also thank you for pointing out a typo that can be devastating if we got it wrong. So
right.
We'll take a close look at that. Appreciate your reading it closely.
Thank you, Senator. Representative Weir.
Thank you, Mr. Chair. Thank you, Ms. Parker McKernan. You mentioned 27 other states have restrictions on non-compete agreements. Is that to say that Connecticut has no restrictions on non-compete agreements?
No. Connecticut already, and I think this came up in earlier testimony too, we have non-competes that are enforceable against physicians with parameters. And we also have other conditions that have to be followed, but that doesn't mean that it's something that's okay. I think there's still, this is a situation where you don't want the ability to have a non-compete that's going to be more restrictive than it needs to be. And I think that that's what we're trying to clarify within this document, within this bill.
Thank you. Okay, so I'm just trying to phrase my, we have 27 other states that I guess in my language are a little more clear. I mean, they have more restrictions than Connecticut, but in your opinion, they are more clear as to where each party stands.
Exactly. I think that that's one of the things that I think is missing in Connecticut is that we don't really know. And I think, again, there's been other testimony today that's really, kind of dealt with that issue, that there needs to be more clarity. The courts do not have a clear position on what is okay and what is not okay. So that's why it's hard for a worker to actually tell whether or not they should be in violation or not. So I think that that's something that we need to clarify through this language. Absolutely. And I might note that I think there's actually all 50 states have some sort of restrictions, but but whether or not they actually go as far as what we're trying to do or not, is they're all on the way to doing that. But we are definitely, it's our turn to do something more significant about what is happening with these clauses.
Thank you.
Thank you, Representative. Any other questions? Seeing none, thank you for your testimony.
Thank you.
Next up, we have Dan Livingston.
Good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor Committee. My name is Dan Livingston, and I'm proud to be an attorney representing unions, civil rights, and other progressive organizations for more than 40 years. I'm here today particularly to talk about Senate Bill 938, an act concerning unemployment benefits for striking workers. You will hear and have already heard from some of the true experts in strikes and unemployment. Workers who risk their own and their families' well-being to help build a better future for themselves, their coworkers, and their communities. Most of us have never had the experience of going on strike, and sometimes we forget the courage it takes. It is through strikes, the rarely used weapon of last resort, that the labor movement helped build the middle class and create a more just America. I grew up in the labor movement and was a union organizer before I became a union lawyer. I saw firsthand the power and the peril of the strike decision, the peril especially present in our country, which is one of the only democracies to allow immediate permanent replacement of strikers. Because of that rule, strikes of anything more than a few days often become about far more than the specific terms and conditions of employment. They get to the very question of whether strikers will have jobs and whether they will have a union. The very special nature of strikes was apparent to the 1935 Congress that created the federal unemployment system, which supports the systems of all 50 states. They had the model before them of the New York State unemployment system, which provided unemployment to strikers, but more conservative members of Congress wanted to deny those benefits. Instead, Congress chose to leave that question to each of the 50 states. And as the Supreme Court said in upholding New York's law, even after finding it altered the economic balance between labor and management, undeniably, Congress was aware of the possible impact of unemployment compensation on the bargaining process. The omission of any direction concerning payment to strikers in either the National Labor Relations Act or the Social Security Act implies that Congress intended the states to be free to authorize or to prohibit such payments. Free to authorize or to prohibit, it's important to understand that choice, for that cannot be a neutral one. When strikes last for more than a few days, workers are at risk of losing everything: homes, cars, if they own them, their jobs, if they are permanently replaced, perhaps their union, maybe everything they have in this world. For each week of unemployment, then, our law makes a choice. Our current law chooses to advantage employers for every week of the strike by treating strikers as though they just didn't want to work. The proposed law before you would maintain that advantage for 2 weeks, but then would do what unemployment usually does for workers who cannot work for compelling reasons: provide unemployment benefits, cushioning the blow for them, their families, and their communities. There's basic fairness in this. No worker chooses to go on strike lightly, certainly not to strike for more than 2 weeks. But from the moment the decision is made to strike, our current law pressures strikers to give up the fight. That's not a choice the General Assembly needs to make: free to authorize or free to prohibit. It is far more consistent with our state's long history of respect for collective bargaining and for the underlying purposes of the unemployment system to make a more balanced choice. And I urge the committee to support Senate Bill 938, and I thank you for raising it.
Thank you, Mr. Livingston. Any questions? Senator Kushner.
Thank you. It's good to see you here today. And in your testimony, you did make me think of a question or concern that gets raised by colleagues. This idea that somehow this would be unfair because it would give employees more leverage at the bargaining table, or if they were already out on strike, than they currently have, and that somehow this would disadvantage the employer. And I wonder if you referenced that in your testimony. I wonder if you could talk a little bit more about that, because I think we do live in a world where people think that it's equal power in a workplace as things exist now under current law, and somehow this would be giving a leg up to the workers. And I don't know if you have anything you could add that would help us understand why that might not be the case.
So I guess I would say it this way. The first 2 week waiting period certainly gives a leg up to the employer. The choices are to provide benefits or deny them to strikers. That's the only choice the General Assembly has for each week, because we look at unemployment each week. So for the first 2 weeks, we're clearly benefiting employers, and we keep doing that even if this bill passed. Right now, we benefit employers forever, for as long as the strike gets. The Congress left to the states the question of where the overall balance is when you look at unemployment benefits as compared to the power of employers and employees of the workplace. Our country, our federal law strongly favors employers, unfortunately, in terms of that balance. We are really the only industrialized democracy that allows employers to permanently replace strikers. That is a huge advantage to employers and puts so much at stake for workers. So the decision by the state of Connecticut to, after 2 weeks, do a little bit to even that balance just by providing unemployment benefits, I think is absolutely fair and consistent with our state's commitment to collective bargaining, to good labor relations. I think it ultimately benefits what happens at the bargaining table by making things a little bit more equal. But frankly, like I said, I think the balance of power, unfortunately, under our overall labor relations scheme, favors employers in this country.
Thank you. That was very helpful. I had forgotten about some of the advantages that employers have during a strike, particularly the right to replace workers. I think that's important to remember and something that we can talk about amongst ourselves and amongst the committee members. But I do think that the other thing that it strikes me is really important is that we keep in perspective that when workers do have the ability to raise wages, protect benefits, or expand benefits, that generally speaking, historically speaking, that has had an impact on all workers, not just the workers that are fighting the fight. I alluded to that with some of the early testimony from the Stop and Shop workers who, you know, it was so clear that their victory wasn't just a victory to protect their pension and their health care, but it also sent a message that these were important benefits that needed to be protected by all workers and for all workers. So I think there's a lot to be said about the way this could benefit our state way beyond just the workers that are involved in a particular strike.
Yeah, I mean, if I can respond to that in just a second, I really do think that when strikes go on and are won, the beneficiaries are more often other workers in the sense than the strikers. So the strikers have already paid so much for what they win, but their coworkers in throughout the industry and in their communities often gain from the new standards that those strikers set for wages, benefits, and working conditions. So I do feel they strike for all of us, and no one strikes lightly. They strike when they have to, but we're the ones who gain. All of us are the ones who gain.
Thank you so much for your testimony today.
Any further questions? Seeing none, Mr. Livingston, tell Ethan I said hello, fellow classmate Noah Webster.
Wow.
Yeah, I remember your face.
I certainly will. I'm delighted to do that. Thank you.
Take care. Thank you for your testimony.
Thank you.
Next up, we have Jeff Tomchik.
Good afternoon. Might have a little 5 o'clock shadow now. It's a long day for you, so I appreciate your patience and your ability to listen to everybody speak about their bills. But I want to say good afternoon to the chairs of the committee, Senator Kushner and Representative Sanchez, and also to the ranking members and to all the members of the Labor and Public Employees Committee. My name is Jeff Tomchik. I am the political director for the Uniformed Professional Firefighters of Connecticut. We represent just under 4,000 union firefighters and telecommunicators across the state. I'm here because I want to give testimony in support of Senate Bill 937. That is the act providing workers' compensation benefits for certain cancers in firefighters. Just to give a little bit, I know I testified on this last year, and I want to add what has developed over the past year. It's important to note that the International Agency on Research on Cancer, which is a division of the World Health Organization, convened a panel of 25 scientists crossing 8 countries, and that made a large move of what they described as firefighting in relation to cancer, which was initially classified as a possibility that firefighters could develop cancer. And they moved that to a Group 1 designation which is identified as firefighting is carcinogenic to humans. So it is a significant risk, and significant amount of science goes into back that. In addition, I spoke last year about there were 48 other states that have a presumptive cancer laws. But in addition to that, the 117th congressional session passed HR 2499, which is protecting federal firefighters against cancer by forming cancer presumption laws for them. In addition, Canada had gone nationwide in providing presumption for their firefighters, identifying the significant risk of cancer to them. Looking at our neighboring states, New York and Massachusetts, which have significant strong programs in their cancer legislation, also sustainable programs, have been providing those for more than 5 years. So it's proven that it works, and it's proven that it's sustainable. On top of this, the science that has been coming in to make this a significant risk to us. We look back over the last 6 months and we recognize that the International Association of Firefighters has categorizes and tracks the line of duty deaths. And there was 35 of them, unfortunately. 22 of those deaths in the last 6 months are related to occupational cancer. At this point in time, unfortunately, if it was a Connecticut resident, a Connecticut firefighter, they could not hold that classification because we do not have any line of duty benefits for incurred occupation incurred cancer. The Center for Disease Control and Prevention the division of the National Institute of Occupational Safety and Health has worked with the Congress, and they developed the National Firefighter Registry, which began in 2018 to identify and find the relationship between firefighting and cancer. All of that data is helping to prove and understand the significant risks that firefighters face every day, but also in an effort to reduce risks and pave way for new health and safety measures. We understand that this legislation will help identify cancer as a work-related injury, and it's going to allow access to benefits just as any other injury that a firefighter may face. More importantly, though, one of the biggest things that we have to recognize is that in order to first identify mechanisms for prevention and steps for early detection is to say that this is an injury that we find on the job.
Mr. Tomczyk, your time is almost up. Please conclude your remarks.
Thank you. In my closing remarks, I just wanted to say, and it's been stated in the past testimony today, that we have drafted, debated, researched, attempted to fund, and tried to implement benefits to support firefighters that are serving our communities. Unfortunately, this is going to be our main avenue of approach. We need to start now, cover our firefighters as they face these known carcinogens. And it's the unfortunate fact that our firefighters are going to face this battle with cancer, and we need to do everything we can to protect them. Thank you for your consideration, and I hope that you support Senate Bill 937.
Senator Kushner.
Thank you. I think one of the comments today from previous testimony that hit me the hardest was firefighter Clarkson Pereira. I hope I said your name correctly. When she testified that a firefighter with cancer would do better falling off a ladder than living with the cancer and fighting the cancer. And I just thought that was a very stark statement that sort of brought it to home for me. There's been quite a bit of testimony against this bill from CCM and Costin, from Bill Adamson, and people that I know because you and your union was very active on the task force last year or 2 years ago, I guess it was. But I have a question. Can you tell us if I've been trying to get this issue of what are the benefits that you would get under workers' comp that you don't currently get, first of all, from the Cancer Relief Fund, if you could just start with that.
Sure. Currently, the Cancer Relief Fund is going to be solely a wage replacement benefit. It affects firefighters across the state different, whether they're career or volunteer. And the position of career, several of the contracts that are negotiated will clearly define how their sick leave can work in regards to wage replacement. Unfortunately, cancer can cause an extended amount of leave from the job, so that, you know, it could go past their accrued sick leave or contractual benefit of sick leave, and then they would have to rely on the fund. Opposed to a workers' compensation avenue, if we compared it to, I believe, what you had said, falling off a ladder, if you had a leg injury, we're talking about instantaneous health benefits for the injury, wage replacement, and no real trying to see, I want to phrase this so it falls on the lines of the legal process for workers' comp, and I don't want to misspeak by any means, but workers' compensation will identify and cover the injury throughout your career and post your career if that injury continues to take affliction on your health. So that's one major aspect of it. There's certainly a lot of other aspects of it, because if the injury, whether it be falling off a ladder or cancer, causes it to be a career-ending case where a firefighter may be permanently disabled, then again, workers' compensation would be able to cover that fully. Currently, the fund will not provide any coverage for that, up to and including identifying the reason that you're retiring for. So one of the biggest items that we like to identify as firefighters is our stature of what we do. I mean, we do it in a prideful way because we're serving the community. And what we're looking at here is taking an affliction that several other states, several scientists and across the world are identifying and saying, you're getting this affliction from the job. But here in the state of Connecticut, you have to leave your work because you can't do your job anymore, with no indication of saying, we're sorry, you have a line of duty injury or a line of duty illness. It's very, very hurtful.
And you mentioned previously about a line of duty death. And what would be the differences between if you fall under workers' compensation, it's considered a line of duty death if the firefighter were to die from the cancer? And what are the differences between the benefits that the firefighter's family would receive in that case under workers' comp and from the firefighter's cancer relief fund?
So currently, the Cancer Relief Fund wouldn't provide any benefits at all. That's the easy portion of it. Unfortunately, there's no benefit. It's simply there for wage replacement. And once the firefighter with disease, if a firefighter has to pass from the cancer, then there are no associated benefits that would be awarded to the survivors, opposed to any type of other line of duty injury that would either permanently disable or cause you to pass, like a structural collapse or passing in a fire. You would fall both under benefits afforded to you by workers' compensation, which would continue health benefits for your dependents, but also identify other aspects of your pension benefits that the municipality may be responsible for contractually through Sydney ordinance. So one example would be, I'm a fire lieutenant in the city of Danbury, and if I happen to pass on the job, then I would be my family, my survivors would qualify for line of duty benefits, an injury sustained or passing sustained in the line of duty, and they would continue on health benefits and pension benefits. Opposed to if it was cancer, none of that would apply.
Thank you. That was really helpful to have it stated so clearly. My last question, I apologize. I know I'm taking a little more time, but I know you can answer these questions. And we had testimony that there are insurance, I think you can answer this one, but there's insurance policies that could provide equal benefits that would be cheaper. And, I don't know if you are familiar with those. If you're not, I guess the only question I would have is if we could find a cheaper way to provide all of the benefits that workers' comp were to provide, would there be any other reason why we shouldn't go that route?
I think that what I discussed in my written testimony and in the testimony today is that we had debated this for a long period of time, and we discussed this, and we tried to come up with alternatives to make this as cost effective as possible, even knowing that we can't put a price tag on what the expected CIRMA or insurance costs would be for a municipality. So with that being said, I think we looked at other viable routes, other viable patterns, and everything is to this point not fulfilled. And we can't sit idly by as our firefighters continue to get cancer. I believe you're going to hear further testimony today, speaking to specific individuals that have unfortunately are losing their battle with cancer. And we have to provide for them. And this is the fight and the path that we have to take.
Thank you. And before I let you go, before I conclude, I just want to say thank you. I am a resident of Danbury, as you well know. And so I want to thank you personally for everything you do for our city to protect us and keep us safe. And should I ever need the services of, I actually have needed the services one time when a wire fell on my property and was sparking, and you guys were there very quickly. And it's always a real feeling of security when you're on the job. So thank you so much for your service.
Thank you.
Any further questions? Seeing none, thank you for your testimony.
Thank you.
Thank you. Up next, we have Jacqueline Baez. I'm sorry if I'm Baez, okay.
I'm sorry. Oh, you gonna test it?
No. For the board.
Please mute. Thank you.
Hi, good morning, ladies and gentlemen of the Labor Committee, Co-Chair Representatives Sanchez and Co-Chair Senator Kushner. My name is Jacqueline Baez. I live in Waterbury, Connecticut. I am a domestic worker and a leader of Comunidad de Trabajadores Domésticos, a member organization of Nagatu Valley Project. I speak in support of the House Bill 5854 and act to will increase the number of wage of our inspector at the DOL to investigate wage theft cases. Here are some of my experience. I clean houses. I love my job because I told my boss we need a break after some hours of work. I clean 4 houses daily. The boss will pick me up at 6 in the morning and I return back to my house at 6 p.m. She told us no breaks. She says that's the drive from one house to the next one was our break. We have to eat our lunches in the car from one house to the other one also. I was never paid for extra hours working overtime. There were many times when she will keep the tips from the people, for tips from people whose houses we cleaning because she says she's the one who has contact with the customers. This past House Bill 5854 will add more wages in our inspector to the Connecticut Department of Labor. That will be very good for domestic workers, as will we have more support to file wage theft cases and more support while we were waiting for the cases to come before the Department of Labor. Thank you for accepting my testimony today on behalf of Nagatu Valley Project. I want to thank you for work in expanding the rights of domestic workers. You have any questions?
Thank you. Any questions? Nope. Seeing none. Thank you for your testimony.
Thank you.
Up next, Meryl Gay.
Senator Kushner, Representative Sanchez. Thank you for this opportunity to testify on House Bill 5858 that would establish a system of FSA dependent care savings accounts that would be administered by the state for all of the families who don't get access to this benefit through their employer. The most recent research I've seen shows that about 45% of families of workers have access to this type of account that enables them to pay for childcare with a pre-tax dollars. So if you take, for example, a family that earns $100,000, their federal tax rate is 22%, their state tax rate is 5%, so they're paying 27% of their earnings in taxes. If they can put $5,000 into an FSA and use that for childcare, they don't pay taxes on $1,350. That's the benefit to them. So this is a relatively inexpensive thing for the state to help address a major problem for families, that childcare is just too expensive. And ironically, childcare is too expensive while the people who do the childcare barely earn a living wage, barely earn minimum wage. So I would like to encourage you to support House Bill 5858, the bill to create an FSA. Be happy to take any questions.
Thank you, Merrill. Any questions? Representative Acker.
Good to see you, Merrill. How does
Twice in one day.
Yeah, there you are. Just comment. So how do you think this plays together with already some of the like Care for Kids program, or how do these get ministered together? Do you think those that don't have opportunities for Care for Kids would benefit from this?
Yes. So most of the people who currently get this benefit are people who work in large companies, insurance companies, et cetera, where they have a good employee benefit plan. I was able to make use of one when my children were little. My wife worked for a union that had a good benefits plan. The issue is that only 45% of the population has access to this. Lots of people who work in small businesses or who are self-employed don't have access to these kinds of tax benefits, the FSAs. So the way that it would work is the state already administers an FSA program for state employees. So the systems all exist. It's not hard to then set up a way in which employers outside of or employees could deposit funds into an FSA to be used for those pre-tax payments for childcare. With Care for Kids only serves families up to currently 60% of state median income, but it will revert back to 50% of state median income. And that leaves out lots of families who struggle to pay for childcare. And when you think about the cost, typically families are paying $12,000 to $14,000 for pre-K and $14,000 to $17,000 for infant toddler care. So this is like a month of free childcare. That's the equivalent. That's how big a benefit this is. It doesn't solve the problem, but it's a good step forward, and it doesn't cost the state that much. The state would forego $250 of that of tax revenue that would normally have been paid on the $5,000 worth of earnings, and whatever that small cost at the comptroller's office for administering the program. But in return, we're getting back $1,100 per family from the federal government in avoided taxes that could be used to pay for childcare.
Thank you, Merrill. And I do see the language says the Commissioner of Labor Commissioner to establish. So I think,
okay.
But I think no, it's not going to go there. I'm pretty sure that because she's already testified, like, I don't have anybody and I can't do this, and it's not in our wheelhouse. So I think there's another area, maybe either OEC or your comptroller's office or something. So thank you for your testimony.
Yeah, thanks.
Any further questions? Seeing none, Merrill, thank you so much.
Thank you.
Next up, we have Wanda Ferreira.
Ferreira.
Okay, I apologize. Thank you.
That's okay. Hi, how's everyone?
We're good.
Good afternoon.
Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackard, and the distinguished members of the Labor and Public Employees Committee. My name is Wanda Ferreira. I live in New Haven. I am a member of Unite Here Local 34 at Yale University. Thank you for this opportunity to testify in support of Senate Bill 938. Before Local 34 went on strike in 2003, our wages were far lower than they are today, and our pension was much smaller as well. We got raises, but our pay was so low that the raises didn't help much. When I went on strike, my family was in a period of transition. My husband and I had recently gotten married. I had a 19-year-old son who was fresh out of high school, and I was pregnant. My husband had been employed by a company which had just closed and was trying to find a new job and a new stable job. During the strike, I was lucky to have a supportive family and husband who worked, but losing my wages was hard on us. We could call our mortgage company and utilities and say we were on time of hardship, but that was only temporarily. Unemployment benefits would help to carry us through that time. At that point, I had already been at Yale for 8 years. We had previously been on strike in 1996, but the strike in 2003 was the first time I truly felt part of a strike. I talked to many of my coworkers about striking and described to them what we were fighting for better wages, steps increase, good pension. However, the fear was difficult to overcome and kept some off the picket line, even though they supported our goals. These workers were scared to lose access to an income because they were sole providers for their households and had husbands and children at home who needed their income to survive. Having unemployment benefits for workers on strike would have made it possible for those workers to join the picket line. When workers go on strike, we aren't looking to live off our strike pay or unemployment benefit. We just need something to carry us through until we settle a contract with higher wages and wages like we did in 2004. I remember the feeling of victory when I saw my new weekly paycheck with gain we won from our strike back then and today. I know winning in 2004 was life-changing for me and my family and set Local 34 on a trajectory towards the standard we have today. Some of the best wages, healthcare, and pension benefits in this country. All workers should feel like they have power to fight for good wages and benefits like we did. And I urge the committee to give Connecticut workers the chance to do something by supporting Senate Bill 938. Thank you for my opportunity to testify. Any questions?
Thank you, Wanda. Any questions? Seeing none, thank you for your testimony.
Thank you.
Next up, we have Aaliyah Villana. Next up, we have Kyan Stewart. KM. I apologize if I'm not pronouncing that correctly.
Good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor Committees. My name is Kyan Stewart. I live in Hartford. I am a certified nurse's assistant at 3 nursing homes: Windsor Health and Rehab in Windsor, Kimberly Hall in Windsor, and Trinity Hill Healthcare in Hartford. I have worked in nursing homes for 4 years, and I love the work that I do. I come before you today to testify in support of SB 938. As a CNA, my job is to take care of my residents and to make sure their needs are met. We attend to residents' hygiene, helping them shower and bath themselves. We feed residents and we ensure they are eating enough and staying hydrated. I love my residents and I will act a fool if I must to make them happy. I will sing for them. I will make jokes with them and do anything I can do to make them smile. It's not in our job descriptions, but CNAs also care for the mental health of our residents. Many residents don't see their family for weeks or months at times. So while we are not related by blood, my residents are my family. The decision to go on strike was not an easy one. Our first concern was our residents. Were they still going to receive the care they deserve if we weren't there? Our next immediate concern was for our families. Many of us have elderly family members and children that rely on us. How would we get by paying our bills and provide for our families? Bosses depend on this fear to manipulate and exploit us. This unfair dynamic allows for caregivers like myself to be taken advantage of and forced to work in unsafe conditions for poverty wages. That is why my co-workers and I decided we need to take a stand. And in April of last year, we went out on strike. We struck not only so that we could have respect and dignity we deserve as workers, but that the next generation of caregivers could work in better condition than we do. Being on strike was scary. Every day for the months we were on strike, we had to face the uncertainty of how we would continue to pay our bills and survived. We were fortunate that our union 1199 helped to support us, but even with their help, we struggled to make ends meet. If my co-workers and I had access to unemployment benefits, we would have been more confident and exercising our rights as workers. The weight of supporting our families and children would have been so crushing, and we would have been able to find more peace of mind as we fought for our dignity. Please pass SB 938 so that workers across the state can stand for themselves and their families without the fear of financial ruin. This is the right thing to do and will lead to more just society here in Connecticut. Thank you.
Thank you. Any questions? Representative Hughes.
Thank you. Thank you very much for your service on behalf of the community. I see you. I worked alongside you in the group homes back in the day, and I thought about you every day during the pandemic when you were risking your lives. I think that the pandemic has taught us, like you alluded to, that we cannot take this workforce for granted, or your dedication for your clients on behalf of their lives, that you are literally a lifeline. And now we have to protect you as that lifeline. I just wonder, is there anything else that you can see that this committee has before us that would help increase the workforce, that we have a crisis facing us in terms of the essential workforce right now? Anything else that you would recommend that we consider?
Honestly, short of staff also is an issue. And most of the time, it's very difficult because we are short staff. Couple days ago, it was 3 CNAs to 60 residents, and that is hard.
To 60?
60. And that is hard. And I'm gonna be honest, but I think employees, to me, they do like they care, but they don't care. We do care. And it was 3 of us, and we did our best, because it's not about us. It's not about the employees, it's about the residents. And as I said, they don't see their family members like for weeks, for months. So we are their family and we love them. So yes, we are tired, but we do our best and we take care of them. And it's not fair for residents to go through all of that, because that's their home and they need to take care of the way how they are supposed to be taken care of. So it's not fair for them. And I think if employees were like getting fines for short staff, maybe they will do a little better. That's what I think.
Employers, you mean?
Employers, yes.
Okay, great. Thanks. So that wage inspection is really critical at the Labor Department to enforce that kind of safe ratio that you're talking about.
Yeah.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Eckert.
Thank you for being here.
Thank
Great
you.
testimony, by the way. Just want to let you know. Sometimes you can get scary to get up there, I can imagine, but you did a great job.
Thank you.
How long was your strike for? How long were you
It
out?
was like for a month.
It was that long?
Yeah.
Is that when, this was last year?
Yes, it was last year, April.
Last April. Okay, because I asked earlier testifiers that we really haven't had long, and that's hard because and I mentioned earlier, our constituents, those that you serve, were also put in a tough situation. They're not getting served by the good staff that you and your colleagues do their job. So I'm just curious to see how long that was. So did you get what you were looking for in your package to get a better wage and better benefits?
Yes, we got what we wanted.
Good.
But we had to stand, and it was really scary for us, but we had to stay out there and stick together to get what we want. And as I said, it's not only about us, but it's about the younger generation that is coming up too.
Yeah, it's a needed workforce. We're not getting any younger.
Yes.
We need workers too. So
Yes.
thank you for being here. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Seeing no hands up on the Zoom. Thank you so much for your testimony.
Thank you.
Up next, we have Barbara Vereen.
Hello?
Yes, we can hear you.
All right, I just need to pull over. Sorry about that.
Please be safe. Yes.
Yes, I'm over. Okay, just gotta put my glasses on. Okay, so my name, oh, sorry, give me 1 second, just gotta pull. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Eckert, and distinguished members of the Labor and Public Employees Committee. My name is Barbara Vereen. I am a New Haven resident, and I am currently the staff director for Unite Here Local 34. And I am here today to testify in favor of SB 938. I grew up in New Haven watching our city lose many good union jobs, such as factories like Olin shut their doors. I was fortunate enough to get a job at Yale University with Local 34. And to make ends meet, I also worked as a proud member of 1199 in the nursing home at night. 11 to 7, I had to put my kids through college. I participated in strikes as a member of both unions. I am proud to say that Local 34 has one of the best standards for CNT workers in the country, but that always wasn't the case. We organize and we fight to get our current standards. And that meant going on strike contract after contract. Striking is never something that workers want to do. It means a hardship. It means a hardship. I'm a single mother of 3 boys, and this was a very difficult decision for me. I knew that I still had to stand up for the long and look at our long-term future. I had to face my fears and join my coworkers on the picket line. The longest strike I participated in lasted for 28 days. During that time, I had to figure out how to support my family while we were on strike. And our strike pay was $200. So that really created a hardship because I couldn't pay I was already working paycheck to paycheck, and it was hard for me to even make ends meet. This is a significant sacrifice for anyone. It was a significant sacrifice for everyone in my household. Unemployment insurance for striking workers will have dramatically changed my situation. I am happy to say that the strike worked. Through our fight, my job allowed me to put all 3 of my sons through college and to buy my own home. I'm a first-generation homeowner. I have access to affordable health care, and I can retire with a pension from both jobs. These are things that every worker should have. I am happy to report that Local 34 has settled the last 4 contracts without a strike. Conflict motivated Yale University and the unions to figure out a better way to solve problems. We still have to campaign and organize, but just the threat of a deeper conflict motivates us to settle contracts peacefully. I imagine that this bill will actually reduce the number of strikes by making conflicts fairer. Yale University has billions of dollars and can weather the storm of long conflicts with workers. Single mothers in Local 34 don't have that luxury. But if employers know that they are playing on a more even playing field, they will be less likely to push their workers out on strike. They will be more willing to accept standards that pay fair wages and benefits without conflict. In a state with such deep inequity, we need a fair playing field for workers, and we need better jobs that give working people a chance to live in dignity. Thank you.
Thank you, Barbara. Any questions? Okay, seeing none. Thank you for your testimony.
Thank you.
Take care. Next up, we have Jennifer Brown.
Good afternoon, Senator Kushner, who stepped out, Representative Sanchez, and members of the Labor Committee. My name is Jennifer Brown, and I live in Manchester, Connecticut, and I work as a direct support staff at Sunrise Northeast. I've been working in the industry for over 25 years. I'm here today to urge you to pass SB 938 and give striking workers access to unemployment benefits. As a direct support staff, I care for people with developmental disabilities and intellectual disabilities. I do everything I can for my clients. When you work in a group home, you become their families, okay? You become their doctors, their nurses, and their friends. When they're sick, we have to figure out why they're sick. When they're crying, we have to figure out what's wrong with them, why they're crying. When we go on vacation, they misbehave because they miss us. Like I said, we become their family. And that's the one thing I love most about my job. With that said, group home workers are not appreciated or respected in Connecticut. Working conditions in group homes are incredibly poor. We work long hours, understaffed for poverty wages. It's really below poverty wages. This work will test you physically and emotionally, not to mention the added stress of struggling to make ends meet outside of work. Even when the legislators allocated more money more funding for group home services, we cannot get the group home agencies to invest their funds in the staff wages and benefits, and ultimately the client's care. Finally, my coworkers and I had enough and decided to go out on strike to achieve the change we needed for our clients and that we deserve. Before we went on strike, I would have to pay $6,000 a month. I don't make $6,000 a month for health insurance. Furthermore, I have only gotten one raise in 15 years, and it took a fight. Like many group home agencies, Sunrise would not recognize our concerns or act upon them. Striking was the only option we had. And even then, it was a hard choice to make. My coworkers and I were nervous about not being able to make ends meet, how we were going to pay the bills and feed our families while on strike. We were fortunate to have the support from our union 1199, but even then it was hard. We were angry, we were stressed out, we were depressed, and every day had to face the financial challenge on being on strike. If we had access to unemployment benefits, this wouldn't have been that case. We could have exercised our rights to strike as workers without fear of not being able to feed our children. Right now, the dynamic between workers and employers favor the employers and empower them to exploit the fears of their workers in order to underpay them and provide them with little or no benefits. The bill will help balance the scale and allow workers to go on strike without risking a financial crisis at home. Please pass SB 938. Thank you for your time. Any questions?
Thank you.
Yes.
Any questions? Senator Kushner.
Thank you. It's so good to see you here.
Yes.
I saw you a few times over the past few years, and particularly when you were on strike, I was able to meet you. And I wonder if you could share with us a little bit. First of all, how long was that strike?
We were out for 3 months.
That's what I thought. It was a very long time.
Yes, it was.
How did you manage?
A lot of hope, a lot of prayer, a lot of talking, because I led the strike and in Hartford. And I think most times we had about 50 people out there, but we were also in other sections of Connecticut. And a lot of talking to my coworkers because they were fearful. And even though I was fearful, I couldn't show it because I had to let them know when you stand for something, you gain everything. And we were out there from 6 in the morning to 8 at night. We were chanting. It was something we had to do, you know, and it was not easy. I had a few go back inside. I pulled one back out and let her know that when you stand together, you can gain whatever you want. We didn't get everything. We're still working on insurance and we still didn't get a lot, but we gained a lot too.
Can you tell us a little bit about what you did win in terms of, was it a wage increase that you won or?
So I have been at this job for 25 years. Somebody coming off the street working with me make the same thing after 1 year. We now have a pay scale. My daughter work alongside her with me. She's been there 12 years. You know, the thing is we work and we take care of the vulnerable 365 days of the year. I have coworkers who don't have insurance. I don't work one job, I work 4. I work 3 1199 agencies. I had to leave one because I couldn't afford the insurance and go to another one where I can get the insurance. I have to bid, I have to bob, I have to hustle. So I work literally 95 hours a week. I worked 3rd shift last night. I came here at 9 this morning. I have to be to work at 5. I told them I'm gonna be late because this is important. And, you know, I do what I have to do to survive.
Well, we'll try and get you out of here so you have at least a minute to take a breath before you go back to work. I remember one thing I think that's important for us to know about, which is that the company you work for, Sunrise, if I remember correctly, they are not based in Connecticut.
Yes, they're based in Florida. I think that's the number one reason we don't get everything, you know. We have people here, and like I said, I've been there 25 years, and it didn't used to be so bad, but now you can't afford insurance. Although we got a little raise, we don't see it with everything going up, economy going up, we're still stuck. We're still stuck. And, you know, I have coworkers who have no insurance. They can't do, you know, I'm 57 years young. I do what I have to do, but everybody can't do that. They only have to be stuck. And, you know, they work a little bit so that they can still receive state insurance.
And
It's
am
unfair.
I correct too that I think I remember that that other similar companies where there's money coming from the state, we should also recognize that
Yes.
Sunrise gets money from the state
Yes.
to perform these services in our communities. And there are many other companies that settled without any strike and gave
Yes.
the workers the raises in other places, but Sunrise held out and would not settle. So if I've got this right, the state is subsidizing a company that's not based in Connecticut that is taking advantage of workers whose coworkers in another place are getting the raises, but they're denying them to people that they, I guess, increase their profits in what they keep in Florida.
That's
Is that correct?
That's correct.
That's
That's
what I
it.
remember.
Like I said, it's a drop in the bucket. So here's how I look at it. Journey Found is another private I work for. It's $11.99. I had to go and take a full-time there because I can afford their insurance. Their insurance for a single person, because my children are now grown, they're have their own insurance. Their insurance is $115 opposed to $2,000 and odd dollars at Sunrise.
Wow.
You understand? So nobody can afford insurance for Sunrise. And we keep just being stuck.
So would it have made a difference had you been eligible for unemployment after 2 weeks out on strike? How would that have affected you in your life during the 3-month strike?
Oh, it would a big effect because, so I'm grateful the union was able to help us out. But again, when you're used to working 80 hours and you get a paycheck, the union helped. It wasn't a paycheck, you know? So when you go and you stand out there and you chant and you be there for your days that you're supposed to be, you know, you get a little subsidy so that you can put a little food on your table. We have people who you had to cut back. You had to cut back on your cable. So no cable for the 3 months, but we still had a roof over our head because we had $11.99 helping us along the way. But if you could get unemployment, you know, you don't have to, some people had to go pick up jobs. I know a few people went to UPS so that they can not lose their homes, not lose getting back on car payments, because when you get into a hole, it's hard to catch up. It's hard to catch up, you know? And so it would help a lot if we was to go on strike again, if we was able to get unemployment.
Thank you so much. And
Yes.
thank you for being here today. And thank you
Yes.
for everything that you do every
Thank
day to
you.
care for our community.
Thank you.
Representative Hughes.
Thank you, Madam Chair, Mr. Chair. I just wanted to reiterate, this particular strike was so long partly because Sunrise is headquartered and domiciled in Florida, which I believe is a right to work state. So states that make it incredibly difficult for workers to unionize, to collectively bargain.
Yes.
They're holding out because they've normalized exploitation of individual workers, which we subsidize by trying to send these nonprofits or providers, profit or nonprofit, state resources or ARPA dollars to make sure that these vulnerable folks that you serve are taken care of. And then they're using it to go to profits and, you know, putting you out on the street, just bargaining for crumbs, what feels like to me for crumbs, just a livable wage, healthcare, and some kind of retirement protections. And that should be what every worker has a
Yes.
right to. Every worker has, and you
Yes.
shouldn't have to go out on the street for that. So I just wanted to underscore what Senator Kushner said, that that we are taking on out-of-state corporations with this bill. And I think that that would be effective towards saying not in Connecticut, you can't get away with that.
Yes, that's beautiful. Thank you.
Anybody else? Okay, thank you for your testimony.
Thank you.
Thank you. You got the projector right in front of you. Next up, we have Phyllis Frazier. Thank you. So it's written testimony for the record. Thank you. Next up, we have Diana Sanchez.
Hi, good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor and Public Employee Committee. My name is Diana Sanchez, and I'm the Regional Coordinator for the states of Connecticut, New York, and New Jersey for the National Day Labor Organizing Network. We have over 60 member organizations throughout the country, and 2 of them are in the state of Connecticut, including Unida Latina Connecticut and Building One Community. I'm here urging you to support House Bill 5854 to increase the number of wage and hour inspectors at the Labor Department. It's super critical for you to understand the importance of this. We get thousands and 100,000s of complaints every year of members organizations where workers go and they share their stories about wage theft, right? Obviously, the first time they go is they connect with these member organizations or grassroots organizations throughout the state. After that, the organizations have to support in filing these cases to the Department of Labor. And of course, fear comes amongst this, right? And as I sit here hearing testimonies, not only from workers and organizers, and also hearing even the strike, I start thinking of how much work there has to be done for, especially for employers and bad employers who get, a risk, like they just get to pass. So I urge you guys to understand that in order for workers and in order for the economy to continue, because once people go on strike, once workers also lose their jobs, you're seeing that this is not only affecting them in their household, but it's affecting economically the whole economic system of the whole state and country. So I urge you to do this. And one important thing to realize is that you have a great community that not only speaks Spanish, not only speaks English, you have different languages. So one important thing is for you to support it and to invest in also hiring workers who can speak directly to workers who are going through this process. Again, it's an urgency that you do this. As far as the longer you take to hire, the longer you take for direct workers to connect to the actual victims of all of these bad employers, then it's going to be harder for them to go back to work, for them to trust to go back to their labor that they've been working. So I urge you on that. I hope that you do support that. And I stand in solidarity, obviously, with the strikers and all the workers, especially to have more than anything, more support through organizations, local organizations who could affiliate with the Department of Labor and make it accessible for the member organizations and grassroots organizations throughout the state of Connecticut. Thank you so much.
Thank you. Any questions? Senator Kushner.
Just a quick thing that in your closing remarks, you mentioned connecting with the grassroots organizations. And I am proud of the work that this committee and the whole legislature did along with the Department of Labor last year to really invest in these organizations that have trusted relationships and can communicate to workers what their rights are. And I appreciate your role in that and your encouragement of that, because we really do need to make sure that workers know what their rights are currently under the law. We don't want to see anybody's rights abused. So I really appreciate the work you and your organization have done to help promote that. Thank you.
Thank you, Senator. Any further questions? Seeing none, thank you, Diana, for your testimony. Next, we have Rebecca Corbett.
Hello, can you hear me?
We can.
Hi. Hi. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, and the distinguished members of the Labor and Public Employees Committee. My name is Rebecca Corbett. I live in New Haven. I worked for 24 years as a member of Unite Here Local 34 at the Yale School of Medicine before retiring, and I still work there part-time. Thank you for the opportunity to testify in support of Senate Bill 938. When I went on strike in 2003, I was terrified. I had 3 children at home. I was afraid I wasn't going to be able to pay my monthly bills. I was afraid I might lose my job entirely, which would mean losing the health care that I received from Yale. At the time, I was receiving state benefits despite working at Yale 40 hours a week and sometimes more. I worried about losing my benefits and my housing, which would have left myself and my children without a roof over our heads. I had been homeless before and did not want to end up back there at that point. I had been working to get off welfare and create a stable life for my family. But it wasn't just me that was scared. Even my coworkers who had spouses bringing in a second income were worried about the consequences of going on strike. People were afraid of getting behind on their mortgage payments and losing their homes. Just 1 week of loss of income could potentially mean disaster for some people, and we were on strike for 3. Having unemployment benefits while on strike would have given my coworkers and I a safety net while we fought for a fair contract. However, what we won by going on strike was life-changing for me and many others. Thanks to the contract we won, a few years later, I was able to buy a house in New Haven that I have lived in now for 10 years. I'm able to help support the families of my now grown children. And now that I'm retired, I'm receiving a defined benefit pension that allows me to help my children and their families. My daughters are in their 30s and have families of their own and struggle to find jobs with good wages and benefits. I believe that unemployment benefits for strikers would empower them to fight for better working conditions for themselves if they needed to, or even for an initial union contract. I also believe that unemployment benefits will make companies negotiate differently if they know that striking workers have support available to them. I know from personal experience that going on strike takes courage, but that by striking, workers can win life-changing victories. These victories are the key to greater prosperity and more rights for workers in the state of Connecticut. I urge the committee to support workers by supporting Senate Bill 938. Thank you for the opportunity to testify.
Thank you. Any questions? Seeing none, Rebecca, thank you so much for your testimony.
Thank you.
Next up, we have Pam Barnett. Nope, take your time.
Good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor Committee. My name is Pam Barnett, and I'm a member of the Teamsters Local 671, and I work as a seasonal school bus driver for the CREC East Hartford Yard. I have been in the field for 15 years as a seasonal bus driver that returns every school year. A month before school starts, we are trained in safety protocols like railroad crossing, child pickup, child drop-off, child checks, bus inspections, and road skills. Seasonal workers are ready day one for the first day of school, whereas the company does not have to lose another month to retrain a brand new driver and have startup issues that begin at the beginning of the school year. I am here today to support the proposed Bill 197 and ask for you to consider helping seasonal school bus drivers and others like us to be treated fairly. School bus drivers are laid off during the scheduled school year. I support the Bill 197 as it will help increase hiring and jobs that will give good pay benefits and ensure school bus drivers return rested and ready for work and drive our kids to school safely. School bus drivers and companies we work for and employ thousands of us strongly support Bill number 197. I urge you to please support Bill number 197 and act concerning unemployment loans related to COVID-19 and work with our workers and companies in our seasonal industries to fix the unemployment insurance fund system before it goes into effect in 2024. Thank you for the opportunity to testify today. I would be happy to answer any questions you have. Sorry, I'm a little nervous.
You did just fine.
Okay.
You did great. Any questions? Senator Kushner.
Just thank you for being here and testifying. You know, I am aware that unemployment benefits don't exist for certain categories of employees that have the ability to return to work. And I just wanted to say that I think that's unfortunate. It wasn't always the case back when I first started working in the 1970s. If you were laid off for the summer, you actually got unemployment benefits. And it's unfortunate that that practice was changed, because I think it's a mistake not to compensate people when they are on a seasonal layoff. So I appreciate what you do, and I appreciate you coming to testify for your company here to get some help.
You're welcome. Thank you.
Any further questions? Seeing none, did great. Thank you.
Thank you.
Next up, we have Sam Saunders.
Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Eckert, and members of the committee. My name is Sam Saunders. I'm a member of the Teamsters Local 671 and work as a seasonal construction worker with Tilcon. I'm here today to support proposed bill number 197 and ask for you to consider helping improve the law to help seasonal workers before the new unemployment insurance reform law goes into effect in 2024. As I work in the construction and material industries, I strongly support Bill 197 as it will help to increase hiring and incentivize employers to provide good paying job opportunities to work. I've worked construction for approximately 24 of my 35 years driving. Unemployment is a means to stay current with our expenses. Construction workers are at the mercy of weather, not knowing when work will resume or come to an end. Finding experienced skilled workers is a challenge, and if you have them, it is important to retain them. Without workers returning, work would be slower and put more lives at risk. As seasonal construction worker, we laid off each year when our construction season ends. This is part of the New England weather that occurs every year. My employer and others in the construction industry depend on the trained workforce to come back in the spring each year to get the Connecticut projects up and running and completed on time. Those industries who experience regular seasonal layoffs each year because of the availability of work should not be penalized at unfair rates versus companies that pay lower benefits and lower wages to their employees. Thank you for your opportunity to testify today. Yeah, ask any question if there's any questions.
Thank you. Representative Eckert.
Thank you for being here and thank you for what you do. My relative has a trucking company and does the same thing, shuts down. Has it changed with what's going on in New England nowadays with the shutdown? Is it delayed? Is it still predicted, December 1, plants close, you're off the road? What's it like right now?
Well, basically, you would think with the weather, especially this year, that work would go on. As a steward, I work a lot of the year. I still have time that I don't get to work, so I do a partial claiming. But companies shut down for multiple reasons. One, you don't want to open up the ground and then all of a sudden have everything change. As far as the asphalt plants, we shut them down. The last one closes down around the middle of December. After that, it just doesn't stay. As you see when they patch the highway out here and the next 3 cars go by and the hole's right back there again, it's all over everyone's car. So basically there's one other company that opens up 1 day a week that I know of around here. And that's just for emergency patches. They have what they call cold patch that goes down and it's a temporary fix. But a lot of it has to do with the weather. And we do a lot of work for the state and federal. And they have guidelines where I believe it has to be 45 and rising, the road temperature, or we can't pave it. So you would think with the weather changing, it would, but companies shut down for that reason. They also shut down because a lot of the guys are burned out. I mean, when the season kicks in, that's when we go, and we don't take vacations, and, you know, you work all summer long from whenever the season starts. We're looking at hopefully bringing most of our guys back in March, we hope, if we get a contract. We also are dealing a lot now with outside contractors, out of state contractors that come in and take work away from us. So it varies. Like you said, in the past, yeah, we would shut down on December 15th, and you're not getting a call back till April, middle of April. It's just, that's the way it was. It has changed. A lot of our guys do get called back for a week here, a week there. I got a bunch of my guys working this week because we have to supply sand to our concrete plants because they're still pouring, and we got big jobs going. So it does change, but it's you can't rely on going to work every day.
Thank you, and thank you for being here.
Thank you.
Thank you. Any further questions? Seeing none, thank you for your testimony.
Thank you.
This time I'll let Senator Kushner take over the rest of the public hearing.
Thank you. Next up, we are going, I see that Megan Fountain is on the list, but she is going to be translating for some of our other witnesses. So I'm going to move next to Mr. Pete Brown, President of the Uniformed Professional Firefighters Association of Connecticut. Good to see you, sir.
Good to see you. Thank you to the chairs and the committee members for taking the time today and listening to all this important testimony. My name is Peter Brown. I'm a 25-year member of the Norwalk Fire Department, and I serve currently as the president of the Uniformed Professional Firefighters Association of Connecticut, which represents about 4,000 firefighters from across the state. I'm here today in support of Senate Bill 937, an act providing workers' compensation benefits for certain cancers in firefighters. While I could share additional statistics and data on rates of firefighter cancer, I think my colleagues have already done a pretty good job with that. Instead, I wanted to share a story about a friend and coworker named Craig Saris. Craig and I started on the fire department together on the same day in 1997. We were both a lot younger, full of life, and excited to start our new careers. Over the years, I had the honor of seeing Craig work tirelessly for his department and for the community he was sworn to protect, and just saw the dedication he brought to the job. About 3 years ago, Craig was diagnosed with an aggressive form of kidney cancer, which had unfortunately spread to other parts of his body before it was detected. He was 49 years old at the time, with a wife and 2 small children at home. Craig never complained about his cancer. He only wanted to keep doing the job that he loved, and he wanted to spend as much time with his family as he could. Over the past 3 years, Craig's fought extremely hard, receiving numerous treatments and several surgeries, hoping to rid his body finally of the cancer. Throughout all the treatment and hard days, Craig never complained. He continued to work, and he wouldn't let fellow firefighters feel sorry for him. Fortunately, a couple weeks ago, Craig was informed that the treatments were no longer successful, and there was nothing more they could do. He was recently placed in a hospice facility where he's been surrounded by friends and family, and all he continues to do was speak about the job and how much he missed everyone. In a recent conversation I had with Craig, he told me the hardest part about his diagnosis was talking to his family. He said, the pain and suffering of surgeries was nothing compared to sitting down and telling his family that he wasn't going to be with them any longer. Throughout his battle, Craig never cared about how this was affecting him personally. He only wanted to make sure that his family was protected. I could tell you as a union official, the hardest thing for me was telling him I don't know when he asked me if everything was going to be taken care of for his family. I told him that we would never stop fighting for them, but without line of duty death protection under workers' compensation, nothing is guaranteed. Craig would have liked to be here to tell his story personally, but his health had deteriorated over the last week or so. We knew it wasn't going to be possible, and I'm sorry to say that we were informed overnight that he had passed peacefully in the facility, surrounded by friends and family, thankfully. Craig's story's not unique in the fire service, but I hope we don't just pass by it. Hundreds of firefighters die from occupational cancer every year. In Norwalk, we lost another friend and coworker a little over a year ago to occupational cancer. Firefighters knowingly put their lives on the line in order to save others, with the understanding that they'll be protected if they are seriously injured, and their families will be protected if they die in the line of duty. We need those protections to extend to occupational diseases like cancer. In the long term, we need to stop or slow the exposure to dangerous PFAS chemicals and other known carcinogens to hopefully reduce rates of firefighter cancer. But until then, it's imperative we finally pass presumptive cancer legislation under workers' compensation here in Connecticut. It's definitely overdue. Thank you, and happy to answer any questions.
Thank you, Pete. And before I turn to my colleagues to see if they have any questions, I'm so sorry for your loss and of your friend and colleague. And it's not the outcome anybody would want, but it does reinforce what we've been hearing here all day, the importance of the work we're doing to make sure that firefighters and their families are well taken care of when they risk their life to take care of us. And so please pass on our condolences to his family. And hopefully this year, we will pass a bill that will give you the assurance that you can tell firefighters, a colleague, a friend, a comrade, tell them that their family will be protected. That is our goal.
Thank you for that, and I will. And I just want to thank you all for your work on this issue over the last few years as well. I know it's difficult work, and we appreciate everything you've done, and hopefully everything you will do for us.
Thank you for that. Any questions from my colleagues?
Thank you for your advocacy for those that you serve, and thank you for your service to your community. I can't imagine doing your job at all, and my condolences to the family and to all his colleagues.
Thank you, Representative.
Thank you so much. We did, I think, have just
Oh,
before you go,
sorry.
I know we did have some testimony earlier from one of the firefighters that's part of your union, when Jeff Tomczyk, I think, really did cover for us the differences between workers' comp, line of duty, injury or death, and what you currently receive in the Cancer Relief Fund. And I think that for us, it's really important that we know these differences. So I appreciated his testimony. I don't know if, we can all go back and look at the tape from these hearings, but if you have not submitted that kind of testimony, we would still appreciate that. I think it would help us in our deliberations to just see sort of a side by side of what you would get under workers' comp as opposed to what you get from this Cancer Relief Fund. That would be helpful.
Definitely, we can provide that.
Thank you so much.
Right.
And thank you for being here today.
Thank you all.
Next up, we have Laura Garcia. And I'm going to get, hopefully Megan is here to translate.
Hi, I'm here. My name is Laura Garcia. I live in Ensonia. I'm a member of Unidad Latina en Acción and Recovery for All. I'm in favor of the Project Bill HB 5854, an act to increase the number of wage theft investigators in the Department of Labor. Good afternoon, and thank you for presentation to my testimony of how important it is to fight against wage theft. I came to the United States almost 10 years ago. I remember my first job was dishwasher. Back on the time, I had to work 13 hours daily. I bought my first television with my whole week of salary. My salary wasn't enough, even that I worked 7 days a week and more than 60 hours a week. I never complained. Instead, I found a second job, cleaning houses. During the day, 7 a.m. to 12. I went there only 2 days. The treat that those people give to their employee was absolutely disgusting. They call us idiots. Hurry up. You should clean this house in 1 hour. Imagine they getting paid 300, 400 for a house, and they only pay us 10 per house because they don't pay the time in the car. So if you clean 3 houses, you get $30. Disgusting. I quit, and I promised myself and I promised to my kids that I'm going to learn English and I'm going to get my own jobs. And thank God that was my case. Now I work for a family for almost 8 years and I love them. But this is not the case for many people. I became an activist and fight against all this injustice. And I heard many stories worse than mine. For example, Juan, who has been working for cleaning the beautiful jar for an old guy. The guy, when Juan asked for his payment, the owner tell Juan that he will call immigration on him if he can keep asking. Or Maria and 6 more friends who work on a nice restaurant, and she even suffering sexual harassment. She came to us, but she's scared, and many more who contribute to this beautiful country, paying taxes for many years, but suffering inside them. I'm talking in behalf of many Lauras, many Juans, many Marias who are suffering modern slavery. And while many of you sit down to eat a delicious plate in a nice restaurant, or you get to your clean house, or you just look at your beautiful jar, many of those works came from tears. So please put in our shoes and pass HB 5854. Thank you so much.
Thank you for your testimony. I see Representative Hughes has a question or comment.
I just wanted to clarify, did you say you were working 13 hours daily, 7 days a week?
Yes, ma'am.
And thank
13
you.
hours.
13. And you felt like you had no recourse against your employer at that time because did I hear you that you didn't feel like you could speak English enough to make your case, or?
Yes, in that time I don't speak English. In that time I don't know about any organization. Back in that time, I don't know anything until I met this great organization and many more that I'm member now.
Thank you so much. And so really the organization helped inform you of your rights as a worker, to be paid on time, to be paid a minimum wage, all those protections, and to be free of sexual harassment. Is that what I'm hearing too?
Yes, they teach me, and now I became activist too, and I hear many stories, and I'm trying to teach them their rights too, because back in that time no one teach me until I get to those organizations.
Thank you so much. I'm just especially concerned about the normalization of sexual harassment and wage theft in those 3 areas that you talked about, house cleaning, domestic workers, and also restaurant workers and landscaping. So I'm concerned that is really prevalent and that we are not enforcing workers' rights.
Exactly, especially in those undocumented people who work under circumstances, and they don't complain because their status. Thank you again.
Thank you for your courage.
Thank you. Any other comments, questions? Okay, thank you so much for your testimony today. Next up, we have William Tuttle.
Good afternoon, and thanks for having us today. I'd just like to take a second after listening to that young lady before us. The work that you do here is vitally important to workers all across the state. And I appreciate all that you do, and having these people in to listen has reminded me why I'm a proud member of organized labor. I'm here to talk in favor of Senate Bill 937. My name is Bill Tuttle. I'm the president of Local 1426. That's Fairfield Fire Department's chapter of the International Association of Firefighters. The good thing about going this late in the day, and I'm sure that you wish that the day didn't go this late, but as I get to hear everybody else, so I've changed what I'm going to say about 15 times as the day goes on, because it's been said much better by people much more eloquent and articulate than I am. 48 other states have this. It's not rocket science. We're not inventing something. And that's kind of where my thought process went as I listened throughout the day to, well, what if we have this, you know, what if we build a new thing over here and it does it a little bit better than what we have now? Workman's comp isn't perfect. We all know that, but it's the system we have. For the 20 years I've been here and working in a union capacity, we've had plenty of workers go out on workman's comp, plenty of fights with workman's comp, all that kind of stuff, but we all know the rules of the game. That's what we should put in place here is workman's comp. Then everybody knows exactly what they're getting and what to expect every day, even if that expectation isn't perfect. So I heard a lot of the opponents to this talking about the costs. I negotiate a lot with towns, with our town, and I've learned over that time when people talk about cost, but they don't tell you the cost, it's because the cost isn't what they want you to think the cost is. So the first selectman of Ridgefield was up there and talking about how, you know, if we put this on comp, it would wipe out the poor town of Ridgefield. So I just did some Google math, looked it up, went into their census. Ridgefield has a population of about 25,000. Figure if there's 4 people per household, that's 6,200 households. They have 34 firefighters. Let's say, and there's no way that this is possible, but by putting those guys on extra workman's compensation, it costs $500,000 a year, which there's no chance it does. But let's say it did. That would come out to an average of $76 a household per year. That is not going to break Ridgefield. That's not going to cause their taxes to go up. That is not going to cause a mill rate increase. It's an accounting error. The income, the median income in Ridgefield, where these people are going to go broke from the $76 a month, or $76 a year. I'm sorry, it's not even that expensive. $76 a year. The median income is $160,000 per household. I'm sorry that cancer is expensive. It's not our fault. We didn't put the PFAS in the gear. We didn't put the chemicals into the couches. We didn't do that. We're just the recipients of it. So all we're asking is that you treat it just like you would any other injury. Let us play by the same rules. We know that firefighting causes cancer. There's no debate about it. There's not two sides to this fight. There's science and there's not. And the feelings of CCM, the feelings of First Select people, the feelings of mayors are all relevant. I can appreciate it, but they don't battle science. Science is what it is. We're getting cancer and we're dying. Pete just stood up here and told you that he just lost a guy this morning. His family doesn't know what they're going to get. And Senator Kushner, you've asked the question a bunch of times, and I've listened, and I've been somewhat confused by the answers sometimes because you are confused by it. I'm assuming because it's not something you deal with all the time. I'm confused with it because, quite frankly, I'm not that bright. But what it comes down to is if I go out on comp, my pay continues, my insurance continues. If I can never come back to work, there's benefits that I get through the town for being disabled. My pension would go to my survivors, or I would continue to get it as a disability pension, and I'd continue to have health insurance. If it's just an illness, I run out of time and then I leave with whatever benefits I had up to that point. For some of us, one of my guys who had cancer, we strung him along to get to that 25-year mark, which is the magic year for us in Fairfield. But if he had left at 23 years, he'd have no health insurance for the rest of his life because he didn't make it to that age. And this is just, you can't work anymore. So that's I hope a more simplistic answer is that with workman's comp and calling it a disability from work, then all the benefits continue, just like if you fell off the ladder, like Caitlin said. And that's all we're asking for. Thank you for your time.
Thank you for your testimony. And it is helpful to have those plain language explanations for us because we're not that smart either. So, just all kidding aside, it is, and, these are things that I'm vaguely aware of. But I want to make sure that they're on the record and that we can go back and we can look at these benefits and the differences so that we can actually, when we deliberate, have that information before us. So your testimony is critically important, and I appreciate you being here today. Do my colleagues have any? Yes, Representative Ackert.
You are very smart, by the way. Should, and so is the senator, by the way. But just to follow up, you said 48 other states have this.
Presumptive cancer.
And they
legislation.
must have workman's comp and they must know the rates.
Right.
So this shouldn't be really a secret,
No.
right? What the rates are and what Connecticut would be. I'm sure there's got to be a workers' comp policy out there that says, if you go there, this is what the rate is. I don't know about $500,000. Now, mind you, just so you know, I don't represent Ridgefield.
Yep.
We don't have the average income down there. So $76, maybe not right, but we got some pretty poor neighborhoods out in the eastern part of Connecticut. Poor in money, not poor in what we offer, in terms of lifestyle. But anyways, just so I know, I just looking to get some idea what the rates would be before we get, when you hear that you're gonna break our community, with this. Just give us an idea. At least we have some knowledge, right? Not you yourself, but somebody.
Well,
that's in the business.
I guess that was the point I was trying to make earlier, sir, is that we had people stand up here from those companies, from the insurance agencies. I didn't hear them mention what the cost is, just that it's expensive. Well, like you said, expensive to you might be different than expensive to me. They have to know the number. Why aren't they telling us? Because the number isn't the scary. My belief is if the number was super scary, they'd be yelling it. It'd be in the radio ads that they took out against us last time.
Thank you. Thank you for your testimony. Thank you, Madam Chair.
Thank you, Representative Hughes.
Thank you so much. And thank you, Madam Chair. Thank you, Bill, and all of your colleagues for staying year after year for this fight. I think the most compelling thing that I heard differently, and thank you for changing your testimony, was that there's confusion around the rules, but not really around workers' comp, because it's been around a long time. It's very clear. It's compensating for injury or disability that you derived from doing your job. And this other fund and this other do we call it, what do we call the benefits? The other benefits, we call it
The Firefighters Cancer Relief Fund.
Yes, LODD Benefits and Relief Fund. That is, or the Firefighter Cancer Relief Fund, that is vague and changing potentially. This does not, in terms of, we transport those benefits from one job to another. Workers' comp benefits across the board. And then the second thing that you said that was really, really important is that, like Senator Kushner said, there's 40 other states and Representative Ackert, we should find out what those costs are and normalize it, because you have been paying the cost. Nobody has been saying that, but you have been paying that cost, you and your colleagues and those families, and that is unfair.
Thank you.
Thank you. Any other comments or? Thank you so much for your testimony today.
Thank you so much for your time.
Next, we have up Dennis Iannotti. Did I say that correctly?
Yes, you did.
Oh, there you are, Dennis.
Right. All right, good evening. My name is Dennis Iannotti. I am a 20-year career firefighter here in the state of Connecticut. I want to thank the committee for allowing me to speak today in support of Senate Bill 937. I speak to you today as not only a firefighter, but also a parent of a child with cancer. In May of 2021, my 8-year-old son was diagnosed with Hodgkin's lymphoma, which is a blood cancer. In my son's 8 and 9 years of life, he endured doctor visits, surgeries, in and out of the hospital, followed by chemotherapy treatments, while my wife and I were at his side. I'm hoping to bring to you today a little bit of a more unique perspective than what I've heard for the most part in all the testimony today. I have had a personal struggle with trying to determine if my occupation and what I have been exposed to has brought that home into my household and affected my children. Just doesn't make a lot of sense to me for a young child who is smiling active to be exposed and diagnosed with blood cancer. So excuse me. So today I just want to state, I'll give you some more data to support it. I want to state that there have been systematic reviews, which is the highest level of evidence. The lowest level of evidence that we have are articles followed by case studies, and the highest that we have are systematic reviews, which encompass all of the data and information. And that has provided us with the highest level of evidence and research. And it demonstrated to us that we have a significant increase in incidence and mortality or death of cancer in firefighters. Depending on the cancer, firefighters are 4 to 9 times more than the general public of having again, higher incidence or frequency of being diagnosed and a higher death rate from cancer. I know that there's a study that was done in Kitsap County, Washington, that indicated that children of Kitsap County of firefighters are 27 times more likely to be diagnosed with cancer than the general public. In my short 20-year career so far, I've had 2 of my brothers, 2 of my members of my department that have both been diagnosed and are battling blood cancers. And those individuals were diagnosed in their 40s. Senator Kushner, you began this legislative process today by going through a safety check in the chambers there, talking about exits, talking about where people need to go in case of an emergency. In the fire service, we're governed by NFPA, National Fire Protection Association, OSHA standards. And the reason those are in place and enforced is because of life loss. And that's exactly why you walk through the steps and explaining to people where they need to go in case of an emergency and so on, because of loss of life. And I don't think that there's any more evidence that we need between everybody who has already lost their life or battling their lives or will lose their lives moving forward for being exposed to cancer. So in closing, I just ask that you please support presumptive cancer legislation for every firefighter in the state of Connecticut. And if not for every firefighter, especially for our families that remain left behind. Thank you for your time.
Well, thank you for your testimony, and you truly did bring a unique perspective that I think we need to hear. We had not touched on that issue of the impact directly on your families and the potential for your family members to contract cancer. And my heart goes out to you for the struggles that your family's facing. I can't imagine how hard that is. And so, it's something we need to address on every level. Prevention, of course, we all agree prevention has to be at the top of the list. But until we stop cancer in firefighters, we need to take care of our firefighters, fully take care of them and address this need. So I really appreciate your testimony. I don't see any other members of the committee. I'm sure they share my feelings and saying to you how strongly your testimony hits us and making us realize how difficult the stories are to hear and how difficult they are for you all to relate and how mostly difficult they are to live with. So thank you for being here.
No, thank you, and continue to fight for us. I appreciate it.
Thank you. Next, we have Jeff Burgess from the University of Arizona. Are you with us, Jeff? I'm assuming Jeff would be getting on remotely. If we see him later, we'll admit him. Margaret Henderson from Danbury, my hometown.
Hello. My name is Margaret Henderson. I live in Danbury, where I am the board president of the Unitarian Universalist Congregation of Danbury. I strongly support HB 5854. We take it as a component of our moral obligation to do that. More Department of Labor inspectors would enhance enforcement of protections against wage theft, and that's what I want to talk about today. If you're talking about people who are most vulnerable to wage theft, you're looking at low-wage workers in industries like restaurant, retail, construction, day labor, nanny, agricultural workers. These people work hard, but the system doesn't give them the same rights that it provides to higher wage workers. This is not accidental. For decades, bad policy choices have helped wealthy families and corporations get wealthier in Connecticut while ignoring the needs of low-wage workers. As a consequence, we now have one of the largest wealth gaps in the country. I want to talk a little bit about Unitarian Universalists. We are gathered around a set of 7 principles as our theology. Our first principle is respect for the inherent worth and dignity of every person. And our second principle is justice, equity, and compassion in human relations. Inspired by these principles, my colleagues and I have worked hard on things like the Domestic Worker Justice Campaign, precisely because we as a state often fail to honor the worth and dignity of domestic workers. And more often than not, we as a state fail to extend justice, equity, and compassion to them. These are nannies, caregivers, people who work in homes of other people. And they have a history of being exploited by things like wage theft. They're highly vulnerable. Most of them are women of color, a large number of whom are immigrants, some undocumented. They already have minimal rights in the workplace due to historic exemptions from federal and state labor statutes. They are essential workers, taking care of the elderly, people with disabilities, children. They clean, they cook, they run errands, they help with personal hygiene. They offer critical companionship. Quite often their services enable their clients' family members to work and earn an income. They're the workers who make all other work possible. So anything we can do to support them in their fight to get paid for the work they do, I think we need to do. I wanted to also comment that wage theft enforcement is good for the overall economy and other businesses too. It keeps honest businesses from having to compete with unscrupulous employers who underpay workers. It allows the state to collect more taxes because if more wages are paid, we get more tax. And so wage theft is helping to undermine vital programs like public schools and healthcare.
Ms. Henderson, your time is almost up. Please conclude your remarks.
Okay. Yeah, many of these minimum wage workers are the primary wage earners in their families, and they need to be paid for the work they do and respected. Thank you.
Thank you very much for your testimony. Any comments or questions? Well, let me just say that I appreciate your testimony here today and standing up for workers in our state that need all the support that we can give them. And I appreciate you and your fellow congregants who have made this your mission. And, you know, I'm glad you shared with us those principles that you live by. I think they're very noble. So thank you for testifying today.
Thank you.
Next up, we have Constanza Segovia. Is Constanza here? Oh, yes. There you are.
Yes, I'm here. Thank you, Senator Kushner, Representative Sanchez, and members of the Labor and Public Employees Committee. My name is Constanza Segovia, and I live in Hartford, Connecticut, and I strongly support HB 5854 to increase the enforcement of wage theft in Connecticut. I'm a community organizer and a member of Hartford Deportation Defense. Our organization represents more than 160 immigrant families in the Hartford area, and we work with our neighbors to build a just and dignified future for immigrant families and our communities. We are also members of the Recovery for All Coalition, fighting for a better future for all of Connecticut, bringing together more than 60 community health and labor organizations. For the past year, one of our main areas of work has been the fight against wage theft and the fight for fair wages for undocumented workers. We have been able to bring bosses to mediation for wage theft cases and are now continuing to gather testimonies from many workers in our community who have been victims of wage theft over and over. Low-wage workers are particularly vulnerable to this, as we know. Restaurant, retail, construction, day labor, nannies, agricultural jobs. These are all the folks that mostly get impacted by wage theft. 100% of our members have these type of jobs. I can say that when I first moved to this country, I did landscaping, I did restaurant work, I did domestic work. These are the jobs that are available to us when we're undocumented. These are the jobs that people are being taken advantage at. National studies show that 1 in 5 workers in these industries are paid less than the minimum wage in a given week. And we know that for most cases, folks are not paid overtime. So as we ramp up our work defending workers' rights here in Connecticut, we know it's important that the Department of Labor is fully staffed and increases their wage and hour inspectors so that they can meet the demand of the work that we're bringing to them. We know that they're already not sufficiently staffed, and we think that we must do our best in our state to support folks who want to report these labor abuses, and we cannot allow unscrupulous business owners to operate this way in Connecticut. Please support HB 5854. We want our community members to be able to rely on the protections that our state intends to provide. Right now, that is just not working well. And we need more workers at the Department of Labor to be able to handle this caseload. Thank you.
Thank you so much for your testimony. Representative Hughes.
Thank you, Madam Chair. And just one question. If your organization is aware of this, pervasive abuse or exploitation of especially undocumented workers, what would happen to the economy if that was stopped and these workers were paid at least a minimum wage and had the worker protections? What would happen to the local economy where these workers live and work?
Well, undocumented workers are our neighbors, right? Our members in our communities. So that money, those wages go straight back into the economy. They get spent at businesses, local businesses. They get invested in new businesses. We know that immigrant folks are well known for their entrepreneurship. So a lot of times people start their own businesses. It immediately goes back into the local economy.
Thank you. And I think it's worth underscoring that those workers are paying taxes, state and local taxes in their paychecks, and that even though those might not be sufficient for the workforce protections when those laws are enforced, they'll be paying more taxes actually, because it'll increase the FICA taxes off of their pay.
That's a very good point. And yes, and beyond the tax contributions, you know, it comes down to respect for people's lives. We cannot live in a state where workers are being abused to this point. And, you know, it's clearly a result of racism and xenophobia and abuse specifically to undocumented workers that are just being taken advantage of. And we see it over and over. It's pervasive.
Yeah, thank you for your testimony.
Thank you. Seeing no other questions, thank you for being here today and testifying. Next, we have, we're going to go back to Jeff Burgess.
Can you hear me okay?
Yes, we can. Go right ahead.
Fantastic. Thank you very much. Good afternoon, Madam Chair and members of the committee. My name is Jeff Burgess. I'm a professor at the University of Arizona Mellon Enid Zuckerman College of Public Health. I previously worked as an emergency physician, medical toxicologist, and occupational physician. I've carried out research with firefighters for over 30 years, with a focus since 2015 on evaluation of cancer risk and cancer prevention. I would like to share with you some key points about cancer and firefighters. First, the World Health Organization's International Agency for Research on Cancer, or IARC, is the international body that makes determinations on whether individual chemicals, occupations cause cancer. IARC met in June of last year and determined that occupational exposure as a firefighter is carcinogenic to humans, making firefighting a Group 1 carcinogen, the highest level. This was based on extensive documentation on measured firefighter exposure to known carcinogens, information on how these exposures cause cancer, and elevated cancer rates in firefighter epidemiologic studies. This information is summarized in a published article in Lancet Oncology, on which I am a co-author. Second, firefighters are exposed to carcinogens both through breathing them in and absorption through their skin. Their turnout gear protects them from heat, but the carcinogenic products of combustion penetrate inside the gear and deposit on the skin. I have a photo of a previously clean white t-shirt worn under turnout gear during a training fire, which clearly shows black soot deposition, in case that can be shared at some point. We have also shown that all firefighters, including firefighters and captains that often enter burning structures while responding to a fire, and engineers and paramedics who rarely enter burning structures, all have increases in polycyclic aromatic hydrocarbon, or PAH, metabolites, which include carcinogens, in their urine after going to a fire. So firefighters are generally exposed to carcinogens at every fire that they fight. Third, there is a latency period between exposure to carcinogens and onset of cancer. And this latency period can be as short as 3 years for some forms of leukemia and as long as 30+ years for some forms of lung cancer. As listed by IARC, there is strong evidence that there are many ways that exposure as a firefighter can cause cancer, including DNA damage, epigenetic changes, oxidative stress, chronic inflammation, and activation of cellular receptors. In our research, we have shown that epigenetic changes, which control gene expression and are essential to the development of cancer, occur within the first 2 to 3 years of a firefighter's career. These changes provide mechanisms by which exposures as a firefighter can cause cancer, and these changes are associated with a wide number of cancers in the general population, including but not limited to cancers of the brain, cervix, lung, prostate, colorectal, esophagus, skin, pancreas, breast, head and neck, and bladder leukemia. So in summary, firefighters are exposed to known human carcinogens through both their lungs and skin, have documented changes in their cells based on these exposures, and have a clearly elevated risk of cancer compared to the general population. Thank you.
Thank you, Representative Hughes.
Thank you, Madam Chair, and thank you for your expertise in this area. Would you then classify the presumptive workers' comp presumption for firefighters and these array of cancers simply as updating the science to the policy, which now we know so much more about in terms of the exposure that firefighters face?
Well, I just first want to be clear that as a faculty member at the University of Arizona, I'm not lobbying, I'm just providing information. So I think that that's important. I do think that there is a great deal more information now, as shown by that IARC ruling, that supports that firefighting does cause cancer. In my mind, it's the question is answered. Firefighting causes cancer. And so now really kind of most of the focus we have is on how to prevent that cancer from occurring.
And I appreciate that research is so crucial to especially attracting new recruits to this life-saving profession. And I just think that our labor policies need to be professionalized and updated to reflect the findings, the expert findings, and we applaud your research. Please continue it. Thanks.
Great. Thank you.
Thank you, Representative. I have a couple of questions about the research itself, because I think one of the reasons that we have built into this bill a rebuttable presumption. And so I know there's been talk about a presumption and a rebuttable presumption. Our bill actually allows for a rebuttable presumptions. In other words, a firefighter's claim at workers' comp could still be contested by the city or the municipality they work for if they were to be able to prove that there were other circumstances, conditions that existed that were more likely the cause of the cancer. And that goes to my question, and that's sort of the backdrop for it. Because I'm wondering, in the research as it's done, are there parameters set in the research itself that sort of screen out people that may have had other conditions, existing conditions, perhaps a family history of a certain kind of cancer, or I can't think of, that's the most likely one, or maybe they were smokers and they, are there screens that are done to sort of mitigate against those other circumstances that could be the cause, the underlying cause of the cancer?
Well, having a family history of cancer only puts you at increased risk. But therefore, I mean, the exposures you get as a firefighter will be even more problematic, because you're likely at increased risk of getting cancer. And then those exposures become even more important. I think that, I would say that most of the workers' comp laws that I know of essentially say that, you are cancer-free when you come into the fire service, and they have investigations that get, that they do a physical exam, and they look for those things when a person first comes in. But I don't know if I'm answering, your questions or not, because, the determination by ARC essentially says that all firefighters, regardless of your type, are at increased risk for cancer due to their occupational exposures. So those will include people, who have, any variety of risks, I guess, when they enter the service.
Okay, I appreciate that. I thought perhaps, I know when we have I believe in our current cancer relief fund, there are some parameters set that might disqualify a person from receiving the benefits of our fund. And but I think your explanation about increasing the likelihood is important, and so we have to be really cognizant of that when we are crafting, criteria. So I think that was all the questions I had right now. So thank you so much for being with us, and it looks like it's still sunny out there in Arizona. It's not so much here at this time.
Great. Well, thank you again for the opportunity to speak with you all.
Thank you.
Take care.
Next, we have James Bahandri Alexander. James, are you here?
I am here.
I said your name wrong. I know. I've known you for a number of years, and I never get your name right. Would you please repeat it for the record?
Sure. No, you were very close. Bandari Alexander. James Bandari Alexander. It doesn't rhyme with anything, so I can't give you any cheats. Um, Thank you, Senator Kushner, Representative Sanchez, a member of the Labor and Public Employees Committee. My name is James Bendar Alexander. I live in New Haven, and I'm here to testify in support of HB 5854, an act concerning the number of wage and hour inspectors at the Labor Department. I'm a longtime attorney for workers legally denied their basic pay and strongly support this legislation to add wage and hour inspectors at the Department of Labor. For the last 10 years, I've represented low-wage workers on wage theft issues, including in front of administrative agencies like DOL, in state and federal courts, and here in the legislature. Unfortunately, I can attest to the rampant violation of basic workplace laws throughout Connecticut, and especially wage and hour laws. My clients facing wage and hour violations work in restaurants, construction sites, landscaping jobs, and in domestic work. In all these places, sadly, wage and hour violations in some areas are the industry standard. But as Senator Nancy Johnson of New Britain put it when she advocated for strict wage and hour laws in our state, this is, quote, a gut level thing. Every member of this committee has likely worked for wages and depended on those wages to house themselves and their loved ones, put food on the table, pay for heat and electricity, and to enjoy life. It is not an exaggeration to say that it is. The wage inspectors at the Wage and Hour Division are a major part of making this possible by ensuring that basic standards are met. I know currently workers are waiting for months to have their first interview with an investigator, which should be unacceptable to us when people's lives and livelihoods are at stake. And sadly, I cannot report that the state bar, of which I am part, really picks up the slack. There are only a handful of lawyers, either at legal aid or in private practice, who will take these cases to court with any regularity. And for the committee members who aren't familiar, the basic idea is that we'll have private lawyers willing and able to take the cases. We'll have the Department of Labor wage and hour inspectors, and we'll have organized labor all working together with good employers to make sure these standards are met. So when wage and hour inspectors aren't part of the equation, that means other parts of the equation have to pick up the slack. And as I said, there are only a handful of lawyers who do these types of cases, especially for low-wage workers. So my overall message is that we should treat wage theft as seriously as we can. And I was listening earlier to the testimony, and somebody said, well, maybe the right thing is to ask the governor. And we are, like that, we're here asking this committee, and we're asking the governor, and we're asking our neighbors and other people in the state to view this issue, take a second really to process what this is. This is about whether, as a worker, which most of us are, we can depend on getting a check. We need to just live life. And once we process that, we realize that there's nobody who we shouldn't be talking to. So I'm really happy to be here. And this hearing has just reminded me of why your committee is so important. It's been wonderful to hear voices of people I know and new people talking about these important issues.
Thank you so much for your testimony. It's been a full day. And, I know we take on a lot of bills in the Labor Committee, and that contributes to longer hearings, but so many of these issues, as we've heard today, are critically important to the individuals in behind each of these bills. I don't see any comments from or questions. I will say that, you worked mightily on the bill that we put into effect to educate workers about their the current laws in Connecticut that protect them, and that employers are required to abide by. And it is frustrating to hear that we did all that work and now we're having trouble with enforcement because there's such a backup. And I know the people in DOL are dedicated to bringing these cases and solving these cases, but they are limited by the number of people they have working for them. So I really appreciate you underscoring the importance of that.
Thank you very much.
Thank you. Well, hold on, Representative Hughes has a question.
Thank you, Madam Chair, and thank you, James, for your testimony. I think for our, is it that one that's on? Is it that? Yeah, we should turn that off. I think to help educate the landscape, because you see this firsthand, I think people think, oh, if there's a problem, just call a service like, legal aid, and they'll call the Department of Labor, and they'll come in and fix it. And I think for this committee and the public's understanding, what does that landscape look like to really address pervasive wage theft? I think people think it's easy to enforce these common protections. And I think that you probably see firsthand how difficult it is.
Yes, well, there are a number of obstacles to proving a case, of course. So, but I'll put those to the side. Those are questions about, what does the worker have to be able to show to like prevail in a case like that, which is its own set of obstacles. But as far as just basic mechanics, like I said, first we have needed to have programs of education, which DOL does, which domestic worker organizations do, which other organized labor does, to inform people of their rights. But those only cover so many people. So you are going to have a number of people who literally don't know what to do and have never been contacted by anybody about how to enforce their rights. The wage and hour posters that are required to be put up often are not. But they do work actually quite pretty well when they are put up. But if an employer is determined to evade these laws, there are plenty of people who don't know where to go. If somebody calls a legal aid office currently today in this state, I was in New Haven legal assistance for a decade and more than a decade, and I'm really proud of all the work we have done, and there is some work ongoing, but most likely what will happen is what you mentioned. They will be referred to a Department of Labor website where they can file a wage complaint. They won't talk to a lawyer. If they do talk to a lawyer, there's maybe I would say a 1 in 50 chance that the lawyer will have the capacity to take the case, or will be able to refer it to a pro bono attorney to take the case. There are between 1 and 5 really active plaintiff side wage and hour lawyers in the state at any one time, and that's been true for the last decade. So when I started, it was, you have to go talk to Peter Goslin. So I would go talk to Peter Goslin. Then there's Mariusz Kurzina from New Britain, who actually is in Maryland, but still practices in Connecticut sometimes. There's Richard Haber, who does larger kind of class action cases, but doesn't take these low-wage worker cases with as much regularity. Anyway, I'm naming people I probably shouldn't, but that's just to prove the point that we know each other. There aren't that many of us. So it's going to the Department of Labor. If it gets there, if it goes anywhere, 90 times out of 100, it's going to the Department of Labor, the State Department of Labor Wage and Hour Division, where I think you've heard testimony currently, the wait time to even talk to somebody, for a worker to talk to somebody is, I believe it was 4 to 6 months. I wouldn't swear by that, but I think that's what I recall hearing testimony on, which sounds right to me. I have clients currently waiting to talk to for the first time to people at the Wage and Hour Division. And the Wage and Hour Division does amazing work for the people that it can reach. And we want them to reach more people. Beyond, if they're not going to the State Wage and Hour Division, where we know that urgent matters are not going to be able to be treated with urgency, then essentially for many workers, they give up and move on, which is a problem for them, but is also a problem for all of us, because what that is right there is the standard just being undermined, flagrantly undermined by attrition. So for everybody, as I said, everyone on this committee has worked for wages. We understand why it's important. If we stop and think about it, we really can do better. I'm absolutely positive.
And how about sexual harassment? How would people go about complaining, proving, or getting any kind of official Department of Labor addressing that?
Well, I believe that currently most sexual harassment claims will go to the CHRO, and which has jurisdiction over the Connecticut Fair Employment Practices Act. They're similar, similarly, I could say only high praise of the people at the CHRO, but you are not going to have a quick trial there either. My students, I teach law now. My students just tried a case there last month, which was fantastic. But you have to wait. So for sexual harassment, the dynamics can be very similar to wage theft in that a person needs to know their rights. They need to know where to go. There needs to be capacity at the places they're going to handle that referral for there to be justice. There are more lawyers who do practice in the area of Title VII employment discrimination than in wage theft in Connecticut. But still, for a low-wage worker whose case may not have the financial value, so to speak, for the lawyer who's litigating it, to get their case taken is quite rare and quite difficult. And again, the legal services agencies have a few lawyers who do employment law, but there's a lot of other things on their plate. So there are definitely holes in that system as well. Overall, I'm a member and a leader in the Recovery for All Coalition because I believe that we really need to fund. We have to figure out a way to fully fund our public workforce where they are providing these crucial services to people, and both DOL and CHRO are prime candidates for that.
Thank you.
Thank you. Again, thank you for your testimony here today. Next up, we have Nayeli Garcia.
Hola.
Hola, is Megan Fountain going to be translating for you today? Hi, Megan, I see you're there. So go right ahead and you can begin.
Estimados presidentes y miembros del comité, mi nombre es Nayeli García Romero y vivo en West Haven.
Good evening, dear members, chairs, and members of the committee. My name is Nayeli Garcia, and I live in West Haven.
Apoyo el proyecto de ley HB 5854 para combatir el robo de salarios en Connecticut.
I support HB 5854 to combat wage theft in Connecticut.
Soy parte de Unidad Latina en Acción, que tiene aproximadamente 1,800 miembros en el estado, y nuestra organización lucha por los derechos de los trabajadores inmigrantes.
I am part of ULA, Latino Unity in Action, which has approximately 1,800 members in the state. Our organization fights for the rights of immigrant workers.
También soy integrante de Recovery for All, una coalición estatal que lucha por un futuro mejor para Connecticut, que cuenta con más de 60 organizaciones comunitarias, religiosas y laborales.
I'm also speaking to you as a member of Recovery for All, the statewide coalition fighting for a better future for Connecticut with labor, community, and faith organizations.
Siendo miembro de ULA, he podido ser testigo de todas las injusticias que pasan los trabajadores inmigrantes.
As a member of ULA, I have witnessed all of the injustices that immigrant workers go through.
Muchos trabajadores no alzan su voz y no se atreven a denunciar el robo salarial que sufren porque muchos empleadores se encargan de meterles miedo diciéndoles que ellos van a llamar a migración.
Many workers don't dare to denounce the wage theft that they suffer because many employers scare them by threatening to call immigration.
El robo salarial afecta a miles de personas trabajadoras y aún más a los trabajadores inmigrantes siendo aún más vulnerables.
Wage theft impacts thousands of workers, and immigrant workers are even more vulnerable.
El Departamento de Trabajo debe tener más agentes que investiguen sobre robo salarial, ya que conozco a personas que toman meses para darle seguimiento en sus casos.
The Department of Labor needs more agents to investigate wage theft. I know people who have waited months to get a response on their claim.
También diariamente gente es contratada en la calle y sus empleadores desaparecen a los días. Ellos están siendo explotados y no reciben justicia.
I've also seen many day laborers, construction workers who are hired on the street corner. Their employers fail to pay them and then disappear, and they don't get justice.
Los empleadores deberían ser tratados como criminales cuando le roban su salario a los trabajadores. Le están quitando un sustento a una familia y muchas familias han quedado con deudas o incluso quedan en la calle.
When employers do this, they should be treated as criminals. They're taking away a family's livelihood, and families are left in debt or even homeless.
Hoy ustedes pueden hacer un cambio real para los trabajadores. Les pido que apoyen HB 5854 y gracias.
Today, you can make a real change for workers. I encourage you to support HB 5854. Thank you.
Thank you very much for your testimony, and thank you, Megan, for the translation. We really appreciate it. Any questions or comments? Not at this time. Thank you so much for being here.
Thank you.
Next, we have Mayor Passero.
Good evening. Can you hear me?
Yes, we can. Please proceed.
Senator Kirschner, Representative Sanchez, members of the Labor and Public Employees Committee. My name is Michael Passero. I am the mayor of the city of New London. Prior to my election as mayor of New London a little more than 7 years ago, I served on the New London Fire Department for 31 years. I am testifying today in support of Senate Bill 937 and HB 5857, both regarding presumptive cancer legislation for firefighters. I'm honored to testify today on behalf of this legislation in place of my brother firefighters whom I served with, who had their lives cut short by this hideous occupational disease. Throughout my 31-year career with the New London Fire Department, numerous brother firefighters were diagnosed with cancer. For all of them, it was a death sentence. Treatments have improved over the years, and fortunately, members of my department are now surviving the disease, but live with the diagnosis hanging over their heads. This legislation will provide, this legislation will provide needed support to those firefighters and their families. I am proud of our fire department in New London for the proactive measures that have been taken to protect our firefighters. This includes venting systems for apparatus exhaust, washing machines that extract hazardous chemicals from firefighting gear, training and awareness programs, and common sense measures like keeping firefighting gear out of the bunk rooms and station living areas. While we work to prevent exposures that threaten the health of our firefighters, we must also take care of those that fall ill from a known occupational disease while they are protecting their communities. I understand it's been a long day for you. You've heard a great deal of testimony. So you've undoubtedly already heard that Connecticut is one of only 2 states without presumptive cancer legislation for firefighters. I find that amazing. You should also have become aware that the study conducted by the International Association of Firefighters from 2001 to 2018 found that 65% of firefighter deaths were due to occupational cancer. Moreover, this past July, the International Agency of Research on Cancer, a branch of the World Health Organization, has classified the occupational exposure of firefighters as a Group 1 carcinogen. In short, the scientific evidence that cancer is an occupational disease of firefighting is overwhelming. Therefore, it's imperative that the General Assembly pass this presumptive legislation to ease the burden on our firefighters under the Workers' Comp Act. I thank you for your time. I know it's been a long day, and but I think, and I'm proud that I'm probably the only leader of one of the municipalities in Connecticut that is standing up and telling our General Assembly, please take care of our firefighters.
Well, I really appreciate your testimony today, Mayor Passero. You have a unique perspective, having been a firefighter for so many years, and I think that probably contributes to your viewpoint on this, and very legitimately. I'm not. That's not a criticism. That's praise. But I do think the concern we've heard from municipalities has been cost. That this will somehow raise, cause the municipalities to have to raise property taxes in a way that would be very detrimental to the residents. And I wondered if you could address that, if you've considered that and what your thoughts are on that.
Yeah, I'm not convinced that would be a significant factor in my weighing the value of this legislation. Throughout my career, we were not consciously aware of the threat that the job posed to our health. And it was, our gear wasn't as good, the science wasn't as good. So, we didn't have the facts that we have now to show that this type of legislation is necessary to protect our firefighters. And I don't believe that the cost, and if the cost is a factor, then that's the price of providing safety to our communities. We certainly should not let that cost be borne merely by the first responders that are looking out after our communities and then leave them if they, if they win that awful lottery. I mean, as firefighters, we live with that. We don't know which of us is going to get the disease, but we know that it's a threat that comes with our occupation. So I'm not going to factor in the cost, and I don't believe it's financially irresponsible for a municipality to support this type of legislation to protect their firefighters.
Thank you very much for that answer, as well as for your testimony. I don't see any other questions. It is true that you're coming at the end of a very long day with a lot of testimony. Had you been the first one up, I'm sure there would have been a zillion questions for you, but we've gotten a lot of information today, and we will consider your testimony as well as we deliberate about this bill. So thank you so much.
Thank you for your time.
Thank you. Next up, we have Senator Henry Martin in the room.
Thank you, Madam Chair. If I could just add my 2 cents into this bill that the mayor was commenting on. I know that this has been in front of our legislature for many years. Just a thought, with what happened in Bristol regarding the tragic shooting of the 2 police officers, it was brought to my attention, there's, the post-traumatic effects of those that were immediately on the scene, and knowing what that may mean for individuals or police officers or paramedics or whoever was there. But taking the bill that we had when I first arrived, Sandy Hook, we had to address the police, the state troopers that arrived there as well. An idea had been shared with me, perhaps we may want to consider funding on the state level these types of tragic events that take place. We're looking at firemen here who, became firemen and didn't even think about what type of exposure and potential cancerous matters that they were inhaling, or their protective gear. But maybe we should be thinking about a major fund that the state would be we put up the guidelines in order to qualify to provide these workman's comp benefits. I don't know what the right answer is. I hear the argument on the other side regarding the municipalities and the extra burden that they would have to absorb, financially. So just a thought, maybe that can start a discussion down the road. But I'm here for another bill, and that is, and first of all, thank you for staying so late and allowing me to testify. So Senator Kushner and Representative Sanchez Senator Sampson, Representative Ackert, and distinguished members of the Labor and Public Employees Committee. My name is State Senator Henry Martin, and I represent the 31st District, which is Bristol, Harlington, Thomaston, Plymouth, and Plainville. And I'm here to support the bill SB 197. I'd like to thank my constituent who brought this to my attention. He wasn't the first one, but he sort of he brought it to my attention where I felt I needed to submit a bill regarding this, and that was Rick Kesner of Emily's Catering Group. And I think he employs 20 to 30 employees, for coming forward and voices his concerns about the impact of the federal borrowing on the small businesses regarding the unfunded, unemployment fund that we have. In 2008, the Great Recession, unemployment reached about 119,000 people. The state borrowed from the federal government in order to pay those benefits, right, the unemployment payments, to a tune of about $1 billion. What we borrowed. In 2009, the employer started to pay back on that loan, and by 2015, 2016, we had paid that loan off. By 2020, pre-COVID, the Unemployment Trust Fund had approximately $700 million in the account to make payments, future payments. And we're about halfway to the goal of $1.4 billion, which is the benchmark that would establish the trust fund to be solvent. Then COVID hit, and resulting in the greatest number of employees on unemployment that the state has ever seen, to a tune of over 290,000 people. And today we're down to about 50,000 people who are still unemployed. But the fund went from 700 million in the black, and then the state needed to quickly borrow another $1.1 billion from the federal government to make unemployment payments. Fortunately, since then, we've been able to pay down on that. And today we have a balance of about 146 million. Assuming that there are no additional borrowing, because a month ago, I think we were like 136 million. And then because of unemployment, we are now at $146 million that we've continued to borrow. And if we continue this, if everything stops right today and the employers start making payments to their quarterly payments towards the loan, we would have that loan paid off by 2026. So it is the employers that do make these payments. The ask from this bill is for the state to pay the $146 million that it's outstanding. Get us to zero, get the employers to zero. In other words, there's no loan outstanding. So the employers' quarterly payments can start replenishing the unemployment trust fund and get us to $1.4 billion. That 1.4 is the sweet spot where if there is an economic downturn or a recession, we don't need to go borrow any money from the federal government. That's my ask. And I don't know, first of all, why the bill is here in the Labor Committee. It really belongs in appropriations, but that's for another discussion. So if you have any questions, I'll be happy to take them.
We do agree that it's probably shouldn't have been in the Labor Committee either in appropriations, or trust fund matters can also be taken up in the Finance Committee because they have cognizance over the trust fund. So there are a couple of other options there, but we appreciate you putting in the bill. I know we did use funds. The state of Connecticut contributed funds toward bringing down the debt in previous years. And so it's certainly something that has happened in the past, and I'm sure it'll be a subject of conversation again.
Yeah, thank you.
Thank you. Thank you for your testimony. Next up, we have John Lugo, who I believe is on remote. So thank you. you can unmute yourself and then go ahead and proceed.
Yeah, thank you. So, hi, how are you? Good afternoon, Senator Julie Kushner and Representative Manny Sanchez and members of the committee. My name is John Jairo Lugo. I'm testifying on behalf of HB 5854 to combat waste theft. I'm the director of Unidad Latina en Acción. Unidad Latina en Acción is a grassroots organization that defends the human rights of workers and immigrants in Connecticut since 2002. Together with 60 organizations across the state, we're part of the Recovery for All, fighting for justice for poor people, workers, and families. In 20 years, ULA has seen many workers cheated and abused in Connecticut. We have helped workers recover more than $1 million and unpaid wages. They work all over the state in restaurants, landscaping companies, construction sites, hotels, and more. Most workers do not even file complaints because they know that they will be fired. It takes so long for the Department of Labor to take action that many workers suffer in silence because the risk of filing a complaint outweigh the benefits. At Five Star Landscaping, Eliseo Aguilar is owed $6,000. He worked for 2 months without getting paid. He made a lot of calls to the owner of that place, and eventually the owner put charges of press charges for harassment, and he got arrested, and now he's facing charges in Meriden. Now he moved out from the state because he's afraid of his former boss. He made a complaint with the Labor Department at the beginning of 2022, and just like last month, he received the first email from one of the agents at the Labor Department. Of the Hook restaurant in Westbrook, Marvin earned $3 an hour, and some weeks he earned nothing at all. At the Study Hotel at Yale, a housekeeper was fired after she complained of stolen tips. At Goodfellas restaurant in New Haven, dozens of servers and dishwashers filed 9 different complaints of waste theft between 2007 and 2015. The Connecticut Department of Labor found Goodfellas guilty. The USDOL found Goodfellas guilty. The court ordered Goodfellas to pay, but the restaurant keeps stealing wages because the penalties were so small. Connecticut needs stronger protection to combat waste theft. I'm also testifying as a worker. I worked 5 years as a server in a New Haven restaurant, Tony's Restaurant. I worked 3 years waiting tables in a hotel in upstate New York. In both jobs, they pay me less than the normal minimum wage because I earn tips. However, they were breaking the law because I did work without tips. I had to arrive before the customers arrived to sweep, map, set up tables, carry bottles, and do other things at the hotel. I did all that plus mowing the lawn of the rest of the hotel. At the hotel, the pay was so little that I could not earn, or I cannot earn enough to pay for my apartment. So the hotel put us 20 workers in a house. I just live in a little room with 5 other people. I will never forget the misery of that job. I call on you to make Connecticut a place where workers who fed us and care for all of us can live with dignity. Thank you very much.
Thank you very much for your testimony here today and the specifics that you provided. I'm looking to see if any of my colleagues have comments, not today, but thank you very much for joining us, and your testimony will be part part of our deliberations as we move this bill through the process. Thanks so much.
Thank you.
Next up, we have Allison Escobar. Is Allison with us? I think Allison is supposed to be on remotely, but I don't see Allison. Okay, we'll move on to Jenny Cornejo. Is Jenny here? I don't see Jenny either. So next I do see Ivan Abarca. Ivan, go ahead and unmute yourself. Ivan, can you hear me?
Hola.
And are you going to speak in Spanish? And Megan is going to
Yes.
translate for you. Thank you. Go ahead and proceed. Empezar. I think I'm close to that, right?
Adelante, Iván.
Buenas tardes, senadora Kushner, representante Sánchez y miembros del Comité de Trabajo y Empleados Públicos.
Good evening, Senator Kushner, Representative Sanchez, and distinguished members of the Labor Committee.
Mi nombre es Iván Antonio Abarca Blanco y soy un miembro de Connecticut Worker Center y también un integrante de la coalición de Recovery for High.
My name is Ivan Antonio Abarca. I am a member of Connecticut Workers Center and also a member of Recovery for All.
Vivo en Bridgeport y apoyo el proyecto de ley HB 5854 para combatir el robo de salario en Connecticut.
I live in Bridgeport and I support HB 5854 to deal with wage theft in Connecticut.
Yo he sido víctima de robo salarial. Un empleador me contrató para hacer trabajos de pintura y carpintería y no me pagó.
I have been a victim of wage theft. An employer hired me to do painting and carpentry, and he did not pay me.
Me sentí frustrado y no sabía qué hacer. Consulté con la policía para que me ayudaran. Ellos me enviaron al departamento de labor.
I was frustrated and I didn't know what to do. I called the police for help and they referred me to the Department of Labor.
Seguí buscando ayuda hasta que me encontré con Connecticut Worker Center y ellos me ayudaron para hacer la queja al departamento de trabajo.
I kept looking for help until I came across Connecticut Workers Center and they helped me file a complaint with the DOL.
Yo tenía miedo a las represalias y miedo a tener que hablar con una agencia del gobierno. Hasta el día de hoy, y el empleador solo me ha pagado una porción y todavía me debe.
So I was afraid of retaliation and I was afraid to speak with a government agency. But they helped me file the complaint. But to this day, the employer has only paid me a portion and still owes me more than $1,500.
Todavía me debe más de $1,500, mi empleador. No cumplió con el Departamento de Labor y la queja fue enviada al abogado general de Connecticut, en donde el empleador pagó por las multas, pero no me pagó lo que me debe.
So the employer did not comply with the Department of Labor. And the DOL then sent the complaint over to the Attorney General's office. The employer paid some fines, but never paid me all of what I was owed.
Yo tengo una familia que mantener, un bebé de 5 meses y una renta por pagar.
I have a family to support. I have a baby, a 1-month-old baby, and a rent to pay.
Así como yo conozco muchos trabajadores que pasan por las mismas circunstancias que yo y no hacen nada por temor a ser deportados o porque piensan que no van a ser escuchados.
Iván, trata de no tocar el aparato. Oh. Like many workers go through the same thing, but they do nothing for fear of being deported or because they think they won't be heard. Adelante.
Si tenemos la oportunidad de tener más trabajadores que entiendan nuestra cultura y entiendan nuestros lenguajes, podemos tener más confianza en estas agencias y exigir nuestros derechos.
If we have the opportunity to have more Department of Labor agents who understand our cultures and understand our languages, we can have more confidence in these agencies and we can demand our rights.
En esta sesión, ustedes pueden hacer un cambio real para los trabajadores. Por favor, apoyen la ley HB 5854. Muchas gracias por su atención y por su tiempo.
In this session, you can make a real change for workers. Please support HB 5854. Thank you very much for your attention and your time.
Thank you for your testimony, Yvonne. It was very important to hear from you and your experience. I do see Representative Hughes has a question.
Thank you, Madam Chair. Sir, do you know or do you think your employer is still doing that, exploiting workers and not paying them?
Muchas gracias, señor Abarca, por contar su historia. La representante tiene una pregunta. ¿Cree usted que este empleador sigue explotando a la gente?
Sí, este empleador sigue en lo mismo, porque incluso yo he tratado de comunicarme nuevamente para que él me pague y no lo ha hecho. Y sí hay otras personas que él les debe.
Yes, he continues to do the same thing. I have contacted him to request payment, and there are other workers who are also owed wages by him.
And finally, do you think you were selected because this employer thought that they could get away with it?
Y para concluir, la pregunta es, ¿usted cree que el patrón lo explotó a usted porque creía que iba a quedar impune?
Pienso que sí, él pensó de que a lo mejor ya le había hecho esto mismo a otros emigrantes y la verdad conmigo fue diferente en el sentido de que yo busqué ayuda. Hay otras personas que no han buscado ayuda porque piensan de que no se va a resolver este problema.
I think yes. I think the employer probably exploited other workers and he got away with it because they didn't have any help to file a complaint. In my case, it was different. I found an organization that helped me file the complaint.
Thank you. And for just finally, and I know it's been a long day, but it sounds like the organization is doing the job that maybe the Department of Labor should be doing. And so we've been relying on these community nonprofits to hold companies accountable for exploiting workers and doing it deliberately and doing it systemically. And it's time we change that. Thank you. Thank you, Madam Chair.
Thank you. I am going to now turn the chair over to Senator George Cabrera. I don't think there's any more questions for you, Yvonne, but thank you for being with us tonight. And I have a meeting that I couldn't change. So Senator Cabrera is going to chair the remaining part of the hearing. If I can get back to, I will as soon as possible. But thank you, Senator Cabrera, for stepping in. And I'll let you take over with the next speaker is Joe Durrett, the next person to speak.
Muchas gracias, Iván.
Gracias, Iván.
Gracias, gracias a usted también.
Thank you, Senator Kushner. Good evening, everyone. I think we have actually Jenny Cornejo back on, right? Who's back on? I don't know if Ms. Cornejo is available.
Oh, correct. Yeah, that is correct. Thank you for that correction. But we'll come to you in 1 minute. I forgot that Jenny is in the room. Go
Quite
ahead.
all right. Go right ahead, Ms. Cornejo.
Jenny, ¿puede prender su micrófono?
¿Cómo están? Muy buenas tardes. Mi nombre es Jenny Cornejo. He sido testiga de robo salarial. Es muy frustrante ver este tipo de casos.
Good evening. My name is Jenny Cornejo. I have been a witness to wage theft, and it's very frustrating to see these cases.
Ya que somos personas trabajadoras, que nuestra única misión es llevar el pan diario y cubrir de techo a nuestras familias.
Because we are working people, our goal is to bring home the daily bread and give a roof over the head, put a roof over the head of our families.
Lamentablemente, la más afectada es nuestra comunidad migrante.
Unfortunately, the community that's most impacted by wage theft is the immigrant community.
Ya que son intimidados con frases, te voy a llamar a la policía.
Because they are intimidated when somebody says, I will call the police on you.
Te llamaré a inmigración para que te deporten.
I will call immigration to get you deported.
Inclusive frases insultantes como eres un maldito migrante ilegal.
They'll even use slurs and say you are a slur word, illegal.
Que tienes que aprender a hablar inglés.
You should learn English.
Situaciones que se viven a diario.
These are situations that we live daily.
Y se vuelven a repetir por nuestra situación migratoria.
And it happens over and over again because of our migratory situation.
Un día acompañé a un amigo a cobrar un cheque por 40 horas.
One day I went with a friend to get his paycheck, just $40.
El contratista dijo, no tengo ahora, vuelve el próximo mes.
The contractor said, sorry, for not $40, 40 hours. The contractor said, I don't have the money now, come back next month.
Mi amigo le dijo, lo siento, yo necesito el dinero porque tengo que cubrir mis obligaciones.
My friend said, I'm sorry, but I need the money to cover my expenses.
El señor, en vez de darle su dinero,
the gentleman, instead of giving him his money,
ingresó a la casa y sacó una pistola y dijo, vete indocumentado.
He went into his house and grabbed a pistol and said, get out of here, you undocumented person.
Te llamaré a la policía porque invades mi casa.
I'll call the police and charge you with trespassing.
Inmediatamente él fue a poner su reclamo al Departamento de Labor
Immediately, he went to file a complaint with the Department of Labor.
en el año 2021.
In the year 2021.
Hasta el momento no le han dado solución.
But up to today, they haven't given him a solution.
Por este motivo, nuestra comunidad
For this reason, our community
no acude a las organizaciones
doesn't go to the agencies
e instituciones del Estado como el Departamento de Labor.
The state agencies like the Department of Labor.
Porque no se protegen sus derechos.
Because their rights are going unprotected.
A veces tenemos miedo de denunciar este tipo de actos atroces.
Sometimes we're afraid to file complaints about atrocious acts.
Por ese motivo exigimos que se incremente el personal en el Departamento de Labor.
And that's why we raise our voices and demand the hiring of more investigators at the Department of Labor.
Para que puedan resolver sus casos y que se haga justicia.
To resolve these cases and to do justice.
Porque los derechos de los trabajadores a nivel mundial son irrenunciables.
Because workers' rights on a global level cannot be denied.
Por eso yo pido, señores senadores, representantes y comunidad en general.
And that's why I call on you, esteemed senators and the community in general.
Por favor, que se apoye a la ley HB 5854.
Please support HB 5854.
Agradezco su atención.
I thank you for your time.
Thank you. Muchas gracias. Thank you, Ms. Cornejo, for your testimony today. Any questions from the members of the committee? I don't see any. Good. Thank you, Mrs. Cornejo. Muchas gracias por tu testigo.
Okay.
I see, is it Megan Fountain who's there, 62? I think you're up next. Oh, that's you. You're the translator.
Yeah, I'm just translating. I won't be testifying. Thank you.
Okay. Thank you. I don't see anyone else in the queue, Mr. Clerk. Is Joe Durrett here? I don't see anyone else on my list. Is there anyone else left that wants to testify?
I believe Deborah Leon is in person.
Okay. Is
Joe
Deborah Leon in the room?
Joe Duert is present in the hearing room and at the desk. Apologies, I did not realize you could not see this.
Yes, I cannot see. Thank you for my eyes and ears. Mr. Durrett.
Thank you. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Acker, and the distinguished members of the Labor and Public Employees Committee. My name is Joe Durrett. I live in South Windsor, Connecticut. I work as a quality inspector at Pratt & Whitney, East Hartford, and I am a health and safety representative for the Machinist Union Local 1746. Thank you for the opportunity to testify in support of SB 938, an act concerning unemployment benefits for striking workers. I've been employed by Pratt & Whitney for nearly 31 years, and I am a second-generation employee, my father having worked at the same plant from the early 1960s until 1992. I have been around Union Hall and the factory for most of my life. I'm not quite old enough to remember the trolley cars that used to travel up and down Main Street outside the factory, but I am old enough to remember the tracks and the median that they used to travel upon. When I was a kid in the 1960s, every 3 years, my dad would tell my siblings and me, don't expect too much for Christmas this year. The reason for that was because the union contract expired every 3 years on the first Sunday in December. And if there was a strike, well, there would be no money for Christmas or heating oil or enough grocery money to feed a family of 7. The Machinist Union struck Pratt & Whitney in 1960 for 9 weeks. I wasn't born until 2 years later, but from what I heard, it was a very contentious and bitter strike. After the dust cleared, somehow the union ended up with that December contract date, although I'm not clear on the details. I remember asking my father when I was a teenager, why doesn't the union just negotiate a better contract date? And the answer was that the company would never agree to the change at that date. You see, it's all about leverage. Sure, the union had the right to strike, but the membership would pay dearly for it if they did, with lost wages and benefits that could take months or years to recoup while walking the picket line in the cold of winter. In 1985, there was another vote to strike, but it was not effective for the union, as each Connecticut local had its own strike vote, and not every local could muster the 2/3 vote necessary to strike. It wasn't until 2001, some 40 plus years later, after the 1960 strike, that some charismatic local union presidents and negotiators rallied all the Connecticut workers to unite and strike the company again. We took some criticism for that strike, and it was December, just 3 months after the attack on 9/11, and some people call us selfish and unpatriotic, but it wasn't about higher wages. I believe the skyrocketing healthcare costs played a part, but for me, it was about showing the company that we could strike. We were out of work for 2 weeks, and Mother Nature smiled kindly upon us with some unseasonably warm temperatures. While being a third shift strike captain, I still managed to get snowed on somehow. When we ratified that contract 2 weeks later with improvements, we felt like we had achieved something positive, but it wasn't without sacrifice. Of course, one of the things we had going for us was our skilled workforce, because there wasn't a plethora of machinists and tradesmen ready to walk in and replace us, but not every union is so fortunate in that aspect. Many union workers in various sectors are still living paycheck to paycheck, and that gives their companies leverage over them. Nobody wants a strike, but when the workforce is up against a ruthless company that seems to hold all the cards, sometimes a strike is the only card left to play. SB 938 can help working families in times when all their options to negotiate fairly with their companies have failed, and alleviate the uncertainty and stress for caring for their loved ones when a decision to strike is on the table. I urge the committee to support this bill. Thank you.
Thank you, Mr. Durrett. Appreciate your testimony this evening. Are there any questions from the committee?
We have several questions from Representative Ackert, Representative Hughes and Representative Weir, or just Representative Ackert, I believe.
Representative Ackert, proceed.
Thank you, Mr. Chair. I do have to leave. I wanted to stay as long as I could, but late for appointment also. But I just want to make a comment. First, thank you for bringing up. I don't think anybody's really talked about the fact that bringing in other workers I don't really think anybody's brought that up. When I think about, the strike, I think about, the employee, being out of work. And I think of if they serve people, in your case, you're a machinist, so it's not making a product that the company has to provide to a company that's waiting for that product. So there's usually, everybody's out of it. But when you say they couldn't bring in other skilled workers, because you are a very skilled worker, there's just not a plethora of machinists out there typically. But in other sectors of the workforce, a business can.
Yeah.
And I'm glad you brought that to the point, because when I think about a strike, I think about the company's got nobody, but there are people that can cross lines.
Yes.
And in this case, your case, it's hard for that to happen because you're a very skilled individual. So thank you for bringing that to light and bringing that point out in that case. So thank you again for being here and speaking on behalf of your colleagues.
Okay.
And I remember my dad striking in the 60s, just so you go back. I'm at that same age as you are, by the way. So
Great.
thanks again. And Mr. Chair, I probably have to take off. So I'll see how many people are left to testify. Thank you, Mr. Chair.
Thank you, Representative.
Thank you,
Yeah.
Mr. Chair, and just to echo what Representative Ackert said, I realize you talk about all the elements that you may be striking out, and these people are outside. This is not cushy. You could be standing out there for hours and hours a day in the snow, in the rain, in the sleet. It is a hardship, and like you say, it's a last resort to a company that may be holding all the cards, and it is one card that can be very powerful and very important. So I thank you for bringing your hard-earned lived experience to the table today.
Nick, I will mention that we did finally get that strike date change in May, because the company needed us to sign an extended contract, so we use that as our leverage against them. But it works.
Thank you.
Thank you for your time.
Thank you. Thank you, Mr. Durrett. Is Mr. Jay Colbert in the room? How about Nicole Saclemente? Deborah Leone in the room?
Yes. Yeah, they're coming.
Okay. Ms. Leong, is she in the room?
Yeah, also, Ms. Eva is here to testify as well, number 82, and I think we have,
82. I have Cheryl Bergman, number 82.
I mean 83, I'm sorry.
Okay, Ms. Bergman's in the room though. I think she's first.
Okay.
Proceed, Ms. Bergman.
Yep.
Good morning, good afternoon.
Good afternoon.
Wait a second. We have folks lined up that you already called on, so that'll
Oh.
be next in the queue and then.
Sorry about that, Ms. Bergman. Apologies.
That's no problem. I'll mute myself.
Thank you.
Thank you, Representative. Who is next, Mr. Clerk? I have several people on my screen here.
I believe Deborah Lyon is currently at the testimony desk.
Yes.
Ms. Lyon, apologies, Ms. Lyon, please proceed. Welcome.
Boa noite a todos, senhores e senhoras e representantes desse comitê, senadora Sanches e a senadora Kushner. Sou membro da Connecticut Worker Center, estou aqui para dar meu testemunho.
I am Nelly Jara, and I'm gonna help in English. Good afternoon, ladies and gentlemen of the Labor Committee, Co-Chair Representative Sanchez and Co-Chair Senator Kushner.
Vou dar meu testemunho em apoio ao HB 5854, uma lei sobre o número de inspetores de salários e horas no Departamento do Trabalho. Sou residente de Danbury e mãe de 3 filhos. Quero contar aqui hoje sobre a história do meu marido Jorge. Meu marido trabalhou por 7 anos em uma loja em Danbury. Durante esses 7 anos de trabalho, meu marido sofreu muitos abusos e humilhações. Ele trabalhava 16 horas por dia em pé.
I'm going to testify in support of HB 5854, an act concerning the number of wage and hour inspectors of the Labor Department. I am a resident of Danbury and I'm mother of 3 children. I want to tell you a little bit about my Jorge husband. My husband worked for 7 years in a retail store in Danbury. During those 7 years of work, my husband suffered many abuses and humiliations.
Muitas vezes ele não podia levar 10 minutos para o lanche ou descansar. Muitas vezes ele tinha que trabalhar doente, porque se estivesse ausente seria demitido.
He worked 16 hours a day standing up. Often he couldn't not take 10 minutes for a snack or rest. Many times he had to work sick because if he was absent, he would be fired. Many times the employers were without their tips because the owner took the tips claiming that he had extra expenses.
Muitas vezes os funcionários ficavam sem as gorjetas porque o proprietário levava as gorjetas alegando que ele tinha despesas extras. Meu marido e vários outros funcionários não recebiam horas extras ou documentos fiscais. Ele trabalhava todos os fins de semana sem poder tirar um domingo para estar com a família.
My husband and several other employers did not receive overtime or tax documents. He worked all weekends without being able to take on Sunday to be with his family.
Meu marido sofreu uma tentativa de assassinato dentro do estabelecimento de um outro colega de trabalho. Esse colega o atacou com espeto de churrasco. E depois disso, a gerente e o proprietário chamaram meu marido e o ameaçaram para que ele não fizesse um relatório policial. Eles disseram que ele seria demitido e que o denunciariam à imigração porque ele era um imigrante indocumentado aqui neste país.
My husband suffered an attempted murder inside the establishment. A co-worker attacked him with a barbecue spit, and after that the manager and the owner called my husband and threatened him so that he would not make a police report. They say that he would be fired and they would report him to immigration because he was an undocumented immigrant here in this country.
Passou tempo e eles o despediram. Quando ele foi buscar suas coisas, a gerente ainda o ameaçou, dizendo que se ele dissesse às pessoas que o haviam demitido, eles o denunciariam à imigração.
A while passed and they fired him. When he went to get his things, the manager threatened him, saying that if he told people that they had fired him, they would report him to immigration.
Procurei ajuda no Departamento do Trabalho e eles rapidamente nos contataram e nos deram todo o apoio deles. O Departamento do Trabalho forçou o empregador a pagar ao meu marido por todas as horas que ele não tinha sido pago. Como fomos corajosos e apresentamos uma queixa ao Departamento do Trabalho, o Departamento do Trabalho investigou toda a empresa e forçou o empregador a pagar as horas extras não pagas a 74 funcionários.
I looked for help in DOL and they quickly contacted us and we were giving all their support. The DOL forced the employer to pay my husband for all of the hours that he had not been paid. Because we were brave and filed a complaint to DOL, the DOL investigated the entire business and forced the employer to pay unpaid overtime wage to 74 employees.
O Departamento do Trabalho ajudou meu marido e eu a solicitarmos vistos de imigração. O visto U para vítimas de crimes e o visto T para vítimas de tráfico humano. Graças à investigação do Departamento do Trabalho e graças ao apoio do Connecticut Workers Center, os Estados Unidos está para aprovar vistos para nossa família. E em breve eles nos enviarão autorizações de trabalhos e número de previdência social.
The DOL helped my husband and I apply for immigration visas. The U visa for crime victims and the T visa for victims of human trafficking. Thanks to the investigation by the DOL and thanks to the support of Connecticut Workers Center, uses approved visas for our family. Soon they will send us work permit and social security numbers.
Agora, muitas pessoas em minha comunidade me contactam para pedir ajuda, porque estão sofrendo situações semelhantes de roubo de salário. O Departamento do Trabalho precisa de mais funcionários, porque é um número muito grande de trabalhadores explorados, não apenas em Connecticut, mas em todo o país. Sejam cidadãos ou trabalhadores imigrantes, são uma força que move este país. Todos os trabalhadores precisam ter seus direitos assegurados com um ambiente de trabalho seguro e um salário decente. Thank you for the opportunity.
Now, many people in my community have contacted me for help because they are facing similar situation on wage theft. The DOL needs more employees because there is a very large number of exploited workers, not only Connecticut, but all over the country. Whether citizen or immigrant workers, we are the force that moves this country. All workers need to have their rights ensured as a safe working environment and a decent wage. Thank you, Deborah Leon.
Thank you. Thank you, Ms. Leon. We appreciate your testimony this evening.
Thank
Are there
you.
any questions from the committee members?
Mr. Chair, this is Ann. I just would like to again extend my gratitude for you waiting all day to deliver that very, very specific and moving testimony about how pervasive. And can I just ask you to repeat, was it 74 workers that were also fined? I mean, the employer was fined to pay back wages to 74?
Yes.
Okay, so it sounds like that had been just the entire business model for this employer is just to exploit and basically commit crimes against their workers and normalize that as their business model.
And members of US DOL, they contact us
Okay.
to have some support with those families because they were afraid to talk directly to them. So
Okay.
we as a nonprofit organization, again, we understand the language, the culture, and they feel more confident coming to us, and we provide after some information that they use to move on in the case and support all the workers.
Thank you for that, Nellie. Also, these workers had TIN numbers, correct?
Yes.
Yes, so that is legal. I think I would like to just emphasize that they had legal work TIN numbers to
So
do
most
delivery.
of the families who are working here, they have the tax ID number and again, we pay taxes. So the money should be put on the DOL for more investigators to do the work and to do the enforcement. And yeah, to prevent wage theft.
Thank you. And thank you for your courage, because it sounds like that your husband and your family were victims of egregious crimes, pervasive crimes. And I support your quest for justice for the entire
Thank
community
you.
and for all of us. Thank you.
Thank you so much. Thank you.
Thank you, Representative. And thank you, Mr. Young, yes, for your courage. I'd echo those sentiments as well. Thank you so much for testifying this evening. Next up, we have Ms. Cheryl Bergman. Ms. Bergman,
She's in.
Good evening.
good evening.
My name is Cheryl Bergman, and I am here today to speak in support of SB 938, the ability for striking workers to receive unemployment benefits. I live in New Haven and am a member of URA, the Yale Union's Retiree Association. I retired from Yale in 2018, but in 1982, I was a founding member of Local 34. In 1984, I was on the Local 34 Executive Board when negotiations for our first contract broke down, and our members voted that striking would be necessary to convince Yale to bargain in good faith. That strike lasted for 10 long weeks. I was 32 years old then, single and living on my own. I paid my rent, my bills, and my college loans from my $9,000 a year salary. I was doing okay. Certainly okay compared to some of my coworkers who had mortgages to pay and families to support. When it became clear that Yale had no intention to bargain in good faith, we began the difficult and scary discussion about going on strike. I say scary because when you are talking about going on strike, you are talking about being without a paycheck. You are talking about your regular day-to-day life being upended. And it's not just about you. If you have parents, a spouse, children, it's about them too. For my personal circumstance at the time, it was just me. But I was the union leader in my department and responsible for 30 people. We were young and older, single and couples, some supporting children and others their elderly parents. Our discussions about striking were filled with emotion, fear, excitement, anxiety, determination. How long would it last? Would it be worth it? Can we win? These questions we did not have the answers for at that moment. What if we don't go on strike? That answer we had. We'd lose this fight for economic fairness and for the dignity and security that good wages and benefits brings to a community. So we went on strike and we were victorious. Yale's illicit claim that they couldn't afford to pay us a living wage was laid bare. Unfortunately, some of our coworkers did not join in the strike. They were far too frightened to be without a paycheck, no matter that the cost was to their dignity and to their relationships with their fellow union members. Those strained relationships and labels assigned have remained for nearly 40 years. I can only imagine how different things might have been if in 1984, we were able to collect unemployment benefits. Would the strike have even happened? Would more workers have felt able to join the strike, making it shorter and less painful? Would Yale have been inclined to bargain fairly since they would be paying in part for the unemployment insurance? In 1935, unemployment benefits were established as a lifeline for ordinary men and women. Those benefits should now be available to striking workers. Leveling the playing field for labor to compete with management in disputes instead of allowing employers to have the ability to starve workers into submission. I thank you very much for your time and for your consideration of this critical bill.
Thank you very much, Ms. Bergman, for your testimony this evening. Are there any questions or comments from the committee members?
No, thank you.
Okay, I don't see any. Thank you very much, Ms. Bergman. Have a wonderful evening.
Thank you, you too.
Up next, we have Ms. Ella Bermudez. Good evening, Ms. Bermudez.
Good evening, There we go. Good evening, distinguished members of the Labor and Public Committee. My name is Ava Bermudez Zimmerman, Child Care Organizing Director for CSEA SEIU. CSEA represents 25,000 workers in the state of Connecticut, 4,000 of them being child care providers. I'm here to speak in support of House Bill 5858, an act establishing a flexible spending account program for child care expenses. In the last 3 years, child care providers have been forced to close their doors, all the way up to 30% of them closing them permanently. That workforce is not coming back. These closures make it extremely difficult for parents to find care. And when they do find care, they have additional expenses that they have to consider. Most childcare, if you didn't know, here in the state of Connecticut and nationwide can cost up to $23,000 a year for one child. Just one child. So if you are out there and have a child of your own, you probably know that the expense is exorbitant. Most of the parents who are not paying that $23,000 sum are probably subsidized in a certain way. Now, if you're a parent that says, well, I'm not on the state subsidy care for kids, I'm not being subsidized, I say, think again. Most of the child care facilities are subsidized by the child care facility themselves, the center director or the organization that runs it. Other options that you have is corporate sponsors or state subsidies or other federal subsidies. All of these come together and maybe some grants splash in and reduce the cost of care for the everyday parent. And still, despite all of these different subsidized versions, the cost of care is still too much for the everyday parent. So when you're looking at funding streams that are creative of how we can fix our problems, we really have to ask ourselves, what ways can the state of Connecticut intervene? Some of these parents are asking to just go to work. You know, they don't want to have the opportunity to make those difficult decisions. They want to know that their child's in a safe environment, an educational environment, and still can go to work without trying to say to themselves, can I put ends meet on the table, or have to figure out childcare, or have to figure out healthcare expense, et cetera, et cetera, et cetera. Everyday parents are constantly making those decisions. And with this bill, it's finally an option to really consider those creative solutions. I asked you to support 5858 because this is a pathway forward. This flexible spending account will allow to defray the cost of care, give families buying power when accessing care, and the state-run program will allow the same opportunity to use pre-tax dollars to pay for care. I open up for any questions and thank you.
Thank you, Ms. Bermudez, for your testimony. Are there any questions from the committee members? All right, seeing any? Nope. All right, thank you so much, Ms. Bermudez, for your testimony. Up next, Mr. Clerk, is Mr. Reverend Josh Pollack. Reverend, how are you?
I'm good. How are you?
I'm well. The floor is yours, sir.
All right. Senator Cabrera and distinguished members of the Labor and Public Employees Committee. Again, I am the Reverend Josh Pollack. For the past 20 years, I've served as minister of the Unitarian Universalist Society East in Manchester. I'm also a faith leader with the Domestic Worker Justice Campaign and with Recovery for All, which, as you know, is a statewide coalition of 60 community, faith, and labor organizations fighting for a brighter future for all Connecticut residents. I live in Glastonbury. I am here tonight to state my strong support for HB 5854, an act concerning the number of wage and hour inspectors at the Department of Labor. I'm here in support of all workers who experience wage theft, but I want to emphasize that I'm here specifically in support of domestic workers. Unitarian Universalists gather our congregations around a set of 7 principles. Our first principle is respect for the inherent worth and dignity of every person. Our second principle is justice, equity, and compassion in human relations. I've long participated in Connecticut's Domestic Worker Justice Campaign precisely because more often than not, we as a state fail to honor the worth and dignity of domestic workers. And more often than not, we as a state fail to extend justice, equity, and compassion to domestic workers. They are a highly vulnerable workforce made up of mostly women of color, a large number of whom are immigrants, some of them undocumented, as you've been hearing today. They already have minimal rights in the workplace due to historic exemptions from federal and state labor statutes. They are easily exploited, easily marginalized, easily ignored, yet they are essential workers taking care of the elderly, people with disabilities and children. They clean, they cook, they run errands, they help with personal hygiene, they sometimes help with clients' medical regimens, they offer critical companionship. Quite often their services enable their clients' family members to work and earn an income. They are the workers who make all other work possible, or as I think I just heard, they're the force that moves this country. So in my extensive interactions with domestic workers, it is clear to me that wage theft continues to be one of the primary ways they experience exploitation. And while in theory, these workers have the ability to seek redress, we know in practice, the Department of Labor does not have sufficient resources to enforce wage theft statutes. I think the answer is simple. HB 5854 would increase DOL's capacity for enforcement. It's a good thing. This session, you can make a real change for domestic workers and other workers who experience wage theft. Please support HB 5854. Thank you.
Thank you so much, Reverend. We appreciate your testimony. Are there any questions or comments from the committee members? Seeing none. Thank you, Reverend, for your testimony this evening.
Thank you. Have a good night.
All right. Up next is Ms. Bella Vasquez, who may require translation. Hola, Ms. Vasquez. Buenas tardes.
Hola, muy buenas noches.
Buenas noches. Adelante.
Usted es el que va a traducir, ¿no?
Yes, I will translate.
Okay. Bueno, estimados presidentes y miembros del comité, mi nombre es Bella Vázquez Jiménez, vivo en New Haven, apoyo al proyecto de ley HB 5854 para combatir el robo salarial en Connecticut.
Good evening, dear chairs and distinguished members of the committee. I'm a resident of West Haven. I'm here to express my support for HB 5854 to combat wage theft in Connecticut, and I live in New Haven. Adelante, Bella.
También soy parte de Unidad Latina en Acción, que tiene aproximadamente como 1,800 miembros en este estado. Nuestra organización lucha por los derechos de los trabajadores, de los inmigrantes.
I'm part of ULA, which has almost 2,000 members in the state, and we fight for the rights of immigrant workers.
También soy integrante de Recovery for All, una coalición estatal que lucha por un futuro mejor para Connecticut y cuenta con más de 60 organizaciones comunitarias, religiosas y laborales.
I'm also part of Recovery for All, a statewide coalition fighting for a better future for Connecticut with more than 60 community, faith, and labor organizations.
Intentaré ser corta, resumir mi vivencia, lo que he vivido, independientemente del robo salarial que he sufrido. Se dan cuenta, estoy en esta lucha porque confío en ustedes. Ahora mismo pedí permiso, estoy estudiando en la escuela de adultos porque quiero seguir adelante y porque no quiero que me discriminen.
I'll try to be brief to sum up my story. Right now, I'm at English class. I want to get ahead. I want to change my future. I'm studying English at night while I work during the day.
Llevo trabajando en construcción desde hace aproximadamente unos 6 años, pero el último año un contratista abusó laboralmente de mí y de más de 20 personas, todas inmigrantes.
I've been working in construction for 6 years, and last year a contractor abused me and 20 other workers.
Durante todo el tiempo que trabajamos con él, nunca nos pagó horas extras. Algunos de nosotros trabajamos de 60 a 73 horas por semana. La necesidad nos llevaba a eso.
During the whole time that we worked for him, he never paid us overtime, and some of us worked 60 to 73 hours a week.
Además de eso, nos dejó de pagar las últimas semanas, y mientras estábamos trabajando con él, nos hizo firmar a mí y a todos mis compañeros un documento donde nos decía que nosotros los trabajadores, que somos trabajadores independientes, y eso nosotros no lo sabíamos.
On top of that, he didn't pay us our final weeks at all. He paid us nothing for our final weeks. And also, while we were working, he made me and my coworkers sign a document classifying, saying that we were independent contractors.
Nos quedamos sin trabajo en la época de invierno y es aún más difícil para nosotros, los trabajadores inmigrantes, conseguir trabajo. Soy madre soltera, tengo 2 hijos menores de edad que dependen de mí.
We were laid off during the cold months. That's the time when it's the hardest to find work. I am a mother who is the head of the household. I'm the only economic provider for my children.
Como no recibí ningún pago en varias semanas después de que al jefe le llamábamos, nunca nos contestaba. Al inicio nos decía que después que le tenían que terminar de pagar los jefes más grandes. A la final nunca nos terminó pagando hasta que ya no contestó el teléfono.
So the employer gave us excuses. He said, well, the person who hired me didn't pay me, so I can't pay you. But then he just stopped answering the phone.
A la necesidad que me encontraba, me tocó pedir prestado dinero para poder cubrir ciertas deudas, ya que tenía que comer y todo, un dinero a intereses muy altos, que hasta la fecha y hoy sigo pagando. Y no es justo que los empleadores nos roben de una manera tan cínica y que las autoridades no hagan nada.
I had to take out a loan just to because I wasn't getting paid. I had to take out a loan at a very high interest rate because I didn't have food to put on the table for my kids. It's not fair that an employer will exploit us in such a cynical way and the authorities do nothing.
Como no hablo inglés, la verdad, por eso estoy estudiando ahora. Me fuimos al departamento de trabajo y una compañera fue la que se atrevió a preguntar para ver si es que podíamos hacer una demanda, ya que la mayoría teníamos miedo de que a lo mejor nos llamen a la migra, yo qué sé. ¿Y cuál fue la sorpresa? Que nos dijeron que como no teníamos social y que somos trabajadores inmigrantes, que no tenemos derecho a nada.
So it was one of my coworkers who had the courage to take me to the Department of Labor office. I was hesitant because I didn't speak English. That's why I'm taking English class tonight. When we got there, the person at the desk told us that we couldn't file a complaint because we didn't have social security numbers.
Nosotros trabajamos igual que todos. Los empleadores que roban a sus empleados son unos criminales y deben de ser tratados como tal. Espero que puedan aumentar más más investigadores en el departamento de trabajo y nos puedan ofrecer entrenamientos a los actuales trabajadores.
We work just like everybody else. And employers who steal wages from their employees are criminals and should be treated as such. I hope that you can increase more investigators at the Department of Labor so that they can also offer training to workers. And I also hope that the Department of Labor will train their workers so they know that they should be taking care of all workers regardless of their immigration status.
Yo considero como cosa personal, ya que todos mis compañeros vivimos esto, que lo más justo es que pongan a más gente, así como nos exigen y nos obligan en nuestros trabajos, también a ellos les deben exigir y obligar. Yo les tengo mucho respeto y ustedes tienen unos puestos de trabajo excelentes, pero nosotros que estamos por acá abajo no nos escuchan. Tienen que apoyarnos. Nosotros queremos salir adelante. Estamos aquí para trabajar, pero sin el apoyo de ustedes no podemos, porque nos cortan todas las alas. Los jefes, porque tienen dinero, se creen que pueden pisotearnos. Yo soy madre soltera, tengo mis 2 hijos, aún estoy pagando. ¿Quién me cubre todo eso? Un año sin cubrir, sin que me hayan pagado. Espero que ahora, por favor, nos hagan caso, nos ayuden. Nosotros, el grupo de compañeros, me ha costado convencerlos. Creo que me estoy alargando mucho.
This is very personal for me. My employers give me orders. Those of us who are below, the people who are at the bottom, our voices aren't heard. Without you, we are powerless. The bosses think they can do whatever they want with us. For an entire year, I didn't have enough food.
Yo digo que ya basta la injusticia, de la explotación, a la explotación, porque nosotros vivimos para poder sacar adelante. Les pido de favor que nos apoyen y que aprueben esa ley, la HB 5854, para que se pueda hacer justicia y nos ayuden. Entonces, comprendo que somos mucha gente, pero por favor, apóyennos, señores senadores, representantes, quienes puedan dar ese voto. Somos seres humanos, pónganse en nuestro lugar, como madres, como padres, todos trabajamos simplemente para poder salir adelante. Ayúdenos, apóyennos de verdad. Y ahora nosotros estamos metiendo las demandas. Espero que también esto no se alargue para un año, ya que mis compañeros no querían hacerlo, pero me ha costado convencerlos. ¿Por qué? Porque yo les digo, confiemos que hay autoridades que sí nos escuchan y sé y confío en ustedes que van a ayudarnos en este problema que ahora tenemos y que gracias a ULA nos está ayudando y vamos a conseguir que nos paguen lo que nosotros trabajamos. Gracias a todos.
Enough is enough. We live to give a better future to our families. Please support this bill. I understand you've heard from many people today, but please put yourself in our shoes as moms, as dads. Please support us. And I hope that the Department of Labor will quickly address the complaint that me and my coworkers are going to file or have filed. I told my coworkers they should file the complaint. They should trust in the Department of Labor. And I hope that I can keep my word. Thank you.
Thank you so much. Muchas gracias, señora Vázquez, por tu testigo, tu honestidad y por tu valentía. Muchas gracias.
A ustedes, muchas gracias.
Tenga buen día. Next up, I believe you're the last one up, is Philip Planty. I'm saying that correct, Mr. Thank you.
Yep, Philip Plant.
Philip Plant, you're the last one on deck, buddy.
There you go. Well,
hello.
Hello, and I would like to thank the committee for your time and attention. I know it's been a long day, so I'll try and be brief with my comments. My name is Phil Plant, and I'm a lieutenant with the Fairfield Fire Department. I've been with the department for just coming up on 30 years now, and I'm here to ask for your support for SB 937. While out of work for an unrelated surgery, I was told by my doctor after a series of abnormal blood tests that I should consult with a hematologist. After consulting with the hematologist and going through additional blood work, it was discovered that I have chronic lymphocytic leukemia, or CLL. This is a cancer that affects white blood cells and the body's ability to fight infections and other cancers. CLL is not a curable cancer. It is something that you live with and try to manage the symptoms. It is also predominantly found later in life. I'm only 52 and the average diagnosis age is 65 to 75. And the biggest thing that my doctor said, and most research does support, is that this is not a hereditary cancer. The DNA damage is done during a person's lifetime. I also have no history of cancer in my family, and I've never been a smoker. This is all new to me going forward, and I'm just at the start of my journey. I was diagnosed on January 27th, just about a week and a half ago. I had a CAT scan yesterday, and I have a PET scan scheduled for tomorrow to determine the stage the cancer is and if it's spread to anywhere else. My doctor did say, however, that depending on how things go, I will be subject to additional scans and blood tests for the rest of my life. And I do have to be concerned about things like getting a cold, the flu, or COVID. The irony of the whole situation right now for me is that in talking to my original surgeon and then my hematologist, both were already under the assumption that Connecticut already had presumptive cancer legislation for firefighters. And they were both shocked when they found out otherwise. I was just getting to the point in my career where I was starting to consider retirement. Now, unfortunately, this diagnosis has put an incredible strain on my wife and I, and this is why I'm asking, please, for your support for SB 937. Thank you very much for your time and your consideration.
Thank you very much, Mr. Plant, for your testimony, for your courage in speaking out. Really appreciate your testimony.
No problem. Thank you.
I think we have a question or comment from Representative Wilson.
Okay.
Thank you, Senator Cabrera. Just wanted to say thank you for staying on and being a part of it towards the end of this. And also thank you for your service and wishing you the best in whatever you have to go through. And we're praying that things do turn out in your favor.
Well, thank you very much for all you guys do, and it's been my honor to serve.
Yes, thank you very much, Mr. Plant. Any other questions from the committee members before we conclude?
Mr. Chair, this is Ann again. I just wanted to thank on behalf of the wider Fairfield community, and really my heart goes out to you in this recent diagnosis. And it just adds to my determination that we will get this over the finish line for you and so many families like yourself. So thank you very much, Mr. Chair.
Thank you, Representative. Any other questions or comments from the committee? Seeing none. Mr. Plant, thank you so much for your courage and your willingness to testify and to share your story with us.
Great. Thank you very much. You have a good night.
Have a good evening.
Bye-bye.
Mr. Clerk, I believe that is it for this evening, unless I'm missing some folks in the room.
There is no one left in the room to testify, I believe, and
Okay.
the Zoom room is cleared.
Great. Well, the next meeting is going to be on, bear with me 1 second. I got it here, Mr. Clerk. The next meeting is going to be set for Friday at 10 o'clock in room 2B, also live via YouTube Live. So without further ado, I can